WP ನಂಬರ್ ಇಲ್ಲಿ ತಗೊಳ್ಳಿ, ಟ್ಯಾಗ್ ತಗೊಳ್ಳಿ. ಲೆವೆನ್ ಕೊಟ್ಟಿರಲ್ಲ. ಎಸ್ ಅದೇ ನನಗೆ WP ನಂಬರ್ ನೋಡ್ತಾ ಇದ್ದೀನಿ, ಏನು ಕನ್ಫ್ಯೂಸ್ ಆಯ್ತು ನನಗೆ.
ಏನು ಎಷ್ಟು ಬರಲ್ಲ FIR ಬಂದಿದ್ವಿ ಎಲ್ಲೇ ನಾನು ನೋಡ್ಕೊಂಡಿದ್ದ ಮೇಡಮ್ ಈಗ
ಕೋಆಪರೇಟಿವ್
Madam, your thoughts?
ಇವು ನನಗೆ ಗೊತ್ತಾಗ್ತಾವ ಈಚೆ ಬರ್ದ್ರ ಏನ್ ಮಾಡ್ದು ಇದು ಎಷ್ಟೇ ಮ್ಯಾಟ್ರ್ ಐತ್ರಿ
ನಂದಲ್ಲ, ನಂದದು. ಮೇಡಮ್, ನಾನು ಹೊಸು ಬರಿಬೇಕಾ?
ಅಂದ್ರೆ ಬಿ ರಿಪೋರ್ಟ್ ಆಯ್ತಿದಕ್ಕ
ಅಲ್ಲ ನಾವು ಮೆಂಡಮಸ್ ಕೇಳೇನು 24 ಇನ್ನೊಂದು 4 ಲೈನ್ ಅರ್ಜಿ ಬರ್ತಾನೆ
ಅಂದ್ರೆ ಆ date ಕೊಡ್ತಾರ ಅದು ಎಂದದ ಅದು ಕೊಡ್ತಾರ. ಇಲ್ಲ
ಕವಿತಾ ಯಾವ್ದಿದು? ಇಲ್ಲ ಕೊಡ್ತಾರೆ ಮೇಡಮ್.
ಎಷ್ಟೇ ಮ್ಯಾಟ್ರ್ ಐತಿ ಅದು ಇಂಥ ಮ್ಯಾಟ್ರ್ ಭಾಳ ತಗೋಬೇಕ್ರಿ ನಾವು ಎಲ್ಲ ಆಯ್ತು
ಏನ್ ಸಲ್ ಬಿಡಲ್ರಿ ಇದು ಇನ್ನ ಫಸ್ಟ್ ಟೈಮ್ ಐತಿ
ಹೆಂಗೆ ಇರಲಿ
ಕರೆಕ್ಟ್
ಅವ್ರ ಕೇಸ್ ನಾವು
Madam.
LB local body ಲೋಕಾಯುಕ್ತ
சொல்றேன் ಮೇಡಮ್.
ಲೋಕಾಯುಕ್ತ ಯಾರು ಇದ್ರೆ
ಅಂದ್ರೆ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ರೆ
ಲೋಕಾಯುಕ್ತ SPP ಇದೆ.
ಅಲ್ಲೇ ಮಾಡ್ತಾರೆ
ಎಲ್ಲ KLR ಆಲ್ಮೋಸ್ಟ್.
ಈ ರಿಪೋರ್ಟ್ ಆದ್ರೆ
ಒಂದು ಬೇರೆ ಇದೆ.
ಸರ್ಕಾರಕ್ಕೆ
ಬರ್ತೀನಿ ಮೇಡಮ್.
ಎರಡು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ ಇದಾವೆ, ಎರಡು ಪಕ್ಕ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇದಾವೆ.
ಇದು ಒಂದು ರೊಕ್ಕ ಕೊಡೋ ನೋಡಿ
ಹೌದಾ ನಮ್ಮ ಕೆಲವೊಂದು ಯೂನಿವರ್ಸಿಟಿ ಹುಡುಗಂತದೆ
ಎಲ್ಲ ಅವು
ಎಜುಕೇಶನ್
ಈ ತನಕ
ಎಲ್ಲಿ ಬರ್ಬೇಕು
ನೀವು ನೋಡ್ಕೊಡ್ರಿ
ಇದೆಲ್ಲ ಯೂನಿವರ್ಸಿಟಿ
6283 na? 628324. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅವರೇ, ಹಲೋ.
overruled. What about number 2,
Number 2 prayer ಬರು.
R1?
Yes. R1 address correct ಇದೆ but ಅವರು earlier I have mentioned same address in the earlier writ petition that was considered Niger G ದಲ್ಲಿ.
Office objection serial number 14, serial number 23 and 24 is overruled. Office objection number 28 shall be complied. ಅದೇ page number 91 ಸರಿ ಸ್ಟಿಚ್ ಮಾಡಿಲ್ವ ಅಂತ ನೋಡಿ.
Please, I will do it.
ಲಿಸ್ಟ್ ಆನ್ ಯಾವತ್ತು ಬೇಕು?
Tomorrow. During course of the day I will.
ಏನು ಅಂತ ಹೇಳಿ. What is the case? Yes, what is the case about?
A case, my lord, this a petitioner is a registered society and it has applied for renewal of the society, my lord, before the third respondent. And the third respondent has refused to renew the society on the ground that the limitation occurred is more than 5 years. However, the government's,
KIT ಬರುತ್ತಲ್ಲ appeal.
no, my lord, it's not available order. Karnataka Societies Registration Act, my lord.
Societies
It's not cooperative, my lord.
Societies ನಾನು ಹೇಳ್ತಿರೋದು.
Yes, my lord. Section 13 of the Societies Registration Act, ನಲ್ಲಿ.
ನೋಡಿ ಇದು.
It is the authority, my lord, who registered the society. They have to take the renewal papers, audit papers and give the renewal, my lord. That is the only procedure provided, my lord. Section 12 and 13 of the Act, my lord.
It's that relates to only bylaws ಅಲ್ವಾ?
Yes, my lord.
Acceptance of change report,
Acceptance of?
changed report by the society. Every year they are supposed to submit the changed report, governing body and audit
Section
report.
13, even the government has issued circulars. Wherever there are delays in renewal of the such societies, my lord, they can be considered ಅಂತ there are 3-4 circulars I have filed. But ಇವ್ರು ಏನದು 5 ವರ್ಷದ ಒಳಗಿದ್ದರೆ ಮಾತ್ರ ಮಾಡ್ರಿ ಸರ್ಕಾರದವ್ರು ಅಂತ ಹೇಳ್ಯಾರೆ. ಇಲ್ಲ 6 ವರ್ಷ ಆಗಿದೆ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ಅಂತ
ಯಾವ್ದೋ ಒಂದು
ರಿಟರ್ನ್ ದ ಪೇಪರ್ಸ್, my lord.
ಒಂದು ಗೌರ್ಮೆಂಟ್ ನೋಟಿಫಿಕೇಶನ್ ಇತ್ತಲ್ರಿ ಕಂಡೋನ್ ಮಾಡೋದಕ್ಕೆ.
Yes. On that effect, my lord, annexure F, which is correspondence.
My lord, annexure F ನಲ್ಲಿ ಇದೆ. ಅಪ್ ಟು ಪೇಜ್ 75 ಮಾಡಿಕೊಳ್ಳದೆ ಇದ್ದಲ್ಲಿ ದಿನಾಂಕ 19/5/2022 ಸರ್ಕಾರದ ಪತ್ರದಲ್ಲಿ ವಿಧಿಸಿರುವ ಷರತ್ತುಗಳನ್ನು ವಿಧಿಸಿ.
AGR, HCGP.
Please, AGA, my lord.
Mr. AG is that to accept notice for respondents.
All the
All
respondents.
respondents.
All the respondents.
Yes. As sought for interim stay, my lord, they may proceed for closure of my society on account of rejection of renewal, my lord.
Purport, in view of the claim of the petitioner that the respondents have failed to receive, respondents have rejected the,
Respond number 3, my lord.
respond number 3 has rejected the annual returns filed by the petitioner. And he is likely to take steps for cancellation of the registration of the petitioner's society, the impugned order is stayed until disposal of this writ petition. This order shall not be uploaded until office objection number 28 is complied with.
Much obliged.
List after service of notice to the petitioner. Ganesh.
Already abated, your lord.
Huh?
Against petitioner number 1, it is already abated. I have to find necessary application, your lordship, as per the instructions.
Purple steps is not taken to bring the legal heirs of the deceased petition number 1. The petition as against petition number 1, petitioner, insofar as petition number 1 is concerned, is already held to have been abated as on 2/9/2024. ಏನ್ ಮಾಡುತ್ತೆ?
Next week it may kind.
ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಳ್ಳಿ.
I will, sir.
As a last chance to file applications, list on.
Much.
Biradar,
Amendment carried out and amendment petition already filed.
The learned counsel for the petitioner submits that he has carried out the amendment and has also filed an amended cost title. Office is directed to check and verify and list the petition for preliminary hearing in B group on date could. ADB, land acquisition matters. Yes, Jairaj Bukka.
Lordship,
Jairaj Bukka.
Lordship, the petitioner is a belong to the Mehtar community for cleaning of the toilets and
So why is it listed today?
my lord, the respondent authority stated that fifth respondent is died, my lord.
ಏನ್ ಮಾಡ್ತೀರಾ?
My lord, I filed a representation before the authority and belongs to the Mehtar community for cleaning. Fifth respondent is a Gram Panchayat member, thereafter is a appointed to the Adyaksha of Gram Panchayat Chimkod. The directly, indirectly, the Adyaksha has not work as any contract work in the as per Gram Panchayat Act. Therefore, my representation as H base number 20 may be considered, my lord.
What is annexure G?
G is the notification order, my lord, in favor of the fifth respondent, my lord, 11/10/2021, my lord. Is no work any date, single date is as per notification, as per order is not worked in the market yard Bidar, my lord. Because his unknown thingala lease and come relationship to this, no single day is not worked, my lord. Because he is a Gram Panchayat Adyaksha.
Yes.
As annexure H has filed before the authorities, no, my representation is not considered. Page number 20, my lord. 2010 ಇಲ್ಲಿವರೆಗೆ ಅನುಭವ ಇರುತ್ತದೆ. ಈ ಕೆಲಸದ ಬದುಕಿಗೆ ದಾರಿ ದೀಪವಾಗಿದೆ. ನನ್ನನ್ನು ಉಪಜೀವನ ನಡೆಯಲು ತುಂಬಾ ಸಹಕಾರವಾಗಿದೆ. ಕೃಷಿ ಉತ್ಪನ್ನ ಮಾರುಕಟ್ಟೆ ಸಮಿತಿಯಲ್ಲಿ ಹೊಸದಾಗಿ ನಿರ್ಮಿಸಿದ ಹೈಟೆಕ್ ಮಾದರಿ 2 ಸಂಖ್ಯೆ ಶೌಚಾಲಯ ನಿರ್ಮಾಣವಾಗಿರುವುದರಿಂದ ಕರೆದಿರೋ ಪ್ರಕಾರ ನಮ್ಮ ಅರ್ಜಿಯನ್ನು ಡಿಡಿ 40,000 ರೂಪಾಯಿನ ತುಂಬಿರುತ್ತೇನೆ. Our occupation is the cleaning of toilets and bathroom, my lord. But the fifth respondent is the Gram Panchayat member. His occupation is a social worker. Or ತೆಕ್ಕೊಂಡು ಬೇರೆಯವರಿಗೆ ಶಿಫ್ಟ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ಫೈಲ್ objection. Thereafter, the fifth respondent no any work at the market at APMC Bidar, my lord.
Now, anyway, you say that the fifth respondent has expired.
My lord, I am not saying that the third respondent stated, my lord, the APMC market had third respondent submission, my lord. The fourth
Whether the respondent whether
Please, ma'am.
respondent ಇಲ್ಲ ನೀವು ಹೈಕೋರ್ಟ್ಗೆ ಬನ್ನಿ, ಇಲ್ಲ ನಿಮ್ ಇಂಟರ್ನೆಟ್ ನ ಸರಿ ಮಾಡ್ಕೊಳ್ಳಿ.
Please, sir. ಬರ್ತೀವಿ ಸ್ವಾಮಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಬರ್ತೀವಿ ರೆಗ್ಯುಲರ್.
ಅಲ್ಲ, ಇದು ಲಾಸ್ಟ್ 6 months ಇಂದ ಹಂಗೆ ಹೇಳ್ತಾ ಇದ್ರಿ ನೀವು.
ಇಲ್ಲ, ಈಗ ಕಣ್ಣಿನ ಆಪರೇಷನ್ ಆಗಿದೆ, ಮುಗ್ದಿದೆ ಏನೋ ಅಂತ.
It's okay, but you can join through video conference, but hey, you have your correct internet connection. I think
Okay.
you're still working on your mobile.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇದು
ಮತ್ತೊಂದು ಡೆಡಿಕೇಟೆಡ್ ಕನೆಕ್ಷನ್ ಇಟ್ಕೋಬೇಕು. ಇದು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 5 ತೀರೋಗಿದ್ರೆ
ಹಾ ಸ್ವಾಮಿ,
it has to be freshly ಇದಲ್ವಾ,
ಪ್ರೆಸ್ ನೋಟಿಫಿಕೇಶನ್ ಮಾಡ್ಲಿ ಅಂತ ನಮ್ದು ಅಷ್ಟೇ. The order is set aside, matter remand back to the
who appears for the other side.
On behalf of Kripa Sagar Patil, I got instructions that they will be issuing a fresh tender notification.
Cool. The petitioner has challenged the allotment of ಏನಿದು ಟಾಯ್ಲೆಟ್
ಟಾಯ್ಲೆಟ್
challenge the acceptance of the tender submitted by the respondent number 5 for maintenance of toilet at the APMC yard, Bidar. Next para. The contention of the petitioner is that the respondent number 5 is a Gram Panchayat member,
thereafter Adyaksha, my lord.
and is a Gram Panchayat member of which village?
Chimkod.
Chimkod village, Chimkod village. And later on was elected as the president. And therefore, he was not entitled to be allotted with the tender relating to the maintenance of the toilet at the APMCR. He further submits that the respondent number 5 has now expired. And therefore, the respondent number 4 is bound to undertake a fresh auction. Full stop. Next, for the learned counsel for the respondent number 4 does not dispute the fact that the respondent number 5 has expired. Full stop. Therefore, the maintenance of the toilet has to be done through inviting fresh tenders from eligible candidates. In that view of the matter, this writ petition is full stop. He contends that the respondent number 4 has taken definite measures to invite fresh bids for the aforesaid purpose. In that view of the matter, it is unnecessary for this court to pass any orders directing the respondent number 4 to take steps to invite fresh bids. However, this writ petition deserves to be disposed. This writ petition is disposed of, directing the respondent number 4 to take fresh steps to invite bids from suitable candidates for the maintenance of the toilet at APMCR Bida within a period of 3 months.
3 months.
Yes, ma'am.
Date of receipt of a copy of this order.
My lords, I am appearing for the petition.
Kumar,
Vote to have been listed in the B group, my lords.
Hmm.
Since it was a date given matter, hence it is listed in orders.
Hmm.
Lords, the petitioner will
May I
apply.
make submission? My lord, in this matter, the statement of objections are required. Since this site is concerned, my lord, already
counsel
auctioned
for the
and it was
respondent
allotted.
seeks time list on.
My lord, ಎರಡು ವಾರ, week after next.
ಯಾವ್ದು ತಗೊಳ್ಳಿ.
ಅದು ಬಹಳ ಲೆಂದಿ ಆಗುತ್ತೆ.
28th or 29th.
ಇಷ್ಟು my lords, it's a old matter, my lords. They could have filed ಒಂದು ವಾರದಲ್ಲಿ ಆದ್ರೆ ಆಯ್ತು.
ಏನ್ ಮತ್ತೆ? Yes, next.
Please.
Charan Desai. There is no representation for the petitioner. ಇಲ್ಲ. Sorry, ಅದು ಹೊಡೆದಾಕಿ. There is no appearance by the petitioner. Notice ಹೋಗಿದ್ಯಾ? ಮುಂಚೆ ಯಾರು ಇದ್ರ ಅಡ್ವೊಕೇಟ್? In terms of the order dated 24/1/2023, the petitioner, who until then was appearing in person, sought time to engage an advocate. Full stop. From then on, the petitioner has not appeared before the court. Even today, there is no appearance for the full stop. Hence, the petition is dismissed for non-prosecution.
I am appearing for the
Harshvardhan.
petitioner. Lordship, I seek 2 weeks lordship time for producing some documents regarding.
Time list of 2 weeks.
Please.
Ravi Patil.
Where? Where? Not right. It's a case where not
Legible copy of annexure AEG.
this is the second round of litigation.
The office objection ಅಷ್ಟೇ ಹೇಳ್ಬೇಕು ಅಷ್ಟೇ.
Please.
EG. Office objection at serial number 6 is overruled. What about annexure C and M to be clarified? ಏನದು?
C is
C and M.
this is a representation made page number 36.
Office objection number 5 is also overruled. So court fee has to be paid.
I paid the court. Paid.
Office objection C number 6 is overruled. Yes, what is the case?
My lord, this is a case where, my lord, petitioner was allotted with a site. My lord, as per annexure A, my lord, lease cum sale agreement.
Hmm.
My lord, the rate of, my lord, may I take, my lord, the earlier order of this honorable court where, my lord, it was considered in detail. My lord, page number 31, my lord. Page number 31. We are I am the allottee of a site.
Hmm.
My lord, the sale, when I had requested for execution of a sale deed, the authority, my lord, increased the price of the site by, my lord, more than 10 times. Therefore, my lord, I had approached this honorable court for the, my lord, challenging that endorsement. May I take your lordship to annexure K, page number 45?
Hmm.
My lord, this honorable court, after considering, my lord, the matter in detail, page number 51, para 8, my lord. In this particular case, also, even without providing an opportunity to the other side, as well as without explaining as to how the escalation can be made from 5 lakhs to 25 lakhs per acre.
Judgment of the Supreme
How?
Court in the
How?
Prakash.
Adane rely ಮಾಡಿ Prakash Dalmil versus Manod State of Karnataka. That was referred to Manod at para 6 of Manod the judgment, page number 50.
Para 6.
How? Then Manod, this matter was allowed. But however, Manod, just before 8 days before Manod, under protest, Manod, the petitioner paid this amount. Manod, that representation is at annexure L Manod, page number 54.
Yes,
Because Manod, he has to clear Manod the loans Manod availed.
take out notice.
Please.
Issue. Yarge.
One government, my lord.
AM
AM
Nagral.
Nagral Manod.
AM Nagral is directed to accept notice for the respondent.
On 2 to Manod 4.
2 to 4.
One government.
Manod 4 appears Manod government joint director.
Yes, my lord.
Industries
Government.
and Commerce.
One
Manod.
and
And
4.
4 AGA.
Please.
2 and 3
AM
AM Nagral.
Nagral.
Yes. Maintainability of WP. Ramchandra, what is challenged?
Auction notification issued by the respondents, my lord. We have challenged here for quashing and we are seeking directions to respond number 4 and 5 to.
Under the Surface Act.
Yes, but actually out of 23 lakhs, he paid 18 lakhs. The remaining also he is ready to pay the under
Ready to
OTS
pay, ನೀವು
scheme.
ದುಡ್ಡು ತಗೊಂಬಂದ್ರೆ we can do something.
My lord, 30th/9/2024 auction held. 30th/9.
Auction ಆಗೋಗಿದೆ.
As per annexure, my lord, it is to be held on 30th/9. ಈ ಹರಾಜು ಮಾರಾಟ ಪ್ರಕರಣ.
ಏನಾಯ್ತು ಆಕ್ಷನ್? ನಿಮ್ ಪೇಪರ್ ಹಾಕಿದಾರೆ ನೋಡ್ರಿ. ಯಾವತ್ತು ಡೇಟು? When is the date of the auction?
30th/9/2024.
30/9/24.
Yes,
ಏನಾಯ್ತು? 4 ತಿಂಗಳಾಗೋಯ್ತು, ಏನಾಯ್ತು?
ಮತ್ತೆ ಇದು February.
I'll get it,
Crown Counsel for the petitioner seeks time to secure instructions
please.
about the auction held on 30th of September 2024. List on. Yes.
For the petitioners, Lordship, the
List
Waiting
after
the-
service of notice to respond.
Lordship, the respondents are KBJNL, Lordship, anybody.
ಯಾರು ಹೇಳಿ?
Krupa Sagar Patil is,
All the respondents?
yes, Lordship.
The Krupa Sagar Patil is directed to accept notice for the respondents.
Respond 1 to 6 months,
1 to 6.
1 to 5.
1 to 5. E-governance officer
Is also, Lordship, comes under their jurisdiction, Lordship. Tendering allotment, Lordship, e-procurement cell.
Respond on date. Good.
Date may be given, Lordship. Yes.
deducting it from your account, salary.
ಅಲ್ಲ ಅದೇ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ. ಇವ್ರು ಪೇಮೆಂಟ್ ಲೇಬರ್ಗಳಿಗೆಲ್ಲ ಪೇಮೆಂಟ್ ಇವ್ ಮಾಡೇ ನೀವು ಆಲ್ರೆಡಿ ಇವ್ರು ಪ್ರಾಪರ್ ಸಬ್ಮಿಟ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿ ಡಿಡಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಆಲ್ರೆಡಿ ಬಿಫೋರ್ ಒಂದು ಸಿಂಗಲ್ ಬೆಂಚ್ ಆಲ್ರೆಡಿ ಆರ್ಡರ್ ಪಾಸ್ ಮೈ ಲಾರ್ಡ್.
Checks were,
Page number 58 my lord.
Yes.
what it is learned, at the time of audit, my lord, objections were raised because he has not settled the account, my lords,
Settle the
for
account.
making payment of the salary towards outsourcing employees, my lords. So that bill we wanted, how much amount that has given towards the advance check which was given to him, my lords. That was not tallying the receipts which were now filed along with the writ petition, my lord. Therefore,
But correct, why are you concerned about it? It is between him and his employees.
let's, he is our employee, my lord. He is employee of Central University. He was given an extra in charge of making payment to the outsourcing agency, my lords. What he has said that I have already made payment, but those receipts are not given for the audit report, my lord.
Page
That
number-
was objection was raised and I said, furnish all the receipts so that they can give the compliance objections to the audit.
Yes, when have you given the receipts?
My lord already.
Time of filing of writ petition, my lords, for the first time they have furnished along with the writ petition. And the reply endorsement is also given to him saying that those receipts which are alleged to have been given by the outsourcing employees, my lords, they are not in order, therefore they have rejected, my lords.
Page number 62 my lord, single bench order. my
When
lord.
will you get instructions?
My lords,
When will you get
10 days,
instructions?
10 days, my lords.
Learn counsel for the respondent seeks.
One date my lord, on date my lord.
To file objections, list on date code. R3 and R4,
Please permit me
Process.
1 week time, my lord.
1 week time is granted to do the needful. Avinash Uplankar. Certificate copy. IA 1 is allowed, 1 of 24 is allowed.
This matter was heard on the,
Yeah.
matter was heard on the last date of hearing pertaining to the cancellation of license, gun license.
Yes, government.
Section 18 appealable order. Arms
Oh.
Act, my lord. Section 18.
Section 18 would not be coming into force because it's only on the conviction it can be done. Mere pendency of a criminal case would not entail the authorities to cancel my license. And unfortunately,
Arms
the,
Act.
the license was granted to this particular petitioner.
Hmm.
It was on 30th/12/2019. The cases registered against this petitioner, about 6 cases are being shown. The 5 cases pertain to the year 2019.
Yeah, that's okay, but appeal ಇದೆಯಲ್ಲ.
ಅದು ಅಪೀಲ್ ಹೋಗಿದ್ದೀನಿ, ಅಪೀಲ್ ಅಲ್ಲೂ ಕೂಡ
It's also
ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ದಾರೆ.
Reject Annexure E appeal order.
ಅಲ್ಲೂ reject
ಅದು
ಆಗಿದೆ.
ಕನ್ಫರ್ಮ್ ಮಾಡಿ.
Hmm.
Being agreed by that thing, I am before this court.
Will you get instructions, Mr.?
Please, my lord, I will go to
Can
the
this
file.
be a
the-
ground for you to
Six.
cancel?
No, my lord, Annexure C, detail order is came to be passed, my lord.
Oh, mere
It-
pendency of a criminal case is that?
No, not only criminal case, my lord, apart from other things also involved.
ಏನು
Other-
apart from that?
Yes,
ಅದರ್
please,
ಥಿಂಗ್ಸ್ ಅಂದ್ರೆ ಮೌಖಿಕವಾಗಿ ನನಗೆ ದೂರುಗಳು ಬಂದಿರುತ್ತವೆ ಜನರಿಂದ. ಆದ್ದರಿಂದ ಕೈಂಡ್ಲಿ ಮೈ ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಟೇಕ್ ಪೇಜ್ ನಂಬರ್ 21. ಇದು ಲಾಸ್ಟ್ ಬಟ್ 1 ಪ್ಯಾರಾಗ್ರಾಫ್. ಸದರಿ ಪ್ರಕರಣಗಳು ಮತ್ತು ಅವರ ಸ್ವಭಾವದ ಹಿನ್ನೆಲೆ ಈಗಾಗಲೇ ಅವರ ಮೇಲೆ ಸಿಂದಗಿ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ರೌಡಿ ಶೀಟ್ ತೆರೆಯಲಾಗಿದೆ. ದಿಸ್ ಹ್ಯಾಸ್ ಬಿನ್ ಸೆಟ್ ಅಸೈಡ್ ಬೈ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್. ಆಯುಧ ಲಯನ್ಸ್ ವಿವರಿಸಿರ್ತಾರೆ. ಪೊಲೀಸ್ ಅಧೀಕ್ಷಕರು ವಿಜಯಪುರ ಇವರ ವರದಿ ಆಧರಿಸಿ ಹಾಗೂ ಇವರ ಚಟುವಟಿಕೆಯ ಬಗ್ಗೆ ಸಿಂದಗಿ ತಾಲೂಕಿನ ನಾಗರಿಕರು, ಅಧಿಕಾರಿ ಮತ್ತು ಸಿಬ್ಬಂದಿ ವರ್ಗದವರು ಮೌಖಿಕವಾಗಿ ನನಗೆ ದೂರು ನೀಡಿದ್ದ ಕಾರಣ ಸೊ ಅಂಡ್ ಸೊ ನಾನು ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
Hmm.
There should be some subjective satisfaction. Any case registered against me under the Indian Arms Act violating the conditions envisaged as per section 17. No case has been registered against me under the Arms Act. And the 5 cases, 6 out of the 6 cases,
So you need not even fire, you have to only show.
ಅದನ್ನು ಮಾಡಿಲ್ಲ ನಾನು.
ನೀವು ತೋರ್ಸಿದ್ರೆ ಸಾಕಲ್ಲ. fire
ಇಲ್ಲ,
ಮಾಡಿ.
ಅದನ್ನು ಮಾಡಿಲ್ಲ ಇದರಲ್ಲಿ ಅದನ್ನು ಮಾಡಿಲ್ಲ. It was hardly for 2 months with me. The license was with me for 2 months.
Is it a, what do you call, single barrel, double barrel or a revolver, pistol, ಏನು?
Revolver, pistol. I have enclosed the license copy at page number 22. Pistol number dash so and so, one extra magazine and 16 live rounds.
9 empty rounds ಏನಕ್ಕೆ?
ಅದು additional ಆಗಿ ನಮ್
Empty rounds ಯಾಕೆ?
actually I don't have anything personal knowledge about
Empty rounds ಎಲ್ಲಿ ಹೊಡೆದಿದ್ದೀರಿ?
one extra magazine and license ಅಥವಾ ವಿನಾಯಿತಿ ಯಾವದಾದರೂ.
One extra magazine and 9 empty rounds and 16 live rounds.
9 empty rounds.
Empty rounds ಎಲ್ಲಿ ಉಪಯೋಗಿಸಿದ್ರೆ ಇದನ್ನ?
9 empty rounds probably practice ಮಾಡಿರ್ಬೇಕು. ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿರ್ಬೇಕು. ಒಂದ್ಸತಿ ಎಲ್ಲಾದ್ರೂ ಹೋಗಿ ಗುರಿ ಇಟ್ಟು can I fire it or not? They might have tested how it works. It's a new pistol. Whether it is going to ಅದೇನಾದ್ರೆ ಸೆಗಣಿಯಲ್ಲಿ ಇಟ್ಟು ಟೆಸ್ಟ್ ಮಾಡ್ತಾರೆ. The testing is
ಪ್ರಾಕ್ಟೀಸ್ ಸಿಟಿಲ್ ಮಾಡಿದ್ರು ಜಂಗಲ್ ಅಲ್ಲಿ ಮಾಡಿದ್ರು ಗೊತ್ತಾಗ್ಬೇಕಲ್ಲ.
ಇಲ್ಲ ಆ ತರ ಯಾವ ನನ್ನ ಎದುರು ಅಗೇನ್ಸ್ಟ್ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಆಗಿಲ್ಲ. ಯೂಶಲಿ ಸೆಗಣಿಯಲ್ಲೇ ಒಂದಿಟ್ಟು ವೆದರ್ ಇಟ್ ಈಸ್ ಗೋಯಿಂಗ್ ಟು ವರ್ಕ್ ಆರ್ ನಾಟ್ ಇಟ್ ವಿಲ್ ಬಿ ಫೈರ್ಡ್ ಅಂಡ್ ಟೆಸ್ಟೆಡ್.
Yes, government.
Please, I will go to file the detail.
And AG is directed
2
to
weeks.
secure instructions. List on date. Put.
Please.
IA 1-2 of 24 is allowed. Next. Yes.
Challenging the Annexure H, my lords, that is.
Annexure?
Annexure H, the order of suspension
Ah.
without pending enquiry, that is in the, as good as in the nature of cancellation of the license. You will also may kindly see the report submitted by the Tahsildar, in page 23, operative portion. On the basis of that report, my lord, the alleged report, he has issued so-called notice. In page 23, my lord.
Yes.
ಕಾರ್ಡುದಾರ ಹೇಳಿಕೆಯೊಂದಿಗೆ ವರದಿ ಸಲ್ಲಿಸಲು 30/10/23 ತಿಳಿಸಲಾಗಿತ್ತು. ಸದರಿ ಅರ್ಜಿಯನ್ನು ಪರಿಶೀಲಿಸಲು ದಿನಾಂಕ 18/23 ಹಗರಗುಂಡ್ ಗ್ರಾಮಕ್ಕೆ ಭೇಟಿ ನೀಡಿ ಕಾರ್ಡುದಾರ ವಿಚಾರಿಸಲಾಗಿ ಸದರಿ ಕಾರ್ಡ್ ಅವರು ಬಯೋಮೆಟ್ರಿಕ್ ಪಡೆಯಲು 10 ರೂಪಾಯಿ ಹಣವನ್ನು ಮತ್ತು ಪಡಿತರ ವಸ್ತು ವಿತರಣೆ ಮಾಡುವಾಗ 10 ರೂಪಾಯಿ ಪಡೆಯುತ್ತಾರೆ. ಒಟ್ಟು 20 ರೂಪಾಯಿಯನ್ನು ಪಡೆಯುತ್ತಾರೆ ಹಾಗೂ ಪ್ರತಿ ಕಾರ್ಡಿಗೆ 1 kg ಅಕ್ಕಿಯನ್ನು ಕಡಿಮೆ ನೀಡುತ್ತಾರೆ. ಕೇವಲ 3 ದಿನ ಪಡಿತರ ವಸ್ತುಗಳನ್ನು ವಿತರಣೆ ಮಾಡಿ ನ್ಯಾಯಬೆಲೆಗಳನ್ನು ಬಂದ್ ಮಾಡಿರ್ತಾರೆ. These are the allegations, my lord. That is without visiting the village, my lord. They issued so-called notice by page 24. Allegations, my lord. They are entirely different from those alleged report and these so-called notices, my lord. ಪ್ರಾಧಿಕಾರ ಪತ್ರ ಪಡಿಸದಲ್ಲಿ ಪಡಿತ ವಿತರಣೆ ಮಾಡಿರೋದಿಲ್ಲ, ಅನ್ನಭಾಗ್ಯ ಪ್ರದರ್ಶನ ಮಾಡಿರೋದಿಲ್ಲ, ಸಮಿತಿ ಸದಸ್ಯರ ಪಟ್ಟಿ ಪ್ರದರ್ಶನ ಮಾಡಿರೋದಿಲ್ಲ, ದಾಸ್ತಾನು ದರ ಪಟ್ಟಿ ಪ್ರದರ್ಶನ ಮಾಡಲ್ಲ, ಅಧಿಕಾರ ತಪಾಸಣೆ ನಿರ್ವಹಿಸಿರೋದಿಲ್ಲ, ಥರ್ಮಲ್ ಪ್ರಿಂಟರ್ ಅಳವಡಿಸೋದಿಲ್ಲ. Then pass the has filed the explanation along with the photographs which has maintained all those things. Without pending inquiry, my lord, they pass this Annexure H as good as the cancellation of this license. Operative portion of that order, may kindly see in page
Page number
30.
23 is what date?
23, my lords.
28/11. 28/11. And the inspection is on 20th of September.
28/11, this is report and.
That is a report.
Yes, ma'am.
Thereafter, they have inspected your shop on 27, 24.
Thereafter, before that, they have inspected and ಹೇಳಿದಾರೆ.
Madam, 27 ಮಾಡಿ annexure F ಗೆ ಬನ್ನಿ.
Annexure F.
27-24ಕ್ಕೆ ತಾಳಿಕೋಟೆ ತಾಲೂಕಿನ ಆಹಾರ ಶಿರಸ್ತೆದಾರರು ಹಾಗೂ ಆಹಾರ ನಿರೀಕ್ಷಕರು ನಿಮ್ಮ ನ್ಯಾಯಬೆಲೆ ಅಂಗಡಿ ಭೇಟಿ ನೀಡಿದ ಸಂದರ್ಭದಲ್ಲಿ
ಅದೇ ಇದೆ ಸೇಮ್ ಅವರು ಡೇಟ್ಗಳು ಮಿಸ್ಟೇಕ್ ಮಾಡ್ತಾರೆ. ಬಂದ್ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ವಿಸಿಟೆಡ್ ಎನಿ ಸ್ಪಾಟ್. ಈ ರಿಪೋರ್ಟ್ ಮೇಲೆ ದೇ ಹ್ಯಾವ್ ಇಶ್ಯೂಡ್ ಸೋಕಾಸ್ ನೋಟಿಸ್.
ಈ ರಿಪೋರ್ಟ್ ಮೇಲೆ ಅಲ್ಲ, ರಿಪೋರ್ಟ್ ಇಸ್ 28/11.
ಅಲ್ಲ, ಅವ್ರ ಡೇಟ್ಗಳೇ ಮಿಸ್ಟೇಕ್ಸ್. ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಅಪ್ಲೈಡ್ ದೇರ್ ಮ್ಯಾಂಡ್ ವಿದೌಟ್ ಪೆಂಡಿಂಗ್ ಎನ್ಕ್ವೈರಿ, ಓನ್ಲಿ ಇನ್ಸ್ಟಿಗೇಷನ್ ಆಫ್ ದಟ್ ಪೊಲಿಟಿಕಲ್ ಪರ್ಸನ್ಸ್, ಲೋಕಲ್ ಪೊಲಿಟಿಕಲ್ ಪರ್ಸನ್ಸ್. ಇಲ್ಲ ಸಿಂಪ್ ಕೈಂಡ್ಲಿ ಸಿ ದಿ ಇಂಪ್ಯೂನ್ಡ್ ಆರ್ಡರ್, ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಇನ್ ಪೇಜ್ 30. ಮೇಲ್ನೇ ಕೋಷ್ಟಕದಂತೆ ಸದರಿ ವರೆಸಿಗೆ ಲೋಪದೋಷ ಮೇಲ್ನೋಟಕ್ಕೆ ಕಾರಣ ಕರ್ನಾಟಕ ವಸ್ತುಗಳ ನಿಯಂತ್ರಣ ಆದೇಶ 16 ಅನ್ವಯ ಸರಿದಿ ಹೊಂದಿರುವ ಪ್ರಾಧಿಕಾರ ಪತ್ರವನ್ನು ಅಮಾನತಿರಿಸುವ ಸೂಕ್ತ ಬಂದ ಕಾರಣ ಈ ಕೆಳಗಿನಂತೆ ಆದೇಶ ಪ್ರಸ್ತಾವನೆ ವಿವರಿಸಿದ ಅಂಶಗಳಂತೆ ಕರ್ನಾಟಕ ವಸ್ತುಗಳ ಸೋ ಆದೇಶ ಕ್ಲಾಸ್ 12 ಮೇರೆಗೆ ಪ್ರದತ್ತವಾದ ಕಾರಣ ತಾಳಿಕೋಟೆ ತಾಲೂಕಿನ ಹಗರಗುಂಡ್ ಗ್ರಾಮ ಸೋ ಸಂಘದ ನ್ಯಾಯಬೆಲೆ ಅಂಗಡಿಯವರು ಹೊಂದಿರುವ ಪ್ರಾಧಿಕಾರ ಪತ್ರವನ್ನು ಅಮಾನತಿರಿಸಿ ಆದೇಶಿಸಲಾಗಿದೆ. Class 12(2), my lord, your last may kindly see the extracted class 12(2) in my petition.
Suspension ತಾನೇ ಮಾಡಿರೋದು.
Suspension is pending inquiry. Without pending inquiry, they can't suspend. They as good as cancellation of authorization.
Yes.
Last may kindly see I extracted clause 12(2) in my petition,
Yes.
ink page 3, ink page 9,
Hmm.
para 12.
Yes.
Rule 12(2) of the control orders provides as under, if the authorized authority is satisfied that prima facie the conditions of authorization or provisions of the order are contravened, he may, notwithstanding anything sub clause 1, suspend the authorization pending inquiry for cancellation of authorization. He can suspend the authorization pending inquiry.
Yes. Take out notice here, government.
It's government.
PG has directed accept notice for response 1 to 4. List on yav 3. When will you get instructions?
1 week.
List on.
Till then, my lord, interim order. Last may kindly see Annex J
No,
approves
madam.
the
No
villages.
interim order. No interim order. Yes, list on date could. Yes. IA1 is allowed. Yes, next. Yes, madam.
The technical bid produced at Annex 53, my lords.
Connection
Annex D,
53.
yes, my lord.
Ah,
My one is Lingasur Taluk, 54.
hmm.
My name is found placed in serial number 3, H. Virupakshappa, ink page 55.
Prakash B. Tambake.
55, the land is
55.
H. Virupakshappa. Lingasur Taluk,
H. Virupakshappa.
yes, my lord.
Ah,
The reasons for rejecting the my technical bid is 1920, 21, 2020 ಸಾಲುಗಳ ಆದಾಯ ತೆರಿಗೆ ರಿಟರ್ನ್ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ, ಆದರೆ ನಿರಂತರ 3 ವರ್ಷಗಳ ಆದಾಯ ತೆರಿಗೆ ರಿಟರ್ನ್ಸ್ ಸಲ್ಲಿಸುವುದಿಲ್ಲ. He has submitted all the returns, my lord, produced at Annex C series and C to C5. As per clause 5(3) of the tender notification. Last may kindly see the tender clause 3 of the tender notification 5(3).
ಇಲ್ಲಿ the page?
Tender notification, my lords.
Page?
Page number 34, man.
Ah, yes.
So 5(3), sorry, 5, they have mentioned it as 5(3), not 5(3), 5(9) ಅಂತ ಹಾಕಿದ್ದಾರೆ. 5(9).
5(9).
Yes, my lords. May
5(9) ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ?
one second.
Huh?
For a minute, move. IT returns, my lord, I'll 4(9), my lord, sorry, tender class 4(9). 4 ink page 23, my lord. 4(9) is found place in ink page 24. The bidder's annual turnover must be 60 lakhs and above from the transportation activities itself. Bidder should submit the details on this regard along with the copies of filed income tax returns 1920, 2021, 21, 22, 22, 23, 23, 24, any 3 consecutive years, financial years. The bidder should submit attested balance sheet, profit loss statement and audited report in the form of so and so. I have furnished all these, my lord, C series, and my turnover is also more than 60 lakhs on Annex C5, ink page 52.
Page number 52.
52, my lord, C5, that is turnover certificate. As for C series, my lord, 19, 22, 23, 24, I have furnished the 24 till 24, 25 returns, tax returns. Reason is, my lord, I have not submitted the 3 consecutive IT.
Appeal ಇದೆಯಲ್ಲ? What will you do with the appeal remedy?
Appeal that is confirmed. I have produced that Annex E.
Annexure E.
Yes, my lord. They have confirmed the same as it is.
Yes, Mr.
My lord, kindly see appeal, page number 60. He has not filed IT return for the assessment year 2021, para 2. He
Aye.
has mentioned, my lord,
ಓದಿ.
ರಾಯಚೂರು ಜಿಲ್ಲಾ ಬಿಡ್ ಮೌಲ್ಯಮಾಪನ ಸಮಿತಿ ದಿನಾಂಕ 9/10/24 ತೀರ್ಮಾನ ವಿರುದ್ಧ ವಿರೂಪಾಕ್ಷ ಸಾಗಣೆ ಗುತ್ತದಾರರು ಮನವಿ ಸಲ್ಲಿಸುತ್ತಾರೆ. ಈ ಮನವಿಯಲ್ಲಿ ಕೆಳಕಂಡಂತೆ ನಿವೇದಿಸುತ್ತಾರೆ. 24-26 ಸಾಲಿನ ಸಾರ್ವಜನಿಕ ವಿತರಣಾ ಪದ್ಧತಿ ಅಡಿ ಮಾನ್ಯ ಆಯುಕ್ತರು ದಿನಾಂಕ 23/8/24 ಟೆಂಡರ್ ಕರೆದಿದ್ದು, ಅದರಲ್ಲಿ ರಾಯಚೂರು ಜಿಲ್ಲೆಯ ಲಿಂಗಸೂರು ಮತ್ತು ಸಿನ್ನೂರು ತಾಲೂಕುಗಳಿಂದ ಭಾಗವಹಿಸಿರುತ್ತೇನೆ. ಆದರೆ 3 ವರ್ಷದ IT ರಿಟರ್ನ್ ಕೇಳಿದ್ದು, 5 ವರ್ಷದ ರಿಟರ್ನ್ ಅಂದರೆ ಸೊ ಅಂಡ್ ಸೊ ಮತ್ತು ಸಾಲಿನ IT ರಿಟರ್ನ್ ಅಪ್ಲೋಡ್ ಮಾಡುತ್ತೇನೆ. ಆದರೆ 2021 ಸಾಲಿನ ಅಪ್ಲೋಡ್ ಮಾಡುವಾಗ ಕಣ್ಣು ತಪ್ಪಿನಿಂದ ಅಪ್ಲೋಡ್ ಮಾಡಿರೋದಿಲ್ಲ. ಆದ ಕಾರಣ 2021 ಸಾಲಿನ ಆದಾಯೇತರ ಪ್ರತಿಗಳನ್ನು ಲಗತ್ತಿಸುವುದರಿಂದ ರಾಯಚೂರು ಜಿಲ್ಲೆ ಲಿಂಗಸೂರು ಮತ್ತು ಸಿನ್ನೂರು ತಾಲೂಕುಗಳ ತಾಂತ್ರಿಕ ಬಿಡ್ ಅನ್ನು ಹಾರುಗೊಳಿಸಬೇಕಾಗಿ ಕೋರಿ ಮನವಿ ಸಲ್ಲಿಸಿರ್ತಾರೆ.
ಅದೇ ಬಟ್ 3 ವರ್ಷ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ.
Yes, ma'am.
3
But
ವರ್ಷ.
under section 16 of KTPP Act, he has to appeal before principal secretary, ma'am, further.
Second appeal.
Yes, ma'am.
ಇಲ್ಲ, this is only commissioner before.
ಇಲ್ಲ, section
Income tax
16.
ಅಲ್ಲ.
Any tenderer aggrieved by an order passed by the tender accepting authority other than government under section 13 may appeal to the prescribed authority within 15 days from the date of receipt of order.
ಇದಾಗಿದೆ ಇದು.
ಆಗಿಲ್ಲ, my lord. He has preferred
Commissioner ಯಾರು?
Commissioner ಮುಂದೆ.
commissioner one matter. Now he has to before principal secretary, ma'am.
ಅಲ್ಲ,
ಇಲ್ಲ,
but where is
second.
the second appeal?
Authorized authority, there is no such second appeal, my lord. Authorized
Is it,
authority
ma'am?
means only commissioner. Since many proceedings, my lord, I have.
Becomes final ಅಲ್ವಾ?
Yes, ma'am.
16(3) ನಲ್ಲಿ.
Yes,
If it is final, then writ petition is maintainable. Where's the question of?
pass off, my lord. I will submit.
See, that is one.
Yes,
But
ma'am.
2 ನಲ್ಲಿ, see this 3 years.
Yes,
Income
any
tax-
3 years ಅಂತ
Any
ಇದೆ
3 years
condition.
ಅಂತ ಕೊಡೋದು ಸಾಕಾಗುತ್ತೆ. So therefore, admittedly, 2019-20.
Yes. 1920 ಇಂದ 24-25
ನೀವು ಕೊಟ್ಟಿರೋದು ಯಾವ್ದು?
2021 they have misplaced.
sought for 19-20, 20-21, 21-22, 22-23. ಈ 5 ವರ್ಷದಲ್ಲಿ ಯಾವಾಗಾರು 3 ಕೊಡ್ಬೋದು.
Yes.
ಬಟ್ ನೀವು 19-20 ಕೊಟ್ಟಿದ್ರಿ, 20-21 ಕೊಡ್ಲಿಲ್ಲ.
ಸತತ 3 ವರ್ಷ ಅಂತ ಇದೆ.
ಹಾ.
ಅದರಲ್ಲಿ ನಡುವ 2021 ಅದಕ್ಕೆ ಗ್ಯಾಪ್ ಆಗ್ತಾ ಇದೆ.
ಗ್ಯಾಪ್ ಆಯ್ತು.
ಆ ಕಡೆಯಿಂದಾನು ಗ್ಯಾಪ್, ಈ ಕಡೆಯಿಂದ ಗ್ಯಾಪ್ ಆಗ್ತದೆ.
ಕಡೆ ಗ್ಯಾಪ್ ಆಯ್ತಲ್ಲ.
That's why.
But he has income tax assessee for continuously.
That is not the issue. Whether you uploaded the documents or not. ನೀವ್ ಹೇಳ್ತೀರ ಕಣ್ ತಪ್ಪು ಅಂತ ನೀವ್ ಹೇಳ್ತೀರಾ? ಕಣ್ ತಪ್ಪಿನಿಂದ ಮಿಸ್ ಆಗೋಯ್ತು ಅಂತ ಹೇಳ್ತೀರಾ?
ಅದು ಎಂಡ್ ಆದ್ರೆ ನಡೀತೈತೆ.
ಈಗ 2017, 18, 19. 20-21 ಕೊಡ್ಲಿಲ್ಲ ಅಲ್ಲಿ, ಅಥವಾ 19-20 ಕೊಡ್ಲಿಲ್ಲ.
19-20 ಇದೆ ಕಣ್ಸ್.
ಇಲ್ಲ 2021.
2017.
ಅವ್ರ ಇದರ ರೆಕಾರ್ಡ್ ಪ್ರಕಾರ ಏನೋ 20-21 ಅಂತ ಹೇಳಿದ್ದಾರೆ.
2019-20 ಇಂದ 5 ವರ್ಷದಲ್ಲಿ ನೀವು 3 ವರ್ಷ ಕೊಡ್ಬೋದು.
19-20, 20, 21, 21, 22.
22, 23, 24,
24-25
ಕೊಟ್ಟಿಲ್ವಲ್ಲ ನೀವು?
24-25
ಕೊಟ್ಟಿಲ್ಲ.
ಇಲ್ಲ ಮೇಡಮ್.
22-23.
22-23 ಎಕ್ಸಾಕ್ಟ್ ಮಿಡ್ಲ್ ಆಗ್ತಾ ಇದೆ.
ನೀವು ಕೊಡ್ಲಿಲ್ಲ. ನೀವು ಮುಖ್ಯವಾಗಿರೋದೇ ಕೊಡ್ಲಿಲ್ಲ. 19-20, 20-21, 21-22 ಕೊಟ್ಟಿದ್ರೆ ಆಗಿರ್ತಿತ್ತು. ಅಥವಾ 20-21, 21-22, 22-23 ಕೊಟ್ಟಿದ್ರೆ ಆಗಿರೋದು. ಸೊ ಮಿಕ್ಕಿದ ಮಧ್ಯದಲ್ಲಿ ನೀವು ಕೊಡ್ಲಿಲ್ಲ. ಸೊ ವಾಟ್ ಶುಡ್ ದಿ ಟೆಂಡರ್ ಇನ್ವೈಟಿಂಗ್ ಅಥಾರಿಟಿ ಡೂ?
ಎಂಡ್ ಇದ್ರ ನಡ್ತಿತ್ತು ಮೇಲೆ ಮಿಡ್ಲ್ ಇದೆ. ಕರೆಕ್ಟ್.
ಏನ್ ಮಾಡೋದು?
But actually, as per the records, my lord, he is income tax assessee since. he has
We
produced-
might be necessary, but if he has not uploaded the documents, ಟೆಂಡರ್ ರಿನ್ಯೂಟಿಂಗ್ ಅಥಾರಿಟಿ ಅವ್ರು ಸ್ಕ್ರೂಟ್ನಿ ಮಾಡುವಾಗ ಏನ್ ಮಾಡ್ತಾರೆ? ನೀವು ಆ ಡಾಕ್ಯುಮೆಂಟೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ, 2021 ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ, ಯು ಆಲ್ಸೋ ಅಕ್ಸೆಪ್ಟ್ ಇಟ್. ಆದರೆ 2021ನೇ ಸಾಲಿನ ಅಪ್ಲೋಡ್ ಮಾಡುವಾಗ ಕಣ್ತಪ್ಪಿನಿಂದ ಅಪ್ಲೋಡ್ ಮಾಡಿರುವುದಿಲ್ಲ. ಅಷ್ಟೇನಾ? ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
I'll get the instruction whether their statement is correct or not.
Petitioner seeks time to secure instructions whether the petitioner has uploaded the income tax returns for the year 2020-21 at the time of filing, submitting the tender. List on yavat beku.
Please.
Ravindra Reddy. Ravindra Reddy.
Next year, C tender notification is questioned, Lord. As per annexure A, my Lord, for Raichur division, there were totally 26 toilets and 21 toilets, 26 toilets and 21 urinals were called for tender, my Lord. But while calling for, after a period of 3 years, my Lord, fresh notification was issued by the annexure C. But while issuing, in regard to Raichur division is concerned, my Lord, 10 toilets and 5 urinals were left out deliberately, my Lord, to see that these toilets and are continued to the same persons who were awarded the work earlier. But otherwise, there is no reason, my Lord, because in the first notification itself, in regard to workmen is concerned, that has not been reduced. Same workman has been mentioned. But only in regard to toilets are concerned, my Lord, that has been changed and reduced.
Where is the earlier notification?
Annexure A, my Lord.
ಎಷ್ಟು ಟಾಯ್ಲೆಟ್ಸ್ ಇತ್ತು ಅದರಲ್ಲಿ?
ಅಲ್ಲಿ 21 ಶೌಚಾಲಯ, 20
ಎಲ್ಲಿದೆ?
ಫಸ್ಟ್ ಕಾಲಮ್ ಅಲ್ಲೇ ರಾಯಚೂರು, ಲಾಸ್ಟ್ ಬಟ್ ಫೋರ್ತ್ ಕಾಲಮ್ ಫ್ರಮ್ ಲಾಸ್ಟ್. ಶೌಚಾಲಯ 26,
ಶೌಚಾಲಯಗಳ ಸಂಖ್ಯೆ 26,
ಮೂತ್ರಾಲಯ 21. And in regard to workmen, next column, 15.
ಈಗ
ಇವಾಗ it has been reduced to 15 and 16. In regard to workmen are concerned, not same as maintained.
How are you agreed by this?
But my only contention, not in regard to tender notification, not it has to be issued in terms of the KTP provisions. Not there has to be a transparency.
No,
They have to give reasons for what reason these toilets and urinals were left
Have you
out.
participated in this bid?
I have participated.
Then why are you worried?
But only in regard to, my Lord, the cost of the tender, my Lord, cost of the expenditure.
Same rule applies to everybody.
Everybody, of course.
So therefore, how can you say that this is?
Their intention wanted to bring it to the notice of this Honorable Court because their intention was not clear. There was no reason to exclude these toilets and urinals.
That if they issue a notification, then you can participate.
Because if these toilets and urinals are included, they will get better business than what now notified.
Can that be a ground to set aside
That's
the
only
auction?
point.
Can that be a ground to set aside? Barkuli, Ashtena, the petitioner has challenged an auction notification dated 27/11/2024 issued by the respondent for cleaning and maintenance of public toilets and urinals at bus stand at the bus stand maintained by the respondent. The petitioner has also sought for a writ in the nature of mandamus directing the respondent to include the remaining 10 toilets and 5 urinals at Raichur bus stand and to process the tender notification as per KTPP Act. Next para. The petitioner contends that the respondent had invited bids on 1/12/2021 for maintenance of toilets and urinals situated at the bus stand of the respondent at various places, including Raichur. The petitioner is only concerned with the toilets and urinals, maintenance of the toilets and urinals at Raichur bus stand, alla?
Oh.
Full stop. He contends that in the earlier notification dated 1/12/2021, the respondent had invited bids for maintenance of 26 toilets and 21 urinals. However, after the expiry of the term of the tender, the respondent has now invited fresh bids in respect of 15 toilets and 16 urinals at Raichur bus stand. It is therefore contended that the exclusion of 11 toilets and 5 urinals is without any basis and is designed to help the persons who have been awarded with the tender on 1/12/2021. It is therefore claimed that the tender dated 27/11/2024 is without proper application of mind and hence is sought to be quashed. Next para. A full stop. In addition, it is contended that in the earlier notification dated 1/12/2021, 30 employees were the minimum employees to be employed for the maintenance of the toilets and urinals, and the said number of employees continued in the notification dated 27/11/2024. He therefore contends that it is now not profitable to employ the same number of workmen to maintain a lesser number of toilets and urinals, and that the tender notification is issued without proper application of mind. Full stop. Next para. The learned other side yaru? KSRTC yaru any KRTC? Kalyan.
Shubhayogi Mutt and Subhash Mallapur.
Mr. Madam idara? Mrs. Ratna Shivyogi Mutt, who was directed to accept notice, submitted that the ground urged by the petition for challenging the notification are not maintainable since these conditions are applicable to all tenderers who submit their bid. Full stop. She contends that in respect of the remaining toilets and urinals, the procedure prescribed under the KTPP Act would be followed, and therefore the petitioner cannot have any grievance. Besides this, she contends that the petitioner submitted his bid and therefore he cannot challenge the terms of the bid. So next, I consider submissions of learned counsel for the petitioner and the learned counsel for the respondent. It appears that the respondent had invited bids on 1/12/2021 for maintenance of 26 toilets and 21 urinals at Raichur bus stand. And the terms of the conditions envisaged that 30 personnel had to be compulsorily appointed for the maintenance of the urinals and toilets. After the term of the tender, the respondent has now invited fresh bids for maintenance of 15 toilets and 16 urinals and has mandated that 30 employees shall be employed in 2 shifts, two shifts for the aforesaid purpose. Full stop. These conditions apply across all tenderers who submit their bids, and therefore the petitioner cannot have any grievance and contend that the remaining urinals and toilets were not put up for auction. Full stop. If the petitioner has participated in the tender and has submitted his bid, he cannot allege that the subject matter of the bid had to be something more than what was notified. Full stop. In that view of the matter, there is no error. In that view of the matter, the petitioner cannot have any grievance against the number of toilets and urinals put to bid and cannot claim that the tender cannot be, that the tender is not commercially viable. Full stop. In that way of the matter, this writ petition fails and is dismissed. Srimati Ratna Shivoyagimat is permitted to file memo of appearance within 10 days.
My lord, I move for the petitioner in this matter.
Yes, please.
My lord, land survey number, my lord, 108/2, measuring 2 acre.
108/2.
My lord, allotted to the, my lord, husband of the, my lord, respond number 4 in the year 1963. My lord, since he has died, my lord, the property was mutated in the name of, my lord, 4th respondent in the year 1980. My lord, she has sold the property, my lord, by obtaining permission from the, my lord, Tahsildar on, my lord, 28/6/2000. Thereafter, my lord, she has filed application before the, my lord, Assistant Commissioner on, my lord, 14/2/2017 to restore the property. My lord, the Assistant Commissioner, my lord, restored the property and sealed it executed by respond number 4 in favor of the petitioner has been, my lord, nullified. And same is, my lord, to be challenged before the first respondent. First respondent confirmed the order passed by him.
Yes, for could issue emergent notice. Sorry. AGS directed to accept notice for response 1 to 3, issue emergent notice to respondent number 4. Since it is stated by the petitioner that the respondent number 4 had alienated this property in question to the petitioner after obtaining necessary consent from the office of the Deputy Commissioner,
Tahsildar.
from the office of Tahsildar. Tahsildar permission ಕೊಡ್ತಾರೆ.
Other ground only that has not been considered, but said it is alienation is, my lord, on 28/6/2000. Same is challenged in the year 2017.
And that the respondent number 4 had sold the property to the petitioner on
28/6/2000.
28/6/2000, but later in the year 2017,
Also.
filed an application for resumption and restoration of the land, all the impugned orders passed by the respondent number 1 and 2 are stayed. Abdul Muqtadir.
My lords, the father of the petitioner passed away on 16/1/2024, my lords. And we had applied for the death certificate, my lords, and the death certificate was issued by respondent number 2, my lords.
Is government,
But on
CMC, government is also party.
AGS directed to accept
1.
notice for respondent number 1. What about 3?
Joint,
3 ge Chief Registrar of Births and Deaths.
yes, it is
3
also
and
government.
4.
4.
3 and 4.
Yes.
CMC Shabad. Gauri Shankar Kashampur is directed to accept notice for respondent number 2.
Okay.
Param Gowda.
The petitioner is appointed by the ZP, my lord, and he was terminated, and same has been referred to the industrial adjudication to the Labor Court Raichur. And the Labor Court Raichur has framed the preliminary issue that whether the claimant is the workman as defined under section 2S of AD Act or not. And holding that he is not the industry. And
What is the nature of work?
is a stenographer, my lordship. Skilled, unskilled, any type of work is covered under.
Just income, salary is to.
His salary was, initially he was paid 10,000 rupees and
On the
thereafter.
date of you filing an application before the labor court, what was your salary? Salary is to.
There is no, nothing has been mentioned in the claim petition or anything about the salary.
Mr. There's something
it
to show that
requires-
it was 25,000 rupees.
No, my lord, there is no such limitation is not mentioned in the as per section. Yes, my lordship.
ಓದಿದಿರಾ?
Yes, ma'am.
ಓದಿದಿರಾ 2 years?
Yes, ma'am. Is covered under
Come to
minimum wages
Annexure
act
C.
only, ma'am.
Come to Annexure D, mister. ಪ್ಯಾರಾ 3 ಓದಿ, ನೀವು ಫೈಲ್ ಓದದೆ ಬರ್ತೀರಾ ನೀವು, ಅಂದಾಜ್ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಾ.
25,000 rupees was the salary, my lord.
ಮತ್ತೆ ಐ ನಾಟ್ ಮೆನ್ಷನ್ ಎನಿವೇರ್ ಅಂತೀರಾ.
No, at the time of 17, he was drawing salary of 25,000.
What is 2S ಓದಿ? Industrial dispersal. Hmm.
2S, workman means any person including an appreciate employed in any industry to do any nature manual, unskilled, skilled, technical, operational, critical or supervisory work for hire and reward, whether the terms of the employment to be expressed or implemented and for the purpose of any proceedings under this act in a relation to industrial abuse, including any such person through the industrial tribunal or labor court has no jurisdiction to abolish the, who has been dismissed, discharged or restricted in connection with or as a consequences of the dispute or which dismissal, discharge or retrenchment has lead to that dispute, but does not include any such person. Air Force employed fire services whose employee mainly managerial or administrative capacity, who is being employed in a supervisor capacity, draw wages exceeding 10,000 per means are excess either by the nature of the dispute attracted to the office or reason to the powers vested in him, function mainly for managerial nature. That the judgment which was referred, they state that it's not in the state is ZP is not in the industry. But another contention is that, my lord, that they state that he has been outsourced, he has been engaged by outsourcing agency. But my claim is very specific that I have been employed by the respondents.
On what basis are you claiming that?
In kindly peruse the claim statement in page number 28, my lordship, para 4. I have pleaded that ಅರ್ಜಿದಾರನು ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ರಾಯಚೂರು ಇವರು ಅಧಿಕೃತವಾಗಿ ಸೇರಿಸುವಾಗ ಯಾವುದೇ ಹೊರಗುತ್ತಿಗೆ ಆಧಾರದ ಸೇವೆಗೆ ಅನುಗುಣವಾಗಿ ಅರ್ಜಿದಾರರನ್ನು ಸೇರಿಸಿದೆ. ನೇರವಾಗಿ ಅರ್ಜಿದಾರರು ಸೇವೆಗೆ ತೆಗೆದುಕೊಂಡಿರುತ್ತಾರೆ.
ಎಲ್ಲಿದೆ ನೋಟಿಸ್, ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಲೆಟರ್ ಏನೋ ಇದೆಯಾ?
No, my lordship. That appointment, they have produced the appointment of Phoenix, my lordship. I have not issued any appointment order, my lordship. At the time of joining, when I asked to issue appointment order, they have produced it before the court that stating that he has been outsourced.
Yes, who appears for Phoenix? Any advocate for Phoenix idara?
Krupasagar has been.
Krupasagar Patil.
Yes,
Raichur ZP Garo. Gaurish Kashampur is directed to accept notice for R1. Krupasagar Patil. Phoenix party name already.
Yes. Phoenix is not the party. I am not employed with Phoenix, my lordship. It's not my case. It's their case that I have been engaged through Phoenix. Never I have contended that I have engaged with Phoenix, my lordship.
You are not engaged through Phoenix.
Yes, my lord. I am not engaged with Phoenix. It's their case that I have been engaged with.
Emergency notice to respondent number 2.
For the petitioner in this matter. My lord, brother of the petitioner Dattatreya has been, my lord, murdered. My lord, the petitioner belongs to, my lord, scheduled caste and scheduled tribe. My lord, thereafter, my lord, under, my lord, appointment of family members of pension persons belong.
Brother of the petitioner was murdered.
Brother of the petitioner has been murdered.
He was a bachelor.
Bachelor. And I filed application for my appointment of, my lord, compassionate ground. Application has been rejected by the, my lord, respondent number 1 and 2. On the basis of that, my lord, the father of the petitioner was holding 2 acre 12 gunta land, and my lord, from that, my lord, he is earning 60,000 rupees per month. On that basis, my lord, my application has been rejected. My lord, subsequently, my lord, the government of Karnataka has issued notification according to which, my lord, the income has been, my lord, deleted from the.
AGS director accept
Please.
notice for response 1 to 3. ಏನ್ ನ್ಯಾಚುರಲ್ ಕೆಲಾಮಿಟಿ ಏನು?
Yes, sir. Due to heavy rain, house of the petitioner was destroyed by that. He has given application on 3/11/2020.
Madam, this house itself in such a dilapidated condition, ಏನ್ ಮಾಡ್ತೀರಾ? ನೀವು ಮನೆನೇ ಮರಮ್ಮತ್ ಮಾಡಿಲ್ಲ ನೀವು. This house itself is in a dilapidated condition. ಮತ್ತೆ ಮಳೆ ಬಿದ್ದೇ ಬೀಳುತ್ತೆ.
Sir.
ಸುಸ್ಥಿತಿಲಿರೋ ಮನೆ ಬಿದ್ದೋದ್ರೆ we can understand. ಮನೆ ಸುಸ್ಥಿತಿಲಿದ್ದು ಬಿದ್ದೋದ್ರೆ we can understand. ನಿಮ್ ಮನೆ ಬಿದ್ದೋಗೋ ಮನೆ ಮಳೆ ಬಂದು ಬಿದ್ದೋಗಿದೆ. There's a question of granting compensation for this. And who is this person in this photograph? Page number 15.
Who is he is the petitioner, my lord.
He stays there.
Yes, ma'am.
ಬಟ್ಟೆ ಮತ್ತೆ ಕ್ಲೀನ್ ಆಗಿ ಹಾಕೊಂಡಿದ್ದಾರೆ, ಮನೆ ಮಾತ್ರ ಹಿಂಗಿಟ್ಕೊಂಡಿದ್ದಾರೆ. Huh? Is government?
I'll take it.
AGS director to accept notice for response 1 to 4. PDO Kalaburagi, Kamlapura, Aidado, Mahangaon.
Oh, Mahag.
Who is the advocate for Jilla Panchayat Kalaburagi?
Kalburi, Krupa Sagar and
Huh?
Gauri's Kasham.
Rupa Sagar Patil is directed to accept notice for R3. Yes.
Writ of mandamus, my lord, consideration of annexure A and B, my lord.
Annexure?
A and B, my lord, complaint submitted by the petitioner to register FIR against the one Mainuddin, son of Mahbub, who offered publicly to kill the petitioner, my lord. That information received by one Khalil over cell phone. Therefore, in this regard, the petitioner submitted complaints before the authority. Till today, they have not taken any action. Therefore, we are seeking directions to register FIR against the said person, my lord.
Yes, government.
Annexure C, we have considered, my lord. Annexure C.
They have not registered FIR, my lord. Even that's
Yes,
not an endorsement.
ಇಂದು ದಿನಾಂಕ ಸೋ ಪ್ರಕಾರ ದಿನಾಂಕ 30/11/2020 ಟೈಪ್ ಮಾಡಿದ ರೂಪದ ಕೊಟ್ಟಿದ್ದ ಸಾರಾಂಶವೇನೆಂದರೆ ಒಂದು ಖಲೀಲ್ ಎಂಬುವನು ನನಗೆ ಫೋನ್ ಮಾಡಿ ಮಣಿಕಂಠ ರಾಠೋಡನಿಗೆ ಕೊಲೆ ಮಾಡಲು.
Why you not registered FIR?
It is registered. So after inquiry.
FIR not registered yet.
Why not 6B ಇದೆಯಲ್ರಿ? There is a threat. Why not 6 ಇದೆ?
Yes.
Why you not registered FIR?
So I'll get you whether their application were issued. Their application were issued. Yes. So far as taking action, whether the FIR is registered or that, I will get the instruction.
ನೀವು ಪೊಲೀಸ್ನವರು ಇನ್ನ ಯಾವ ಕಲಿಯೋದು ನೀವು?
I'll get the estimate, whether they have filed.
It's a cognizable offense, you have no other option. You have no other option, Mr. Cognizable offense report ಮಾಡಿದಾಗ. How can you do this? ಅಲ್ಲಿ ಅವರು ಇದ್ರಲ್ಲಿ ಸ್ಟ್ಯಾಟಿಸ್ಟಿಕ್ಸ್ ಇರುತ್ತೆ ಅವ್ರಲ್ಲಿ.
Yes.
ಅವ್ರು FIR ಜಾಸ್ತಿ ಮಾಡಕ್ಕೆ ಹೋಗಲ್ಲ, ಯಾಕಂದ್ರೆ ಜಾಸ್ತಿ ಮಾಡಿದ್ರೆ ಅದಕ್ಕೆ ಉತ್ತರ ಕೊಡ್ಬೇಕಲ್ಲ, ಏನ್ ಮಾಡಿದೆ FIR ಅಂತ. ಅದಕ್ಕೆ ಅದು ಬರೆಯೋದು ಸ್ಟ್ಯಾಟಿಸ್ಟಿಕ್ಸ್ ತೋರ್ಸಕ್ ಹೋಗಲ್ಲ.
I'll get the instruction.
AGS directed to accept notice for response 1 to 4. The AGS directed to keep the respondent number 4 present on the next date of hearing. List on ಯಾವತ್ತು ಬರಕ್ಕೆ ಹೇಳಿ ಅವ್ರಿಗೆ.
Please.
27? ಹಾ.
Please, my lord.
Siddhapurkar. Yes, why alternate?
Lord, marginal land was allotted to me.
Ah,
Subsequently, there was some dispute between the housing board and some other person. Ultimately, it reached this honorable court, and there was a direction to conduct a survey. After survey, my lord, it was found that that marginal land was not at all acquired by the housing board.
hmm.
Therefore, my lord, I filed an application to allot me an alternate site because I have paid around 12 lakhs. of
Marginal
rupees.
land alternate ಹೆಂಗ್ ಕೊಡಕ್ ಬರುತ್ತೆ?
Around 12 lakhs of rupees I have paid. Let
get
them
your
either
money back.
refund the money or
Refund the money we can understand, but you can't get back alternate site. ಏನೋ ಪಕ್ಕದಲ್ಲಿ ಸ್ವಲ್ಪ ಜಾಗ ಮಿಕ್ಕಿತ್ತು ಅದಕ್ಕೆ ನಿಮಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹೌದು.
Now, if you want your money back, we'll direct them to return the money. Yes, government.
I have filed a
Some
copy on it.
matters alternative side ಕೊಟ್ಟರ ಅದಕ್ಕೆ
In some other cases, my lord, alternate sites have been allotted.
Just ಅಂತ 8 guಂಟಾಸ್ land was 8 persons have been allotted. 8 guಂಟಾಸ್ land is excess ಅಂತ ಅಂತಾರೆ ಸರ್ವೇದಾಗ.
ಅದೇ ಮಾರ್ಜಿನಲ್ ಲ್ಯಾಂಡ್ ಅಂದ್ರೆ ಏನು? ಇವರ
That is
ಪಕ್ಕದಲ್ಲಿ ಸ್ವಲ್ಪ ಜಾಗ
yes, yes.
ಮಿಕ್ಕಿರೋದನ್ನ ಕೊಡೋದು. ಈಗ ಪಕ್ಕದಲ್ಲಿರೋ ಜಮೀನು ನೀವು ಅಕ್ವೈರ್ ಮಾಡಿಲ್ಲ ಅಂತ ಆಯ್ತು.
Long back only it was there and it was allotted by registered sale deed to him.
Correct.
ಆಮೇಲೆ ಅವ್ರು ನೋಡು ರೆಸ್ಪಾಂಡೆಂಟ್ ಅದು ಇಲ್ಲಿ ಸರ್ವೆ ಆಗಿತ್ತು ಇನ್ appeal in the survey department ಜಾಯಿಂಟ್ ಡೈರೆಕ್ಟರ್ ರಿಮೈಂಡೆಡ್ ಮ್ಯಾಟರ್ ದೆನ್ ದೇ ಅಗೇನ್ ಸರ್ವೆ ಮಾಡಿದ್ರೆ ಎಕ್ಸೆಸ್ ಅಂತ ಇಟ್ ಇಸ್ ನಾಟ್ ಅಕ್ವೈರ್ಡ್ ಅಂತ.
So if it is not acquired, you can't, where's the question of, this is not a marginal land at all.
ಈಸಿ ಇಂಟ್ರೆಸ್ಟೆಡ್
ದುಡ್ಡು ವಾಪಸ್ ಕೊಡಿ.
ಅದೇ ದುಡ್ಡು ವಾಪಸ್ ಕೊಡೋ ಬದಲು ಆಲ್ಟರ್ನೇಟಿವ್ ಕೇಳ್ತಾರ.
ಅಲ್ಲ ದುಡ್ಡು ವಾಪಸ್ ಕೊಡಿ ಬರ್ಕೊಳ್ಳಿ. AGS, sorry.
ಎಲ್ಲ ಅಲ್ಲಿ ಎನ್ಕ್ವೈರಿ
What's your name, Mr.?
Shivkumar Malipatil.
Mr. Shivkumar Malipatil is directed to accept notice for the respondents. List on yavat.
27, 28.
Pay the money back with interest.
Obliged.
Sachin Mahajan.
Two parallel proceedings were, my lord, initiated by the Waqf board. My lord, initially on 9/8/2018, proceedings under section 4(1) of the Karnataka Public Premises Act, my lord, was invoked. A batch of writ petitions were filed, my lord, before the principal bench, stating that, my lord, Public Premises Act cannot be invoked against, my lord, the tenants who are in possession on the basis of agreement. Then, my lord, that writ proceedings, my lord, came to be withdrawn on 4/1/2023. In the meanwhile, my lord, before these proceedings were withdrawn, on 4/1/2023, my lord, on 27/1/2022, much before that, my lord, another complaint, my lord, is entertained under, my lord, section 54. And section 54, my lord, it mandatorily requires that it's the proceedings should be preceded by a notice issued to, my lord, the tenant. Now, without issuing the notice, which is, my lord, mandatory under section 54, and during the pendency of the first, my lord, proceedings, the respondent, my lord, initiates
Waqf Act.
Section 54, my lord. Whenever the chief executive officer considers whether on receiving any complaint or on his own motion that there has been any encroachment on the land, building space or any property which is work property and which has been registered as such under the act, he shall cause to be served upon encroacher a notice specifying the particulars of the encroachment and calling upon him to show cause before a date to be specified in such notice as to why the order requiring him to remove from the encroachment before the date supposed to specified should not be made, and shall also send copy of such notice to the concerned Mutawalli. Now, my lord, when this notice is mandatory,
Encroachment ಹೆಂಗಾಗುತ್ತೆ ಇದು?
now, my lord, they have filed, my lord, the proceedings under 54, my lord, and without, my lord, my participation, that order is also passed, my lord. I'm challenging that, my lord, I'm before your lordship. That also includes, my lord, tenants whose tenancy period, my lord, has expired. But nevertheless, my lord, it was mandatory on their part, since they have invoked section 54. Notice was, my lord, mandatory. Complaint, my lord, under 54 is at annexure C. Page number 21, my lord.
Annexure?
Annexure C, my lord, page number 21. Dargah Hazrat Sayyid Shah Ahmad versus my lord Muhammad Hussain Ruknuddin. Complaint under section 54 of the Waqf Act 1995 with a prayer, my lord, to get the premises. Now, this was done when the earlier proceedings, my lord, under the Public Premises Act, my lord, was pending.
Yeah, but therefore, this is not a case under 54.
Lord,
Because
they have
say
specifically
not-
invoked 54, my lord, proceedings are conducted
have
under
invoked,
54.
sir. They might have invoked section 54. It is not 54. It doesn't say that you are an encroacher. How is the work property recovered?
My lord, it is under 54, my lord, the CEO has to take steps, my lord.
54 and it is not 54. You're not an encroacher.
My lord,
It says that you're a tenant.
I'm a tenant, my lord.
That is what they also say. So
Yes.
54 is not applicable. Which is what is applicable?
My lord, I make one submission, my lord, in this part.
Yes.
My lord, kindly see my definition of encroachment. My lord, definition of this is a 2013 amendment, my lord, as per the Waqf Act, my lord. Earlier, my lord, I initiated the proceedings under the KPP Act, my lord. After the expiry of the lease or license. After the amendment 2013, my lord, the Waqf Act 2013 amendment, my lord, the definition of the encroachers, section 2EE. The
ಹಂಗೆ ನೀವು ನೋಟಿಸ್ ಕೊಡ್ಬೇಕಲ್ಲ.
Yes, my Allah, my lord. Kindly see, my lord, there is a encroacher under the Waqf Act, my lord. Kindly see definition.
That is okay. Even if you assume that the petition is an encroacher.
My lord, encroacher means there is a including the definition. Kindly see section 2EE.
Yes, yes.
Means, my lord, any person or institution of public or private occupying the Waqf property in whole or part without any authority of law, including a person whose tenancy, lease or licensee was expired, has to be terminated by the Mutawalli or board.
So whether you have issued a notice before initiating proceedings and against him.
Verify. Because, my lord, now, my lord, question, my lord, and my learned friend has argued the matter. 54 proceeding is not maintainable, but the 54 proceeding is now maintainable after a 2013 amendment, my lord.
Then what is maintainable? How do you get back the possession?
My lord, now, my lord, I have initiated directly, my lord, I have initiated the proceeding under section 54. My lord, issuance of the notice does not arise, my lord, because after the expiry
Please
of
read
the
54. Read 54 now.
My lord, 54, my lord, the meaning of the definition, my lord, after expiry of the lease, my lord. Earlier, it is not their word.
Sir, why don't you read section 54?
But the recovery of the product, kindly see, my lord, removal of the encroachment of the Waqf. Whenever the chief executive officer considering whether or receiving any complaint on own motion, that there is an encroacher or land bleeding and space and other property, which is the property which has been registered as under the act, this act, he shall make served call upon the encroacher a notice specified in the particulars encroachment, calling upon to show cause before the date as specified in the such notice. My lord, after receiving of the complaint, my lord, section 54 proceedings was initiated.
Mr. Where is the notice is what I am asking you.
My lord, the notice before filing of the notice, my lord, does not arise, my lord, because is after the expiry of the lease, my lord, automatically, my lord, the occupation of the
Mr. P.S. Mali Patil is directed to accept notice for respondent number 1 and 2. Issue emergency notice to respondent number 3 and 4. 3 and 4 ನೀವೇ ತಗೋತೀರಾ ಮುತವಲ್ಲಿ ಸಾವ್ರು?
Mutawallis I am appearing.
3 and 4.
No, 2 melons. 3 and 4 they are the
of tenants, my lord, their notice. is not
Co-tenants, my lord,
necessary.
their presence may not be, they are mere formal parties, my lord.
Mr. Gopal Yadav
Please.
is that to accept notice for
Or-
undertakes to appear for respond number 2. Notice to R3 and R4 is dispensed as no relief is sought for against them. Next para. Since it is a case of the petitioner that the respondent number 1 has initiated proceedings under section 54 of the Waqf Act, and that the same is done without complying section 54(1), the proceedings before the respondent number 1 deserves to be stayed till the next date of hearing. Hence,
Meanwhile,
the
but
proceedings
maybe
before
given
the-
if notice was issued, I will file vacating.
ತಿಳ್ಕೊಂಡು ಹೇಳಿ, hence the proceedings before the respondent number 1
But final order is passed.
hearing number so and so is stayed till the next date of hearing.
Huh? No, final order is passed, my lord, which is now challenged.
Final order is passed.
Final order is passed.
ಇದಾಗೋಗಿದ್ಯಾ?
ಆಗಿದೆ.
My lord, once the final order is passed, my lord, there is a provision under the section 54(3), my lord, to file an application before the Waqf tribunal. Kindly see, my lord, section 54(3). The chief executor has to file an application before the Waqf tribunal for seeking of eviction order. And the order of the section 54(2), my lord, is not a speaking order.
54(3), he may make an application.
Yes, for seeking for eviction.
ಕರೆಕ್ಟ್ ಅಪ್ಪ. ಈ 54(3) ಆರ್ಡರ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಿದ್ರಲ್ಲ ಸಚಿನ್.
ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್ ಮಾಡಬೇಕು, ವಕ್ಫ್ ಬೋರ್ಡ್ ಆರ್ಡರ್ ಮಾಡಬೇಕು.
54 order is made, my
passed
lord.
by the tribunal.
Before the tribunal, my
Whether
lord.
an order under section 54(3) is passed or not.
No, no, my lord, not under 54.
Then let the proceedings be stayed.
Please.
Correct ಆಗಿ ಮಾಡಿ.
Please, I'm sorry, my lord.
Petitioner who is proposed
Director
to
of renewal of.
President of the Managing Committee of Waqf Dargah is before this court seeking writ of mandamus.
ಯಾರು?
Lord,
Mr. Naresh Kulkarni is directed to accept notice for response 1 and 2.
On submission, I am filing a including application for proposal.
ಮಾಡಿ. Naresh Kulkarni is directed to accept notice for response 1 and 2.
may I request a date could.
List on date. Is Siddharuda Pujari?
Please.
Is government?
Yes, ma'am. My lord,
AG is directed to accept notice for response 1 to 4.
yes.
Panchayat Raj Engineering Department ನೀವೇ ತಗೋತೀರಾ?
ಇಲ್ಲ ಮೇಡಮ್,
ಯಾರು?
ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಪ್ಯಾನಲ್
ಕಲಬುರ್ಗಿ. ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಕಲಬುರ್ಗಿ ಯಾರು? Krupasagar Patil is directed to accept notice for R5.
I am seeking interim order, man.
What interim order?
Withdrawal of the PDP certificate.
ಆಯ್ತು, interim order ಏನ್ ಕೊಡೋದು?
Based on that, my lord, my selection has been, appointment has been cancelled.
Your appointment has been?
Cancelled, my lord. Annexure R, my lord. Annexure R. I have served almost 11 years, my lord.
Till the next date of hearing, the impugned order is stayed. List on date.
Petition.
Ready?
Ready, man. The lordship has directed on 27/6/2024. The government has took a time to file a statement of objection.
Yes, government. 2016 petition ಇನ್ನ ಇಟ್ಕೊಂಡಿದೀವಲ್ರಿ.
Sorry, madam.
Huh?
My other colleague is looking after us today, he has not come. It may be taken next week, meanwhile I will file
But
objection.
who has to allot this CA site? ಯಾರು ಮಾಡ್ಬೇಕಾಗಿಲ್ಲ?
Shiv respondent.
So government ಬೇಕಾಗಿಲ್ಲ. Mr. Shivkumar Tengli. Objection file ಮಾಡಿದ್ರಲ್ಲ?
ಮಾಡಿಲ್ಲ.
ಹಾ.
It may be password, highly intimate.
Password. The BK Hiramat.
Correspondent.
Yes. Anyway, what does it, the electrical inspectorate say?
My lords, first you file, my lords, suit. Suit has been filed by the, my lords.
Electrical inspectorate ಏನಂತಾರೆ? What does the electrical inspectorate say about the death? How did the death happen?
During.
ಎಲ್ಲಿದೆ? Where is the report of the electrical inspectorate?
Kindly, my lords, which time may be granted, my lords?
ಹಿಂಗೆ ಹೋಗ್ತಾ ಇದೆ ಬಿರಾದರ್.
ಇಲ್ಲ, ನಾನು I seek
ಸುಮ್ನೆ ಹಿಂಗೆ.
instructions, my lords.
We are doing a disservice. 2001 suit.
ಹೌದು.
ಯಾವಾಗ ಸತ್ತೋಗಿರೋದು?
The date of death. my lords.
2000 ಸತ್ತೋಗಿರೋದು. 24 ವರ್ಷ ಆಗಿದೆ, ಇನ್ನ ಅವ್ರಿಗೆ ಏನು ಕೊಟ್ಟಿಲ್ಲ. ಕೊಡ್ಬೇಕೋ ಕೊಡಲ್ಲೋ ಗೊತ್ತಾಗ್ತಿಲ್ಲ ಅವ್ರಿಗೆ.
ಅಲ್ಲ, there is a ಇದರಲ್ಲಿ ಡಿಲೇ ಮೇಲೆ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
ಆಯ್ತು, ಬಟ್ 2000 ಅಲ್ಲಿ ಅವ್ರು ತೀರೋಗಿರೋದು.
ಅಲ್ಲ, the petition, the writ is filed in the year 2021.
That's okay. When, what is the nature, cause of death? Cause of death ಏನು? ಶಾರ್ಟ್ ಸರ್ಕ್ಯೂಟ್ ಆಗಿ ಕಿಡಿ ಬೀಳಲಿಕ್ಕೆ ಹತ್ತಿದ್ದು, ಇದರಿಂದ ಮೃತ ಶರಣಪ್ಪ ತಮ್ಮ ಬಾವಿಗೆ ಇದ್ದ ಚಾಲು ಮಾಡಿದ ಕರೆಂಟ್ ಮೋಟಾರ್ ಸುಡುತ್ತದೆ ಅಂತ ತಿಳಿದು ಮೋಟಾರ್ ಬಂದ್ ಮಾಡಲು ಸ್ಟಾರ್ಟರ್ ಬಟನ್ ಒತ್ತಿದಾಗ ಕರೆಂಟ್ ಶಾಕ್ ಕೊಡೋದು ಮೃತಾಗಿದ್ದು ಅದೇ. Yes, where is the report of the electrical inspectorate? The objection file ಮಾಡಿಲ್ಲ.
ಮಾಡ್ತೀನಿ ಸರ್.
ಪಾಸ್ವರ್ಡ್ ತರಿಸಿ, ಎಲೆಕ್ಟ್ರಿಕಲ್ ಇನ್ಸ್ಪೆಕ್ಟರೇಟ್ ತರಿಸಿ.
My lords.
Please,
ಅಲ್ಲ,
please.
one week time may be granted.
Oh, sorry. Yes,
ಅಲ್ಲ,
next.
I want, my lords,
I'll issue a non-bailable warrant if you don't get the document.
1 week time may be, finally, my lords. ನಾನು
Sorry,
ತರಿಸ್ತೀನಿ.
sorry.
Because I.
24 ವರ್ಷ ಆಗಿದೆ ಸತ್ತೋಗಿ, ಇನ್ನು ನೀವು
ಅಲ್ಲ.
1 week time ಅಂತ ಹೇಳಿದ್ರೆ.
ಅಲ್ಲ, finally, my lords.
Finally ಇಲ್ಲ, ಎಂತದೂ ಇಲ್ಲ.
Kindly, my lords.
I'll
because-
issue a non-bailable warrant to the concerned super SC.
ಅಲ್ಲ,
Either you get him, at least the electrical inspectorate report ಬೇಕು.
ಅಲ್ಲ, ತರಿಸ್ತೀನಿ ಸ್ವಾಮಿ, ಒಂದೇ ವಾರ.
ತರ್ಸೋದಲ್ಲ, ಇವಾಗ ತರ್ಸಿ ಫೋನ್ ಮಾಡಿ.
ಅಲ್ಲ,
ಎಲ್ಲಿರೋದು ಇದು? ಎಲ್ಲಿರೋದು ಇದು?
my lords, ಇದು ಇಂಡಿ ಸ್ವಾಮಿ. ಇಂಡಿ.
ತರ್ಸಿ, ಇಲ್ಲಾಂದ್ರೆ bailable.
ಅಲ್ಲ,
NBW.
ಒಂದೇ finally.
Sorry.
ಅಲ್ಲ, next week ಅಲ್ಲಿ ಇಟ್ಕೊಳ್ಳಿ.
Sorry, mister.
Finally, my lords.
Sorry.
Because
Next.
ಅವ್ರದ್ದು ಕಾಂಟ್ಯಾಕ್ಟ್ ನಂಬರ್ ಅದು ಏನಿಲ್ಲ ಸ್ವಾಮಿ.
I'm sorry. Yes,
That's
next.
reason. Weeks time, my lords.
ಇಂಥ ಕೇಸಸ್ ಅಲ್ಲಿ no sympathy.
ಒಂದೇ week.
ಇಂಥ ಕೇಸಸ್
Kindly, my lords. Humble submission.
2021
ಅಲ್ಲ.
ಒಂದೇ ವೀಕ್ ಅಂತ ನೀವು ತರ್ಸಿದ್ರೆ ಹೆಂಗ್ರಿ ಡಾಕ್ಯುಮೆಂಟ್ ನೀವು?
ಅಲ್ಲ, ಒಂದೇ week.
No.
Last, finally.
I'll issue a warrant, let him.
ಅಲ್ಲ.
Mahantesh Patil.
This is my lords, I don't have the contact number, my lords.
ಇಂಥ
That's reason.
ಕೇಸಸ್ ಅಲ್ಲೆಲ್ಲ ಡೋಂಟ್ ಆಸ್ಕ್.
ಅಲ್ಲ, ಒಂದ್ ವಾರ, next week ಅಲ್ಲಿ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ. Next week
Sorry.
ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೀವು ಏನ್ ಬೇಕು?
ಹೈಕೋರ್ಟ್ ಇದ್ದು ಉಪಯೋಗ ಇಲ್ಲ ಅಷ್ಟೇ.
ಅಲ್ಲ, ಒಂದೇ ವಾರ. Last.
Mahantesh Patil ಹೇಳ್ರಿ.
Kindly, my lords, next week.
No, sorry, mister.
In this matter, last to date of hearing, the other side submitted, they will provide the information. Therefore, on that ground, it is urgent.
What information?
Lord, I in fact inquired with the officer, my lord, for continuation of such. Lord, it is not available for them to, my lord, pass on to, my lord, petitioner hearing.
What will you do? How will you furnish the information?
Lord,
ನೀವು?
he has sought for the information of, my lord, the one, my lord, a large area that is of the vicinity of the Raichur. where my
What is the
lord,
information sought for?
my lord, kindly see the
Annexure
ಶಾಂತಿ ಲಾಡ್ಜ್
Mallards.
ರಾಯಚೂರು ನಗರದ
13.
ಶಾಂತಿ ಲಾಡ್ಜ್ ರಾಯಚೂರು ನಗರದ ಮೋಟಿವಾಡ ಏರಿಯಾದಲ್ಲಿ ಇದ್ದು ಈಗ ನಾನು ತಮ್ಮಲ್ಲಿ ಕೋರುವುದೇನೆಂದರೆ ಶಾಂತಿ ಲಾಡ್ಜಿಗೆ ಹೊಂದಿಕೊಂಡಂತೆ ಪೂರ್ವ ಪಶ್ಚಿಮ ಉತ್ತರ ದಕ್ಷಿಣ ಎಲ್ಲಾ ದಿಕ್ಕುಗಳಲ್ಲಿ ಬರುವಂತಹ ರಸ್ತೆ ಹಾಗೂ ಮೋರಿ ಚರಂಡಿ ಕಾಲುವೆ ಹಾಗೂ ರಾಜಕಾಲುವೆಗಳು ಹಾದು ಹೋಗುವ ಬಗ್ಗೆ ತಮ್ಮ ಕಾರ್ಯಾಲಯದಲ್ಲಿ ಇರುವಂತಹ ದಾಖಲೆಗಳನ್ನು 2 ಪ್ರತಿಗಳಲ್ಲಿ ದೃಢೀಕರಿಸಿ ನೀಡಬೇಕೆಂದು ಪ್ರಾರ್ಥನೆ.
sought for since 1956, my lord.
56 ಇಂದ ಕೊಡಕ್ ಬರಲ್ಲ.
ಹಾ, ಅದೇ ಸ್ವಾಮಿ, ಆ ತರ ಕೇಳ್ತಾ ಇದಾರೆ.
25 ವರ್ಷದಿಂದ ಕೊಡ್ಬೇಕಲ್ಲ.
Kindly see annexure C, my lord.
Hmm.
They are given a information, my lord, by saying that ನೀವು ಕೋರಿರುವ ಮಾಹಿತಿಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಶಾಂತಿ ಲಾಡ್ಜ್ ಮುಂದುಗಡೆ ಒಂದೇ ರಸ್ತೆ ಇದ್ದು ಸದರಿ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಅಧಿಕೃತ ದಾಖಲೆಗಳು ಕಾರ್ಯದಲ್ಲಿ ಲಭ್ಯ ಇರುವುದಿಲ್ಲ. ಇವರು 4 ಕಡೆ ರಸ್ತೆ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಅಲ್ಲಿ ಒಂದೇ ರೋಡ್ ಇದೆ. Document is not available. By considering this fact, my lord, appeal is closed, my lord. ಈಗ ಅಪೀಲ್ ರಿಓಪನ್ ಮಾಡೋದಕ್ಕೆ ಅವರು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡಿದ್ದಾರೆ, ದಟ್ ಇಸ್ ನಾಟ್ ಪರ್ಮಿಸಬಲ್ ಇನ್ ದಿ ಐ ಆಫ್ ಲಾ ಅಂತ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. That was challenged before this court. Kindly see annexure G, my lord, page number 23.
21.
ಉಲ್ಲೇಖಿತ ನಿಮ್ಮ ಪತ್ರವನ್ನು ರಾಜ್ಯ ಮಾಹಿತಿ ಆಯುಕ್ತರು ಆಹ್ವಾನಿಗಾಗಿ ಮಂಡಿಸಿ ದಿನಾಂಕ 24/4/2018 ಆದೇಶದ ಖಂಡಿಕೆ 6 ಮತ್ತು 7ರಂತೆ ಪ್ರಕರಣ ವಿಲೆ ಮಾಡಿರುವುದರಿಂದ ಉಲ್ಲೇಖಿತ ನಿಮ್ಮ ಕೋರಿಕೆಯನ್ನು ಪರಿಗಣಿಸಲು ಅವಶ್ಯಕತೆ ಇರುವುದಿಲ್ಲ ಎಂದು ನಿಮಗೆ.
Please point out under which provision of law are they required to maintain this information? Under what provision of law are they required to maintain this information?
Then, my lords, I will point out the law because they have submitted last 2 dates of hearing.
Now.
Hangidre I will get I will research and come within 2 days. There is a one act, my lords, which says they have to maintain some records.
Right, Maintenance of Public Records Act, no doubt. But is there any requirement in law that they should maintain the particulars of each and every property? East yadu, west yadu, north yadu, south yadu,
At least they have to provide the, my lords, information at least regarding the measurements of the roads situated within the city limits.
No, you are not asked for it. All that you asked is ಪೂರ್ವ ಪಶ್ಚಿಮ ಉತ್ತರ ದಕ್ಷಿಣ ಎಷ್ಟು ರಸ್ತೆ ಇದೆ, ಮೋರಿ ಇದೆ, ಅದಿದೆ ಇದಿದೆ ಅಂತ ಕೇಳಿದಿರ.
ಅಲ್ಲ, ಈಗ ಅವರು what they are now doing, every time, my lord, they will come and mark this place is needs for development of road. And every time they have go on extending, my lords. In some of the owners.
Are you the owner of this Veeragunda Shanti Lodge?
No, he is not the owner, my lords.
Then
he is an advocate.
Then why do you need this information?
My lords, what they are doing is the information why this all read is every time, my lords, now the under old Raichur city, under the guise of they are widening the road, they were come, my lords, and marking the buildings, and they will demolish directly even without issuing notices. And now we are not aware that, my lords, we have purchased the properties through the registered sale deeds from last 30 to 40 years we are
Where is
residing.
your sale deed?
I will produce because this is only they have last date of hearing what they have submitted it, we will provide the information.
Good. Learned counsel for the petitioner is directed to secure instructions as to under what provision of law are the is the respondent number 3 required to maintain the particulars of a property such as its boundaries, etc. Is list on yavat
Next week in
date put. Next, Nagaraj Naidu.
Now they are saying that in the year 2015 they have, my lords, proposed master plan. As per the master plan, they are demolishing it. In some of the owners, they have lost the entire property itself.
Master plan notify ಮಾಡ್ತಾರಲ್ವಾ?
Notify ಮಾಡಿದ್ದು, even they are not providing that copy. They are saying that there is a master plan, therefore we are writing the road. Every time, now also my client asserts that some of the portion of the building is marked now.
Master plan is a master.
Sought for in this application, my lord.
We are not such. The whole the issue is that not why this is needed is that is why they are directly coming and marking and demolishing.
The master plan is available. How do you say it's not available?
Alla, master plan proposed in the year 2015.
In
Even for implementing master plan, my lords, if I am the owner in a old area, I am having a registered sale deed from last 30 to 40 years. I am residing therein.
Sir, you are not the owner. You are an advocate who wants some information.
Well, that is true. But the whole the issue is that why this information needed is why we have filed the
Okay, we are
application.
not concerned about why you are why you need the information. Document maintain ಮಾಡುವಂತ ಜವಾಬ್ದಾರಿ ಅವ್ರಿಗಿದ್ರೆ you can ask for those documents. Just point out under what law they are required to maintain these documents. ಚೆಕ್ ಬಂದಿ ಎಲ್ಲಾನು
ಅಲ್ಲಿ ಇದರಲ್ಲಿ RTA ಆರ್ಡರ್ ಬರಿಬೇಕಾದ್ರೆ ಬರ್ದಿದ್ದಾರೆ. How to categorize all those things ಅಂತ ಹೇಳಿ.
ಇಲ್ಲಿ
That is why they have ordered for.
They have to assess a building. I can understand. Is there any requirement in law that they should maintain the boundaries of the properties, maintain a record regarding the the boundaries of the properties? You asked for the boundaries
of the road, my lord.
Boundaries of the lodge.
ಅಲ್ಲ ಲಾಡ್ಜ್ ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗಿರೋದು. ಲಾಡ್ಜ್ ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗಿ ಕ್ರಾಂತಿ ಲಾಡ್ಜ್ ಏರಿಯಾ ಮೋಚಿವಾಡ ಏರಿಯಾದಲ್ಲಿ ಇದ್ದು ಕ್ರಾಂತಿ ಲಾಡ್ಜ್ ಗೆ ಹೊಂದಿಕೊಂಡಂತೆ ಇಲ್ಲ ಅನೆಕ್ಷರ್ ಬಿ ಒಂದಿದೆ.
ಶಾಂತಿ ಲಾಡ್ಜ್
ಮೋಚಿವಾಡ ಏರಿಯಾದಲ್ಲಿರುವ ಶಾಂತಿ ಲಾಡ್ಜ್ ಹೊಂದಿಕೊಂಡಂತೆ ಎಲ್ಲಾ ದಿಕ್ಕುಗಳಲ್ಲಿ ನಾನು ಈಗ
ಹೊಂದಿಕೊಂಡಂತೆ ಅಂತ ಇರೋದು.
Page 15, my lord, page 15.
ಶಾಂತಿ ಲಾಡ್ಜ್ ಹೊಂದಿಕೊಂಡಂತೆ ಅಂತ ಇರೋದು.
ಹೊಂದಿಕೊಂಡಂತ ವರ್ಡಿಂಗ್ ಇದೆ ಸರ್. ಶಾಂತಿ ಲಾಡ್ಜ್ಗೆ
ರಸ್ತೆ ಅಂತ
ಪಶ್ಚಿಮ ಉತ್ತರ ದಕ್ಷಿಣ
ಹೊಂದಿಕೊಂಡ
ಶಾಂತಿ ಲಾಡ್ಜ್ ಬೌಂಡ್ರೀಸ್ ಐ ಕಾಂಟ್ ಆಸ್ಕ್ ಮೈ ಲಾರ್ಡ್ಸ್. ಶಾಂತಿ ಲಾಡ್ಜ್ ಬೌಂಡ್ರೀಸ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಐ ಕಾಂಟ್ ಆಸ್ಕ್ ಟು.
ಅದೇ ಕೇಳ್ರ ನೀವು ಪೇಜ್ 10 ಬನ್ನಿ ಅನಕ್ಷರ ಎ. ಶಾಂತಿ ಲಾಡ್ಜ್ಗೆ ಹೊಂದಿಕೊಂಡಂತೆ ಪೂರ್ವ ಪಶ್ಚಿಮ ಉತ್ತರ ದಕ್ಷಿಣ ಎಲ್ಲಾ ದಿಕ್ಕುಗಳಲ್ಲಿ ಬರುವಂತಹ ರಸ್ತೆ. ಶಾಂತಿ ಲಾಡ್ಜ್ಗೆ ನೀವು ಕೇಳಿರೋದು
ಅಲ್ಲ ಶಾಂತಿ ಲಾಡ್ಜ್ಗೆ ಬರುವಂತಹ ರಸ್ತೆ
ಹೊಂದಿಕೊಂಡು ಶಾಂತಿ ಲಾಡ್ಜ್ಗೆ ಹೊಂದಿಕೊಂಡಂತೆ ಪೂರ್ವ ಪಶ್ಚಿಮ ಉತ್ತರ ದಕ್ಷಿಣ ಎಲ್ಲಾ ದಿಕ್ಕುಗಳಲ್ಲಿ ಬರುವಂತಹ ರಸ್ತೆ ಹಾಗೂ ಮೋರಿ ಚರಂಡಿ ಕಾಲುವೆ ಹಾಗೂ ರಾಜ ಕಾಲುವೆಗಳು ಹಾದು ಹೋಗುವ ಬಗ್ಗೆ ಇರುವ ತಮ್ಮ ಕಾರ್ಯದ ಸೋನ್ಸ್. Please point out if there is any requirement in law that they should maintain particulars. List on date code. Nagaraj Naidu.
For the petitioner, my lord. This petition is the fair price of owner, my lord.
Please wait. Please wait. We are taking up serial number 32. Please wait. Yes, Mamdapur.
Yes, time for the respondent side. Only for limited relief, the petitioners are all dwellers of a notified slum area, my lords, in Vide. Now, my lords, the respondent authorities, without following the provisions of the Slum Clearance Act, they are trying to, my lords, evict and demolish the entire slum, which is impermissible.
Whether this is declared as a slum?
Yes, yes. I have
Really the notification?
Annexure B. Annexure A, B, and these identity cards, registration cards, they have been issued under the provisions of Lord's slum clearance.
Yes.
My lord,
That's the common.
2021 they have issued. There is no apprehension, sir.
ಅಲ್ಲ ಯಾವಾಗಾದ್ರೂ
There is no such action taken by the respondents, my lord.
Sorry, once you declare it as a slum,
Yes, my lord.
what is it you should do?
No, without following procedure, we cannot. Yes.
ಬರೀ ಫಾಲೋಯಿಂಗ್ ಪ್ರೊಸೀಜರ್ ಅಲ್ಲ, ಅವ್ರು ಬೇರೆ ಇನ್ನು ಮನೆ ಕಟ್ಕೊಡ್ಬೇಕು ನೀವು.
ಹೌದು my lord.
ಎಲ್ಲಿ ಮಾಡಿದೀರಾ? What have you done? You have to rehabilitate them.
Yes, my lord.
You have to clear the slum and rehabilitate them. ಎಲ್ಲಿ ಮಾಡಿದೀರಾ? What steps you have taken? Slum clearance.
Section 11.
ಸ್ಲಮ್ ಅಂದ್ರೆ ಸ್ಲಮ್ ಆಗೇ ಇರ್ಬೇಕಾ?
ಎಲ್ಲ
ಇದನ್ನೆಲ್ಲ ಸರ್ವೆ ಮಾಡಿಬಿಟ್ಟು ಕಂಡೀಷನ್ ಅವರಿಗೆ ಬೇಕಂದ್ರೆ ಮುಂದೆ ರೀಡೆವಲಪ್ಮೆಂಟ್ ಸೆಕ್ಷನ್ 14 ನೋಡಿ 14, 15.
Yes, we identify some
Yes.
land where these people can shift.
I will verify with authorities and I will submit one, because as on today 21, they have filed writ petition. There is no action taken by the
ನೀವು ಬರೀ ಮನೆ ಖಾಲಿ
ಎಲ್ಲ
ಮಾಡ್ಸೋದು.
rehabilitation ಏನ್ ಮಾಡಿದ್ದಾರೆ ಎಲ್ಲ.
ಒಂದ್ಸತಿ ನೀವು ಸ್ಲಮ್ ಅಂತ ಡಿಕ್ಲೇರ್ ಮಾಡಿದ್ಮೇಲೆ ಕಾನ್ಸಿಕ್ವೆನ್ಸಸ್
Yes,
ಅಂಡರ್ ದ ಆಕ್ಟ್ ಹ್ಯಾಸ್ ಟು ಫಾಲೋ. ವಾಟ್ ಹ್ಯಾವ್ ಯು ಡನ್? Learned AG seeks time to secure instructions as to the steps that the respondent should be taking after declaring the land in question as a slum. Yes, list on.
First week of February.
Yes. Proxy counsel, my lord, senior counsel not feeling well. 1 week time.
Slum Clearance Board.
You have a slum clearance board.
R3, my lord.
R3 in there.
Slum board.
Now, what do you want to do? R2 is the Commissioner Karnataka Slum Clearance Board. KT Bantnaur.
R3, my lord. Only.
KD Bantnaur.
Yes, my lord, senior.
Who is R3?
Commissioner Karnataka, R3 is executive engineer.
Executive
Karnataka.
engineer.
Same department.
What, keep him present on the next date of hearing.
Please, my lord, senior counsel is not feeling well.
Yaru?
Presented on.
Okay, my lord. Please.
The learned counsel for the respondent number 3 is directed to keep the respondent number 3 present before the next date of hearing. List on.
1 week, my lord.
Huh?
1 week.
List on date good. 27/1.
Please.
Please.
In the meanwhile, you also secure instructions.
Yes, ma'am.
Nagaraj Naidu. ನಾಗರಾಜ್ ನಾಯ್ಡು ಇವಾಗೆಲ್ಲ ಬಂದಿದ್ರಲ್ರಿ. ನಾಗರಾಜ್ ನಾಯ್ಡು, ಕ್ಯಾಲ್ವಿನ್ ಫೋರ್ಟಾಡೋನ.
I appear for the petitioner, my lord, in this matter.
ನಾಗರಾಜ್ ನಾಯ್ಡು.
Calvin Furtado.
ಇಲ್ಲಪ್ಪ ನಾಗರಾಜ್ ನಾಯ್ಡು ಯಾರು?
Okay.
There is no representation for the petitioner. List on date. Same order. Bapu Siddha.
I'm here for the petitioner notice. The petitioner challenged next re-notice. The order passed in the Lok Adalat notice. The page number 49 notice, Annex E. The contents of the petition in the notice, the petitioner and respondent are present. Advocate for the petitioner and advocate for the respondent present. This is the petition filed by the petitioner and recovery of arrears of maintenance The matter has been settled the mediation of conciliators. In view of the said settlement, and the respondent submitted that he has already paid up rupees 5 lakh to the petitioner number 1 towards her lifetime maintenance. Further, both the parties have also filed a copy of the Kulanama and Talaknama in view of the said settlement of the petitioner number 1. Filed memo dated the present petition is closed as fully satisfied. Accordingly, the present petition stands closed and as fully satisfied. This has been notified. Subsequently, I have filed the OS number, page number 55, Annexure F, for the declaration and injunction against the order dated 8/9/2016. For the given the Talaknama and Kulanama is not binding upon the petitioner, that is been decreed by the court below. The respondent has fraud and misrepresentation with the Kulanama and Talaknama on the dated 8/9/2016. It is very clearly speaks about the suit has been decreed. Page number 92.
Yes.
The suit of the decree is quashed. The plaintiff declared as the legally wedded wife of the dependent and her marriage with the dependent were still subsisting. Talaknama and Kulanama dated 8/9/2016 are invalid and not binding upon the plaintiff as they are taken the exercising the fraud and misrepresentation.
Yes.
This has been committed by the respondent.
Yes.
That even though one of the 5 lakhs is not been issued by the petitioner, that has been even though signature is not been taken signed by the petitioner.
You are not assisted by an advocate.
Yes,
You are assisted by an advocate.
yes.
Then,
But the signature is now taken the blank papers.
sir, don't say that in before the court. Signature was taken on blank paper and then assisted by an advocate. Nothing.
But the beyond the back the
ಅಲ್ರಿ ಕಾಂಪ್ರಮೈಸ್ ಆಗುವಾಗ ಅಡ್ವೊಕೇಟ್ ಕೇಳೋದಿಲ್ವಾ ಪಾರ್ಟಿ ಕರ್ಸಲ್ವಾ
beyond the back they are stating that the matter is settled in Lok Adalat.
How is
But
it possible?
that is that 8/9/2016 order has been subsequently challenged that Kulanama and Talaknama
It
is
is okay.
yes,
What about this 5 lakhs?
but the petitioner has not received till today. That is the amount.
Then why did you accept
But
it?
they are taken subsequently given that amount.
You are present there in the Lok Adalat or not?
Present subsequently given that amount, but even though not has given the amount.
You were present in the Lok Adalat?
Yes,
Your advocate was also
Yes.
present?
all these advocates are signatured in the
Then,
joint memo.
then how
But
does
the amount has been not received. That reason, subsequently, the respondent has not given the amount.
can't help it.
The one opportunity, even though the maintenance has been not
One opportunity, now you can go and file a claim your maintenance if you want.
the full and final settlement in respect of the petition number 1. The wife,
Petition
there is no source of income to the petition number 1.
That is your foolishness. You were foolish. Your advocate was there. You were there. Mediators asked you, "Enamma ದುಡ್ಡು ಬಂದಿದ್ಯಾ?" You said yes. Now you come to the court and say ದುಡ್ಡು ಬಂದಿಲ್ಲ ಅಂದ್ರೆ how is it acceptable?
Subsequently, I given that amount. But the
Has the civil court declared that you have not received the 5 lakh rupees compensation or the maintenance? Has the civil court declared it?
that has not been challenged.
Why did you not ask for declaration?
That reason that taken the
Why did you not ask for a declaration that you did not receive 5 lakh rupees?
the respondent has not creating the fraud and misrepresentation.
The petitioner has challenged a compromise that was reported before, at the Lok Adalat in criminal miss 117/2015. Next para. The petitioner number 1, being the wife of the respondent, had initiated proceedings under section 125 of the Code of Criminal Procedure, claiming maintenance for herself and for her children. Full stop. The said petition was contested by the respondent.
Only respect of petition number 1 has been stated.
Full stop. The dispute was referred to the Lok Adalat since the court felt that there were chances of settlement. The petitioner and the respondent were present before the mediators. who mediated the dispute. Petition number 1 and the respondent were present before the mediators who mediated the dispute. At the intervention of the mediators, the parties settled the dispute, in terms of which the respondent in terms of which the petitioner number 1 and the respondent acknowledged that the respondent had already paid a sum of ₹5 lakhs to the petitioner number 1 towards permanent alimony, towards her maintenance for her life. Full stop. The petitioner number 1 and the respondent also filed a kulanama and a talaknama. Full stop. The petitioner number 1, who was represented by advocate, was also present. Consequently, the proceedings was closed on 8/9/2016. Full stop. Later, the petition number 1 filed OS number 2/2017 for a declaration that the kulanama and the talaknama obtained by the respondent number 1, kulanama and the talaknama referred above were fraudulent. The said suit was decreed and the court declared the talaknama and the kulanama dated 8/9/2016 as invalid and not binding upon the plaintiff. Consequently, it declared the petitioner number 1 to be the legally wedded wife of the defendant and that her marriage with the defendant was still subsisting. The petitioner has now challenged the settlement arrived at before the Lok Adalat petition on the ground that the petitioner number 1 did not receive the said sum of ₹5 lakhs. Next paragraph. Notice of this petition was issued to the respondent, who though served with the notice has not appeared. Next paragraph. The learned counsel for the petitioner contends that the petitioner was cheated into believing that the proceedings would be closed. Petitioner number 1 was cheated by the respondent in as much as he did not pay the sum of ₹5 lakhs mentioned before the mediators. He also contends that the conduct of the respondent in obtaining a fraudulent kulanama and a talaknama was upheld by the civil court in OS number 2/2017. Therefore, he contends that the order passed by the Lok Adalat also deserves to be quashed. Next paragraph. The petitioner number 1 was assisted by an advocate. Full stop. The petitioner number 1 was present before the Lok Adalat along with her advocate. And it was in their presence that the mediators held that the parties had amicably resolved the dispute, in terms of which the petitioner number 1 acknowledged the receipt of a sum of ₹5 lakhs prior to the mediation itself. Therefore, the petitioner number 1 cannot now contend that she did not receive a sum of ₹1 lakh.
5 lakhs.
₹5 lakhs before the mediators, as the petitioner number 1 and the respondent had agreed that the said sum of ₹5 lakhs was paid prior to the dispute being settled before the mediation. In that way of the matter, the petitioner number 1 cannot now challenge the settlement arrived at before the Lok Adalat. If the petitioner is entitled to any petitioner or the petitioners, petition number 1 or the petitioners 2 and 3 are entitled to any maintenance in view of the judgment passed in OS number 2/17, they are entitled to pursue the remedy before the competent court in accordance with law. Sanjeev Kumar Patil, 36 Adjarna. 37, Gawali Deepak. ಹೇಳಿಪ್ಪ. ಮೈಕ್ ಯೂಸ್ ಮಾಡಿ.
ರಿಟ್ ಆಫ್ ಮ್ಯಾಂಡಮಸ್ ಇವನವ್ರು.
ಹಾ, ಫೈಲ್ ಓದಿದ್ದೀರಾ?
ಫೈಲ್
ಹೇಳಿ ಏನು ಕೇಸ್ ಏನು ಅಂತ ಹೇಳಿ.
Respondent number 2 is acquire land site number 1925 situated in Mailar village, Your Honor, Bidar district. This land survey number is allotted to petitioner. He was poor family of homeless dwelling. He was poor family, Your Honor. Petitioner. He was respondent number 3 is called as per the news notification of newspaper, Your Honor. Petitioner is applied for the site. Petitioner application was approved and allotted.
ವಾಸ ಮಾಡಿದ್ರ ನೀವು?
Yes.
ವಾಸ ಇಲ್ಲಿ ಮನೆ ಇಲ್ಲ ಅಲ್ಲ ಅಲ್ಲಿ?
ಅಲ್ಲಿ ಪ್ಲಾಟ್ ಅಲಾಟ್ ಆಗಿತ್ತು, Your Honor.
ಪ್ಲಾಟ್ ಅಲಾಟ್ ಆಯ್ತು.
ಅಲಾಟ್ ಆಗಿ
ವಾಸ ಎಲ್ಲಿದ್ರಿ? ವಾಸ
ಈಗ ಸದ್ಯಕ್ಕೆ ಗುಲ್ಬರ್ಗದಲ್ಲಿ ಇದ್ದಾರೆ. ಗುಲ್ಬರ್ಗದಲ್ಲಿ ಇದ್ದಾರೆ ಸರ್.
ಮನೆ ಇತ್ತು, ಸ್ವಂತ ಮನೆ ಇದೆಯಾ?
ಅಲ್ಲಿ ಪ್ಲಾಟ್ ಅಲಾಟ್ ಆಗೈತಿ, Your Honor.
ಬೇರೆ ಮನೆ ಇಲ್ವಾ ನಿಮ್ಗೆ?
ಇವಾಗ ಇಲ್ಲ, ಇವಾಗ ಅಲ್ಲಿ ಪ್ಲಾಟ್ ಅಲಾಟ್ ಆದ್ಮೇಲೆ ಅವ್ರು ಅಲ್ಲಿಂದ ಅಲ್ಲಿ ಸೈಟ್ ಇರ್ಲಿ ಅಂತ ಹೇಳಿ ಇಲ್ಲಿ ಬಂದರು, Your Honor. ಇಲ್ಲಿ ಅಲ್ಲಿ ಟ್ಯಾಕ್ಸ್ ಎಲ್ಲ ಕಟ್ತಿದ್ದಾರೆ.
ಅಲ್ಲಪ್ಪ, ನಿಮ್ಗೆ ಅಲಾಟ್ ಆಗಿರೋ ಸೈಟ್ ಅಲ್ಲಿ ಮನೆ ಕಟ್ಟಿಲ್ಲ?
ಮನೆ ಕಟ್ಟಿಲ್ಲ.
ಎಲ್ಲಿ ವಾಸ ಇದ್ದೀರಾ?
ಇವಾಗ ಗುಲ್ಬರ್ಗದಲ್ಲಿ ಇದ್ದೀವಿ.
ಅಲ್ಲಿ ಸ್ವಂತ ಮನೆನಾ ಬಾಡಿಗೆ ಮನೆನಾ?
ಇಲ್ಲಿ ಬಾಡಿಗೆ ಮನೆಯಲ್ಲಿ.
ಬಾಡಿಗೆ ಮನೆ ಎಲ್ಲಿ ಹೇಳಿದಿರ ಹಂಗಂತ?
ಸರ್,
ಎಲ್ಲಿ ಹೇಳಿದಿರ ಬಾಡಿಗೆ ಮನೇಲಿ ಇದೀನಿ ಅಂತ?
ಬಾಡಿಗೆ ಮನೆ ಅಂತ ಹೇಳಿದ್ರು. Tomorrow. Take it tomorrow.
Petition itself is not maintainable. Petition is not maintainable. In 2012, they issued a legal notice by admitting that some of the other persons are illegally encroached the property and charter. If it is a disputed question of facts, my lord.
The page number?
Page number 27, my lord. 12 ಅಲ್ಲಿ legal notice issue ಮಾಡಿ ಇವಾಗ they are seeking for mandamus. 2022 filed writ petition.
ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಬೇರೆಯವರು ಎನ್ಕ್ರೋಚ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ.
My lord, may I read, my lord? 27, page number 27, last para. Therefore, you are hereby requested on behalf of my client to instruct the engineer to your office to visit the CMC layout of land survey number 192 of village Mailur, and going through the said layout, point out the plot of my client, him bearing hearing number 1759, now against assigned with the CMC.
ನೋಡಿ ಹೇಳಿ ಏನಾಗಿದೆ ಸೈಟ್ ಅಂತ.
Allala, my lord, they are saying that as on today, this site is not transferred in the name of applicant. ಅದನ್ನು ಹೇಳ್ತಾರೆ. ಅವ್ರ ಇದೇನೋದಕ್ಕೆ ಇಲ್ಲಿ 1989 ಇಂದ 86 ಇಂದ till today ಅವ್ರು ಅಲ್ಲಿ ಹೋಗೇ ಇಲ್ಲ ಅಂತ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೋತಾರೆ. That is the case, my lord.
ನೀವೇನ್ ರಿಪ್ಲೈ ಯಾಕೆ ಇಶ್ಯೂ ಮಾಡಲ್ಲ ನೀವು? ಈ ನೋಟಿಸ್ಗಳಿಗೆ ರಿಪ್ಲೈ ಯಾಕೆ ಇಶ್ಯೂ ಮಾಡಲ್ಲ ನೀವು? Why you people don't issue notice to this replies? Replies to this notice? Commissioner notice ಕೊಟ್ಟರೆ ರಿಪ್ಲೈ ಮಾಡಬಾರ್ದು ಅಂತ ಇದೆಯಾ? Find out what is the status of this plot.
Please.
Barcode. The learned counsel for the respondent number 3 is directed to secure instructions about the status of plot number 1759. Now assigned with CC number 147-4-531/1. List on yavat?
Next week, any day.
List on phones. Don't come to the court without reading the file.
Yes, sir.
38 ಏನಾಯ್ತು? Nagarajan Naidu. There's no representation for the petitioner. List on. Mahesh Patil.
Petition, my lord, Manager JKL is involved, my lord. The matter, my lord, is the petitioner have got a sanctioned license of fair price shop, my lord.
Have we challenged?
The Manager J, Manager K and Manager L, my lord. Three order is challenged, my lord, in this writ petition. Manager J is the passed by the impugned order, my lord, respond number 2, Deputy Commissioner. The matter pertaining to, my lord, the petitioner have got a sanctioned fair price shop license, my lord. My lord, as per 2013 is given the license, my lord. Thereafter, my lord, one of the villager have given the complaint against me. Is not given proper food grains. That complaint is received the response number 3 and passed the order to suspend the license, my lord. That license is the suspend order challenge before the Deputy Commissioner is confirmed, and petitioner have prepared the appeal before the response number 1 authority, and the appeal is also dismissed, my lord. That's why writ petition is challenged, my lord. Only simple allegation, my lord. Is the
Simple allegation on
is
that?
page number 40, my lord, is the Manager K, page number 40 is the appeal prepared by the respondent number 1, my lord.
There is 7 allegations.
Where-
What is simple allegation ಅಂತ ಹೇಳ್ತಾರೆ?
ಅಂದ್ರೆ 1 kg 2 kg, my lord.
ಓದಿ ಏನ್ allegation ಇದು?
The complainant, my lord, is the Manager D, my lord, is page number 22 is the complainant. Even the one of the villager against me, my lord. Page number 22 as per Manager D. ವಿಷಯ ಔರಾದ್ ಬಿ ತಾಲೂಕಿನ ಚಟ್ನಾಳ್ ಗ್ರಾಮದ ಸರ್ಕಾರಿ ನ್ಯಾಯಬೆಲೆ ಅಂಗಡಿ ಸಂಖ್ಯೆ 1ರ ವರ್ತಕರಾದ ವೈಜಿನಾಥ್ ತಂದೆ ಹನುಮಂತ್ ಇವರು ಆಹಾರ ಧಾನ್ಯ ವಿತರಣೆ ಮಾಡುವಲ್ಲಿ ಅವ್ಯವಹಾರ ಮಾಡಿರೋ ಬಗ್ಗೆ ದೂರು. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಈ ಮೂಲಕ ತಮ್ಮಲ್ಲಿ ವಿನಂತಿಸಿಕೊಳ್ಳುವುದೇನೆಂದರೆ, ನಾನು ಗಂಗಶೆಟ್ಟಿ ತಂದೆ ಹನುಮಂತರಾವ್ ಮೂಲಿಗೆ ಚಟ್ನಾಳ್ ಔರಾದ್ ತಾಲೂಕ್ ಬೀದರ್ ನಿವಾಸಿಯಾಗಿದ್ದು, ತಾಲೂಕಿನ ಚಟ್ನಾಳ್ ಗ್ರಾಮದ ಸರ್ಕಾರಿ ನ್ಯಾಯಬೆಲೆ ಅಂಗಡಿ ಸಂಖ್ಯೆ 1 ವರ್ತಕರಾದ ಶ್ರೀ ವೈಜಿನಾಥ್ ತಂದೆ ಹನುಮಂತ್ ಇವರು ಆಹಾರ ಧಾನ್ಯ ವಿತರಣೆ ಮಾಡುವಲ್ಲಿ ಅವ್ಯವಹಾರ ಮಾಡುತ್ತಿರುವ ಅದರಂತೆ ಈ ಕೆಳಕಂಡ ಇರುತ್ತದೆ. ಏಪ್ರಿಲ್ ತಿಂಗಳ 2020ನೇ ಮಾಹದಲ್ಲಿ ಆಹಾರ ಧಾನ್ಯ ವಿತರಣೆ 5 kg ಮಾತ್ರ ಆಹಾರ ಧಾನ್ಯ ವಿತರಣೆ ಮಾಡಿರುತ್ತಾರೆ. ಮೇ ತಿಂಗಳಲ್ಲಿ 5 kg, ಜೂನ್ ತಿಂಗಳಲ್ಲಿ ಮಾಹದಲ್ಲಿ ಯಾವುದೇ ರೀತಿಯ ಆಹಾರ ಧಾನ್ಯ ವಿತರಣೆ ಮಾಡಿರುವುದಿಲ್ಲ. ಜುಲೈ ತಿಂಗಳ 2020 5 kg ಮಾತ್ರ ಆಹಾರ ಧಾನ್ಯ ಮಾಡಿರುತ್ತಾರೆ. ಈ ಮೇಲಿನಂತೆ ಸದರಿ ನ್ಯಾಯಬೆಲೆ ಅಂಗಡಿ ವರ್ತಕರು ಪಡಿತರ ಚೀಟಿದಾರರಿಗೆ ಸರಿಯಾದ ರೀತಿಯಲ್ಲಿ ಆಹಾರ ಧಾನ್ಯ ವಿತರಣೆ ಮಾಡದೆ ಸದರಿ ಆಹಾರ ಧಾನ್ಯಗಳು ಅಕ್ರಮವಾಗಿ ಮಾರಾಟ ಮಾಡಿಕೊಳ್ಳುತ್ತಿದ್ದಾರೆ. ಇದು ಮೊದಲು ಬಾರಿ ಅಲ್ಲ, ಸುಮಾರು ಸಲ ಇವರ ಇಂಥ ಅವ್ಯವಹಾರ ಮಾಡುತ್ತಾ ಹಲವಾರು ಬಾರಿ ಆಹಾರ ಧಾನ್ಯಗಳನ್ನು ಮಾರಾಟ ಮಾಡಿಕೊಂಡು ಪಡಿತರ ಚೀಟಿದಾರರಿಗೆ ಮೋಸ ಮಾಡುತ್ತಿದ್ದಾರೆ. ಇವರು ಸುಮಾರು 2.50 ಕ್ವಿಂಟಲ್ ಆಹಾರ ಧಾನ್ಯವನ್ನು ಅಕ್ರಮವಾಗಿ ಮಾರಾಟ ಮಾಡಿಕೊಂಡು ಪಡಿತರ ಚೀಟಿದಾರರು ಮೋಸ ಮಾಡಿರುತ್ತಾರೆ.
ಸಸ್ಪೆನ್ಷನ್ ಮಾತ್ರ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು.
ಸಸ್ಪೆಂಡ್ ಚಾಲೆಂಜ್ ಮಾಡಿ
ವಾಟ್ ಇಸ್ ರಾಂಗ್?
ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ದಟ್ಸ್ ವೈ ಫೈಲ್ ರಿಟ್ ಪಿಟಿಷನ್.
ನಿಮ್ಮ ಆಥರೈಸೇಷನ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿಲ್ಲ.
ಅಥರೈಸ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿಲ್ಲ ಸರ್.
ಸಸ್ಪೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. ಅಲಿಗೇಷನ್ ಇದೆ. ಏನ್ ಎನ್ಕ್ವೈರಿ ಮಾಡ್ತಾರೆ?
ಏನು ಮಾಡ್ತಾ ಇಲ್ಲ, ಹಂಗೆ ಪೆಂಡಿಂಗ್ ಇದೆ. ಈಗ ಬೇರೆಯವ್ರಿಗೆ ಯಾರಿಗೋ ಒಬ್ಬರಿಗೆ ತಾತ್ಕಾಲಿಕ
ಟು ಕನ್ಕ್ಲೂಡ್ ನೀವು ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ರಿ 2022ನೇ ಇಸ್ವಿಯಿಂದ ಹಂಗೆ ಉಳ್ಕೊಂಡಿದೆ.
there is no any entry
Hold.
more.
The petitioner has challenged the suspension of the authorization granted to him by the respondent number 3.
Yes, Manager B.
Which was confirmed by the respondent number 2.
Yes.
Petition ಹಾಕಿದಿರಾ?
sir. Manager K, my lord.
As well as the respondent number 1.
Manager K, my lord. Respond number 1.
Stop. Next para. The petitioner was sanctioned an authorization to run a fair price depot on 9/3/2013. A complaint was lodged by one of the ration card holders on 25/8/2019.
2020 lords.
25/8/2020.
Yes, ma'am. Manager D.
Accusing the petitioner of not distributing the food grains during April 2020, May 2020, June 2020, and July 2020. We'll stop. Following this, the respondent number 3 issued a notice dated 25/8/2020 and held proceedings and found that a case was made out for an inquiry against the petitioner Consequently, it suspended the authorization granted to the petitioner in terms of an order dated 28/8/2020. The said order was challenged by the petitioner before the respondent number 2, which too was dismissed on
18/8/2021.
18/8/2021. The petitioner then challenged the said order before the respondent number 1, who also dismissed it in terms of the order dated 16/6/2022.
Please.
Being agreed by the aforesaid orders, the petitioner is before this court. Next, the learned counsel for the petitioner contends that the allegations made against the petitioner are without any basis and are too insignificant for suspension of the license granted to the petitioner. He contends that the respondents have not initiated any action post the suspension of the license granted to the petitioner. He therefore submits that the impugned orders of suspension be set at naught and the license granted to the petitioner be restored. Full stop. The learned AG, on the other hand, contended that the complaint lodged by the cardholder set out 4 allegations against the petitioner, while the respondent number 2 has found out several allegations against the petitioner. He contends that he submits that not distributing the food grains as per the policy of the state government, should entail in suspension of the license. And the respondents have therefore, pending an inquiry, suspended the license granted to the petitioner. He submits that the allegations made against the petitioner has to be inquired into, and therefore there is no error in the orders passed by the respondents 1, 2, and 3 suspending the license of the petitioner. Next, I have considered the submissions made by the learned counsel for the petitioner and the learned AG. Next, the impugned order passed by the respondent number 3 shows that the same was in view of a complaint lodged by one of the card holders who accused the petitioner of not distributing the food grains during April, distributing the correct amount of food grains during April 2020, May 2020, and July 2020, and not distributing any food grains at all during June 2020. Full stop. The respondent number 3 has thereafter issued a notice to the petitioner before taking any steps, and after hearing the petitioner has found out that the allegations made against the petitioner warrant inquiry, and hence passed the impugned order dated 28/8/2020 suspending the license granted to the petitioner. The respondents 2 and 3 were also subjectively satisfied that the allegations made against the petitioner were prima facie true and warranted investigation, warranted an inquiry. Full stop. Having regard to the facts mentioned above, if the petitioner has failed in his duty to distribute the food grains as per the directions issued to him, he cannot escape from undergoing a scrutiny or an inquiry. And pending inquiry, the petitioner cannot be permitted to supply the food grains. And therefore, the respondents 1, 2, and 3 were justified in suspending the license granted to the petitioner. Hence, no interference is warranted with the said orders. The writ petition stands dismissed. Mohammed Fahmid Khan.
Yes, sir. I am for petitioner, my lord. My lord, I being agreed by the
हाँ,
order annexure R, authorizing the Karnataka Waqf Board and its officer to
annexure.
issue annexure R, Your Honor, page 60.
Hmm.
Authorizing the Karnataka Waqf Board, Bangalore, and its district work officer, authorizing them to issue the marriage certificates in respect of the Muslims married couples, was issued, Your Honor. Being agreed by that order, Your Honor, I have challenged annexure R before this honorable court, my lord. My lord, if Your Honor go through the section 32 of the Waqf Act, Your Honor.
Hmm. ಹಿಂಗೆ ವಕ್ಫ್ ಬೋರ್ಡ್ಗೆ ಹೆಂಗ್ ಪವರ್ ಎಸ್ ಪ್ಲೀಸ್
Powers and functions of the board, my lord. Nowhere in the powers and functions of the board.
Read. Please read.
D, to settle the schemes of management for a Waqf.
Yes, Mr. Who appears for the respondents? Waqf board here.
I am appearing for the board.
What is the power of the Waqf board?
Lord, it is
No, what is the power of the state government to authorize the Waqf board to issue marriage certificates?
because, my lord, there are instances wherein, my lord, these Kazis, my lord, were not performing their duties and there were so many allegations against them. Therefore, my lord,
Correct, that's okay. But what is the power of the Waqf board to issue marriage certificates? What is the power? And how can the government authorize the Waqf board to do this?
it is the government who has to answer, my lord, because.
Yes, government.
My lord. Yes, my lord. This matter come before principal bench, my lord. The honorable court directed the government to secure instruction regarding power. What is power issued by the government issued authorization to Waqf board.
ನಿಮ್ಗಿರೋದು ಬರೀ Waqf property ಮೇಲೆ ಮಾತ್ರ.
Yes, my lord. It is
How
marriage.
between two private individuals, ಮದುವೆ ಆಗೋದನ್ನ ನಿಮ್ಗೆ ಹೆಂಗ್ ಅಧಿಕಾರ ಇದೆ? ರಿಜಿಸ್ಟರ್ ಮಾಡೋದಕ್ಕೆ. How can you ask the Waqf board to keep it? Huh?
Yes, my lord, it is between private parties.
Two private individuals. ಮದುವೆ ನೀವ್ ಮಾಡ್ಸಲ್ಲ.
ಮಾಡ್ಸಲ್ಲ.
ಮಸೀದಿಲ್ ಮದುವೆ ಮಾಡಿಸ್ತಾರೆ. ಮಸೀದಿಲ್ ರಿಜಿಸ್ಟರ್ ಆಗುತ್ತೆ. So how can the government ask the Waqf board to do this? Huh?
That's why honorable court directed government advocate to secure instruction in principal bench.
ఏం principal bench?
Principal bench
At the
has
pending
already
court.
issued the interim order restraining the Waqf board and district officer from not issuing any marriage certificate as per the order annexure R, my lord.
Suppose this petition ಹೇಳಿ ಏನು ಅಂತ.
My lord, the honorable principal bench has observed at para number 4, my lord, of their interim order. The main plank of the submission on behalf of the petitioner is that the Waqf board and the officers have no powers in law to issue marriage certificate to the applicants of the community. It was submitted that as per the Karnataka Marriage Registration and Miscellaneous Provision Act 1976 and the rules framed thereunder, the powers to register a marriage are confirmed on the sub-registers of the Stamps and Registration Department under the Revenue Department. It was submitted that only Marriage Registration Act and the Special Marriage Registration Act deal with the marriage registration provision and confirm powers on the officers by virtue of which the marriage between the parties belonging to any community may be registered. And lastly, Your Honor, any para number 6, my lord, any time careful reading of the provisions of section 32 of the Waqf Act 1995 would go to show that it in no manner provided that the Waqf Board and its officer possess or could be said to be vested with the powers to issue the marriage certificate. Issuance of marriage certificate is neither a matter connected with the better administration of Waqf Act, nor it is a matter incidental to the administration and management of Waqf for which the Act is enacted, and the Waqf Board are constituted to function. Under the specious ground that the applicants of particular community are to be felicited with issuance of marriage certificate by the Waqf officer to help them out from the difficulties they face in various ways, is no ground whatsoever to justify the authorization of Waqf officer to issue marriage certificate, when the Waqf Act 1995 in none of its provisions could be read to have confirmed such powers. In view of the strong prima facie case, the impeachment order dated 30th/8/2023 authorizing the Waqf Board and its officer to issue the marriage certificate in the state shall remain in abeyance till the next date of hearing. And further, it was extended here, time to time. Under the Waqf Act, my lord, there is no provision to authorize the Waqf officer or Waqf Board to issue the marriage certificate. Under the Kazi Act and under the Karnataka Special Registration Act, Marriage Registration Act, the registrar and sub-registrars are the person to have the power.
No, but which is the law which permits registration of marriages amongst Muslims? Because special law only, special act only, there's a provision. Under the Hindu Marriage Act, there's a provision.
Yes, Your Honor.
For Muslims, how provision madadu?
But even for the Muslims, Your Honor, this act, the Karnataka Special Marriages Act, 1976, authorized, empowered the sub-registrar and registrar to register the marriages of Muslims couples.
The act, Karnataka Special Marriages Act.
Yes, Your Honor.
Pudri. It makes a sense because the Masjid al record ಮಾಡಿಟ್ರೆ suppose somebody wants to have access to the record, ಹೆಂಗ್ ಸಿಗುತ್ತೆ? ನನಗೇನೋ ಒಂದು extract ಬೇಕಪ್ಪ. I want an extract of a marriage. How will I get an extract? How will I get an extract?
My lord.
My lord, here.
At para number 4 of the judgment interim order, I would like to draw on attention. Para number 4 of the interim order of the principal bench, my lord. Para number 4. Learned advocate for the petitioner would rely on the decision of the Honorable Supreme Court in Srimati Seema versus Ashwani Kumar.
Karnataka marriages tegiri idu, Karnataka Act tegiri, Acts and Rules. Karnataka Marriages Registration and Miscellaneous Provisions Act 1976.
The Honorable Supreme Court has observed, accordingly, we are of the view that marriages of all persons who are citizens of India belonging to various religions should be made compulsorily registrable in their respective state where the marriage is solemnized.
Acts and Rules ilva? Karnataka Marriages Registration and Miscellaneous Provisions Act 1976. ಇದೆಯಾ ಮೇಡಮ್ ಅಲ್ಲಿ?
ಮಾಡ್ಬೇಕಂತ
1976.
ಮೇಂಟೈನ್ ಮಾಡ್ಬೇಕಂತ ಮಾಡ್ಯಾರ.
ಬುಕ್ ತರಕ್ಕೆ ಪ್ರಿಂಟ್ ಹಾಕ್ಬೇಡಿ, ಬುಕ್ ತರಕ್ಕೆ ಹೇಳಿ. ಇದೆ ಬಿಡಿ. Is there any prescription in the Sharia Act about registration marriages?
No, no,
Then ಎಲ್ಲಿ register ಮಾಡೋದಿಲ್ಲ.
Lord, there is no registration as such, my lord. Therefore, this order has been passed. Here, my lord, in order.
What about this Act of 1976? ನೋಡಿದಿರಾ?
Lord.
Have you seen this Act of 1976?
Yes, nodal of some, but there is a provision that registration of marriage, even Muslims can register the marriage. Before the registrar, Muslims can register the marriage under this act.
Under which act?
Under special marriage.
1976 Act.
Yes. But here, my lord, if lordship see the order, the direction was issued to the mosque, the concerned mosque of the area shall maintain, marriages should be done in the mosque and they should maintain a record, and that record should be submitted to the Waqf board. Waqf board in turn issues the registration. Waqf board is not performing any marriages here.
No, that is right, but when there is an act, it
is there, my lord, because
when there is an act, where is the question of?
They should not override the act. But your lordship.
So how can you ask the Waqf board to register marriages? There should be, ಇವಾಗ marriage register ಆಗಬೇಕು ಅಂದ್ರೆ, I'll just give you an example.
Yes.
You can't marry a minor.
Yes.
You can't marry a minor. Now, before the Waqf board, you go and register marriage with a minor. Can the Waqf board refuse to register? Can the Waqf board say she is a minor, I will not register?
Because they are bound by the law of the land so far as
So
marriages are
therefore,
concerned.
there should be a procedure for the Waqf board. There should be an act. There should be a legislation which authorizes the Waqf board to register a marriage.
What your lordship is pointing is, unless there is a law which permits them to register, they cannot govern by, because here there is no direct entitlement for them to.
And see, registering it before the mosque. Suppose if you want particulars of a particular person who is married, ನೀವು ಮಾಸ್ಕ್ಗೆ ಹೋದ್ರೆ they will say ಇಲ್ಲ ಕಳೆದೋಗಿದೆ, register ಇಲ್ಲ. Then how will you prove that point?
Because they have to immediately report to the Waqf board, and people can.
Waqf board power ಇಲ್ಲ. They don't have power under the act. Their ಇರೋ ಕೆಲಸನೇ ಅವ್ರು ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ. And you are giving them additional responsibility of registering a marriage. Please read all marriages in the state of Karnataka, including Muslims.
Yes, ma'am.
So therefore, this is a beneficial piece of legislation, alva.
Yes.
One last submission. Earlier, during the year 2009, the same order was passed by the respondent number 2, authorizing the Waqf board for the issuance of marriage certificate, which was challenged by the father of the petition number 1 before this honorable court, which was caused the order. I had directed the respondents to conduct inquiry regarding the issuance of marriage, whether the Kazis are empowered to issue the marriage certificate or the Waqf board. I made a representation as per annexure Q.
But Kazi Act repeal agidiyalla.
Kazi Act is repealed, but as per saving clause section 4 and 1 and 3, my lord, the persons who are functioning and discharging their duties as Kazis before the repealment of the Kazi Act, they are continued to be function as Kazis. As per saving clause 4, 1 and 3.
Kazi for performing marriage is fine.
Yes.
Kazi for performing marriage is fine. But what about registration of marriages? Can they register the marriage?
No, sir. The Kazis are not registering the marriages. They are performing the duties to perform the marriages of the Muslim couple. And also, as per the Hyderabad Atiyat Inquiries Act 1952 rules, Your Honor, the Kazis are the only person who is authorized under the Act to issue the marriage certificate. In turn, Your Honor, after the receipt of the marriage certificate issued by the Kazis and Nikanama and joint photos and affidavit of both the parties, the regional commissioner is authorized to attest it after verification and getting the report from the concerned office who have performed the marriages. He will attest that they are the persons as husband and wife and their marriage is valid. This is the procedure, Your Honor.
Yes. Put it that, put it 1976. Is there any reference to the Kazis Act?
No. There is no.
And this act has got overriding effect.
Lord,
So
since-
even if there's some provision made in the Kazis Act, that will override. That will be overridden by this act.
Lord, since the matter is pending before the principal bench, Lord.
So what? We can also decide. Principal bench, Gulbarga bench, all equal.
Equal.
Mata?
Not ground here.
Why do you say principal bench is superior?
No, not superior,
Then-
Lord, because matter is pending, therefore.
So we'll decide this case, let the principal bench follow it. Yes, Kazi Act ಬಗ್ಗೆ ಏನು ಹೇಳೋದಲ್ಲ ಸೇವಿಂಗ್ ಕ್ಲಾಸ್ ಏನು
Kazi Act, as per section 2, Your Honor, the
ಕೊಡಿ
government is.
ಇದೆಯಾ
Kazi Act.
ಕಾಜಿ ಆಕ್ಟ್
Page 24. Page 24. Even in my writ petition, I have enclosed the copy of the Kazi Act, my lord.
ಅಪೆಂಡಿಕ್ಸ್ ಸಿ ಅಂದ್ರೆ ಏನಿದು
Annex A, page 23, my lord, in my writ
ಪ್ಲೀಸ್
petition.
ವೆಯ್ಟ್ ಪ್ಲೀಸ್
Page 24.
ಪ್ಲೀಸ್ ವೆಯ್ಟ್ ಅಪೆಂಡಿಕ್ಸ್ ಸಿ ಯಾಕೆ ಬಂತಿದ್ದು ಕಾಜಿ ಆಕ್ಟ್
Kazi Act, Annex A, page 23 of my writ petition.
No, why this Kazi Act is mentioned in Appendix C? first schedule. ನಿರಸನಗೊಂಡಿರುವುದರಿಂದ ಬೀದರ್, ಗುಲ್ಬರ್ಗ, ರಾಯಚೂರು, ಯಾದಗಿರಿ, ಬಳ್ಳಾರಿ ಹಾಗೂ ಕೊಪ್ಪಳ ಜಿಲ್ಲೆಗಳಲ್ಲಿ ಕಾಜಿಗಳ ಹುದ್ದೆ ಜಾರಿಯಲ್ಲಿದ್ದುದರಿಂದ ಪರಿಣಾಮ ಬೀರುತ್ತದೆ. ಆದ್ದರಿಂದ ಈ ಭಾಗದ ಜನರು ಕರ್ನಾಟಕ ರಾಜ್ಯದ ಇತರೆ 24 ಜಿಲ್ಲೆಗಳಲ್ಲಿ ಅನುಸರಿಸುತ್ತಿರುವ ಪದ್ಧತಿಯನ್ನೇ ಅನುಸರಿಸಬೇಕಾಗುತ್ತದೆಂದು ಈ ಮೂಲಕ ತಿಳಿಸಲಾಗಿದೆ. ಅನ್ವಯವಾಗುತ್ತದೆ 6 ಜಿಲ್ಲೆಗಳ ಇಲಾಖೆ ಜಿಲ್ಲಾ ಮತ್ತು ತಾಲೂಕು ಮಟ್ಟದ ಜಲಸೆಗಳಲ್ಲಿ ಎಲ್ಲಾ ವಕ್ಫ್ ಸಂಸ್ಥೆಗಳಲ್ಲಿ ಪ್ರಕಟಿಸಲು ಹಾಗೂ ಆಯಾ ಜಿಲ್ಲಾಗಳ ವ್ಯಾಪಕ. So this notification dated 3/12/2013, it says that in other districts, whatever procedure that is followed, the same procedure has to be followed in respect of Bidar, Kalaburagi, Raichur and Yadgiri.
Thereafter, it was, again, the order was amended here.
ಏನಂತ ಮಾಡಿದ್ರು?
Next page, immediate after that.
ಕೆಲವು ನಿರ್ದೇಶನಗಳನ್ನು ನೀಡಲಾಗಿತ್ತು. ಈ ಸುತ್ತೋಲೆಯನ್ನು ಹಿಂಪಡೆಯಲಾಗಿದೆ. ಹಿಂಪಡೆಯಲು ಬಂದ ಮನವಿ ಆಧಾರದ ಕಾನೂನು ನ್ಯಾಯ ಮಾನವ ಹಕ್ಕುಗಳ ಇಲಾಖೆ ಅಭಿಪ್ರಾಯವಾಗಿ ಕರ್ನಾಟಕ ಜನರಲ್ ಕ್ಲಾಸಸ್ ಕಾಯ್ದೆ ಪ್ರಾದೇಶಿಕ ಜ್ಞಾನಗಳನ್ನು ಪ್ರಕಾರ ಕಾನೂನಿನ ಯಾವುದೇ ಸೂತ್ರವನ್ನು ಅಥವಾ ನಿಯಮವನ್ನು ಅಥವಾ ವಿಶ್ವಸ್ಥಾಪಿತವಾದ ಅಧಿಕಾರ ವ್ಯಾಪ್ತಿಯನ್ನು ರೂಢಿ ಅಥವಾ ಕಾರ್ಯ ಸ್ವರೂಪ ಅಥವಾ ಸರ್ವವನ್ನು ಅಥವಾ ಈಗ ಇರುವ ಪದ್ಧತಿ ಆಚರಣೆ ವಿಧ ಮೂಲಕ
Next, the ready, Malo. Page 28.
How does it help your case? Kazi Act is repealed. Kazi Act is repealed. Government said in respect of other districts, whatever procedure that is followed, the same procedure has to be followed here.
Thereafter, as per Annexure D, page 28, my lord.
In this book,
Read petition.
page 28.
Page 28, Annexure D, my lord. In partial modification of notification number dated 10/2/2010, withdrawing the earlier notification dated 5/3/76, extend the Kazi Act 1880 to the whole of state of Karnataka is modified as under.
For 5 districts.
The Kazi Act 1880 is applicable to the Hyderabad, Karnataka area, that is in the district of Bidar, Gulbarga, Yadgir, Bellary, Raichur and Koppal only.
Yes.
So my submission before this honorable court is that, Your Honor, as per the Repealing Act of 2013 and saving clause of section 4193, subsection 193, I am the person who is eligible to perform the duties of Kazi, which includes performance of marriage and even for issuance of marriage.
Yes.
So by annexure or Your Honor, it is causing difficulty to me for discharging my
Find out
duties. my lord.
what is the position of Kazis under the Kazi Act?
It is repealed.
Repeal adrunu, there's some corrigendum issued 2000 annexure D ನಲ್ಲಿ district ಗೆ apply ಆಗುತ್ತೆ ಅಂತ. Thereafter, there is one more circular. But annexure E ನಲ್ಲಿ there is one circular 2013 which says that the other districts ಅಲ್ಲಿ ಏನೇ follow ಮಾಡ್ತಿದ್ರು same procedure follow ಮಾಡಬೇಕು ಅಂತ.
Which was amended in Annexure F, my lord. Annexure E is amended and some changes are done as per Annexure F, my lord.
So how you do the marriage, we are not concerned. How the marriage is done, we are not concerned.
Yes.
Question is, where should it be registered? Whether it is a Kazi who has to register or under the 1976 Act.
Yes.
If it is under the 1976 Act, then what is the role of the Kazis? Whether they still function, they do not function. If they function, what is their powers in view of the 1976 Act?
My functions are to perform the marriages of the Muslim couples in accordance with the personal Shariat law.
Correct.
And on the basis of my documents, the sub-registrar and registrar to register the marriages of the Muslim couples under the 1976 Act, my lord. And they have to issue the marriage certificate to the couples of the Muslim.
Now, what I'm trying
not
to
the Waqf body.
what I'm trying to tell you is, Kazis, you can still perform the marriage.
Yes.
Kazis are the only persons who can perform the marriage, no
Yes,
dispute.
my lord. Yes.
Question is whether the Kazi can register the marriage in view of the 1976 Act, or it is the sub-registrar of marriages or the registrar of marriages who has to register it.
This is a sub-registrar of the registrar under the 76 Act has to register the marriages, not the Khazis. Khazis are only employed to perform the marriage.
Yes.
And the sub-registrar and
Now,
registrar.
suppose I'll give you an example. Please don't misunderstand me. Suppose if a Kazi performs a marriage and tomorrow it has to be registered under the 1976 Act. The boy says that I have not at all married her. Then it can't be registered under the Act.
No, sir. The marriage performed of the Khazi cannot become null and void.
ಅದಕ್ಕೆ ಕೇಳ್ತಿರೋದು whether the what is the force of the marriage certificate given by a Kazi?
It is having every force here, my lord.
ಇವಾಗ ಬೀದರಲ್ಲಿ ಒಬ್ಬ ಮದುವೆ ಆಗ್ತಾನೆ,
Yes.
ಗುಲ್ಬರ್ಗ ಅವ್ನು ಬರ್ತಾನೆ, ಇನ್ನೊಂದ್ ಕಡೆ ಮದುವೆ ಆಗ್ತಾನೆ. Then he will say, I have not at all married in
He
Bidar.
cannot say like this. His signature in presence of the witnesses and in presence of Wakil and in presence of the head of the family has to be obtained by the Khazi before the persons who gathered at the time of function of the marriage. He cannot deny it. His photo is affixed on the marriage, Siyanama. His signature is obtained 4-5 places. Witnesses has to be signed on the marriage certificate, Siyanamas. Wakil, that is advocate, has to be present. A person whose marriage is performed by the Qazi is not supposed to deny it, my lord.
In marriage certificate,
ಅಲ್ಲ ಅದೇ ನೋಡಿದೆ ನಾನು.
Government order dated.
The question is very simple here. Whether the Waqf board under the Waqf Act
That
1990.
that I am convinced.
Yes,
That I am convinced.
that is.
Question is, in 1976 Act ಇರೋದ್ರಿಂದ, what is the relevance of a marriage certificate given by a Kazi is what I am trying to know. ಈ Act ಇರೋದ್ರಿಂದ, see the Act says the moment a boy and a girl marries, they have to send a file an application before the concerned sub-registrar.
Yes, yes. madam.
Within 30 days, he can register it. If it is not registered, there's a procedure under section 6 after 30 days.
Yes.
So therefore, what is the significance of the marriage certificate given by a Kazi? Tomorrow they register under this Act. The boy or the girl will come with some of the certificate issued by some Kazi, saying that no, I'm already married to that girl. This certificate is bogus.
You
No?
cannot say
So
that.
therefore, I want to, before I decide the case, I want to know what is the significance of the certificate issued by a Kazi, particularly in the light of the Act of 1976. So whether only this Act will prevail or the certificate issued by the Kazi will prevail. That's ಸ್ವಲ್ಪ ನೋಡಿ ಹೇಳಿ.
We'll
I
file.
hope you understood, both of you
Yes, sir.
understood.
We also filed written objection because let there be objection from our side in this matter because
ನೀವು ಯಾರಿಗೆ?
So already they have
Board-
taken 2 years time.
Board.
but as well as government because
ನಿಮ್ದೇನಿದೆ?
this matter is
Already they have taken 2 years time here.
here, here.
Mister, you are not a Waqf so far as marriages are concerned.
Yes, yes, yes.
Waqf is for a different purpose.
Yes, yes.
ಮತ್ತೆ ಮದ್ವೆಗೆ ಎಲ್ಲಿಂದ ಬರ್ತೀರಾ ನೀವು? ಮದ್ವೆಗೆ ಹೆಂಗ್ ಬರ್ತೀರಾ?
Yes, madhvege baralla, but in the garb of this writ petition, Kazis want to regularize themselves. What they're trying to-
ಪ್ರಾಪರ್ಟೀಸ್ ಬಂದೇ ಇಷ್ಟು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದೀರಾ. ಇನ್ ಮದ್ವೆಸ್ ಬಂದೆ ಇನ್ನೇನೇನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಿರೋ ನೀವು? How much of confusion we will create?
Like, yes, the intention of petitioner is my lord to regularize themselves in the garb of this.
No, let there be.
Because as the lordship has pointed out, they say they are also not having any authorization to register or what is the validity of their marriage performed by them. Because so far as this impugned order is concerned, my lord, here also mosques have been given authority to perform the marriages. They are also standing on the same footings because there is no legal sanctity or authority to them which override this.
ಇದು ಸ್ವಲ್ಪ ನೋಡಿ ಹೇಳಿ ಇದನ್ನ.
Yes, my lord.
The AGA is directed to secure information about the status of Kazis in the Hyderabad, Karnataka area in view of the repeal of the Kazi Act 1880. We should also secure information about the status of the marriage certificates that are issued by Kazis post the repeal of the Act of 1880. Full stop. The learned counsel for the petitioner is directed to research on the question, research on the issue regarding the primacy of the 1976 Act, 1976 Act over the powers of the Kazis to issue marriage certificates. More question. Huh? Whether the Act overrides the Kazi's power to issue marriage certificates. Whether the Act of 1976 overrides the power of the Kazis to issue marriage certificates. ಅದ್ರ ಬಗ್ಗೆ ಸ್ವಲ್ಪ ನೋಡಿ ಹೇಳಿ. ಯಾವಾಗ ಹೇಳ್ತೀರಾ?
1 week.
ಲಿಸ್ಟ್ ಆನ್ ಡೇಟ್ ಕೊಡಿ. ಇದ್ರ ಮೇಲೆ once ಇದು ಬರ್ಕೊಳ್ಳಿ. The learned counsel for the petitioner has furnished a copy of the order dated 7/1/2015, 25, passed by the division bench of this court in WP number 19284 of 2024. The same is taken on record. This is before the division bench.
Division bench, my lord.
Division bench.
My
PIL.
first week of February.
March.
My lord, one submission.
I told.
Lord,
My lord, serial
instead of 27, my lord, let it be in first week of the March.
3/2, na?
Yes.
Third. ಯಾವತ್ ಬೇಕು ಹೇಳಿ, you decide.
March.
Third February.
March.
February.
Yes, Gaurish.
45, my lord. I am appearing for respondent. I inform to the other side, my lord. I want to file an objection in this case.
Learned counsel for the respondent number 6.
Interim order is there, my. Interim order.
List on so and so interim order granted under this section till the next.
45.
Serial number 47.
Ah,
4th February.
Other side also inform me.
you are for
ಅಷ್ಟೇ.
Respondent.
Mahantesh Patil. Fair Price Depot.
We can act.
Huh?
We can act. Petitioner.
Learned counsel for the respondent number 5, 6 time list on.
My lord, serial number 62, my lord.
Interim order. Whether? 47 interim order is in order. You extend till the next date.
With your lordship's view, item number 55, Mr. Vasad is here for petitioner. I am for respond number 5. I seek one stamp to file the objection statement.
Learned counsel for the respondent number 5, 6 time list on yavat beku.
1 week's time to file the objection statement.
ಯಾವತ್ತು?
55.
ಡೇಟ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ 27th
Yes.
January. Next Monday.
My lord, serial number 62, my lord, I'm sorry.
Yes.
I'm for the petitioner, my lord. 1 week time may be granted, my lord. I am not able to appear in person, so kindly,
Learned counsel for the petition 6 time list on so on.
my lord, there is an interim order extension.
55.
Sir, the interim order is there, serial number 62.
55.
Hello?
ನನ್ನ ಹತ್ರ ಇಲ್ಲ.
Sir.
ನಾವು ಸ್ವಲ್ಪ ಲೇಟ್ ಆಗಿ ಬಂದೀನಿ ಅವ್ರು ಎಲ್ಲ ನೋಡ್ಕೊಂಡು.
Court officer. Court officer, sir. Court officer, sir. Sir. Court officer, sir. Sir.
ಬರ್ಲಿ ಸರ್ ಮಾತಾಡ್ತೀನಿ.
Court officer, sir. Hello. Hello. Sir.
ಸರ್ 1 ನಿಮಿಷ ನಿಂದ್ರಿ. 1 ನಿಮಿಷ ನಿಂದ್ರಿ ಸರ್.
Sorry.
ವೇಟ್ ಮಾಡ್ರಿ, ಇಲ್ಲಿ ವಕೀಲ ಮಾತಾಡ್ತಾ ಇಲ್ಲ. 45 ಅಲ್ರಿ ಇವ್ರದ್ದು? ಫ್ಲಾಶ್ ಅಲ್ಲ ಸರ್. ಸರ್ 45 ಎಂಟ್ರಿ ಮಾಡಿ. ಇಲ್ಲ ಚಾಲೋ ಸರ್. ಮಾಡಿ ಬರ್ತೀವಿ ನಾವು. ಆಮೇಲೆ ಬರ್ರಿ 2:30 ಬರ್ರಿ. 44 ಇದೆ, ಏನೂ ಆಗಿಲ್ಲ. ಏನೂ ಆಗಿಲ್ರಿ, ಹಾ ಇದೆಯಲ್ಲ ಸಾರಿ 46 ಆಗಿದೆ. ಸರ್ ನಮಸ್ತೆ. ನಮಸ್ತೆ ಸರ್. ಬೇಟ
ये तो है कल लगा केस है.
45 ಅಂತ ಕೊಡ್ಬೇಕು, 47 ಅಂತ ಕೊಡ್ಬೇಕು.
Sir.
That tribunal. WP 201687 कल लगा है.
कल है मैटर.
थोड़ा कॉपी दे दें.
नंबर दे,
ये
फोन नंबर दे.
यहाँ पर ही बैठा हूँ 2 घंटे जो भी चार्जेस होगा मैं दे दे.
क्या फोन नंबर दे.
इधर ही बैठ.
Court officer, sir. Sir, ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
ಕೇಳಿಸ್ತಾರೆ ಹೇಳ್ರಿ ಸರ್.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 62
ಹಾ
ಸಾಹೇಬ್ರು ಇಂಟರ್ಮೋಡ್ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿದ್ದಾರೆ, ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಡೇಟ್ ಏನು ಅಂತ ಹೇಳಿ ಸರ್.
27 ಅಂತ ಹೇಳಿದೇವಲ್ಲ, ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಬರುತ್ತೆ ಅದು.
27 ಸರ್ ಇಂಟ್ರಿಮೋಡ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ.
ಆಗಿದೆ ಆಗಿದೆ.
ಓ ಒಬ್ಲೈಟ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಹೇಳಿ ಇವ್ರೆ.
ಸರ್ ಸಾರಿ ನೀವು ಸರ್ ಎಷ್ಟನೇ ಮ್ಯಾಟರ್ ನಿಂತಿದೆ ಸರ್, ಸ್ವಲ್ಪ ಹೇಳಕ್ಕಾಗತ್ತಾ?
43 ಮುಗಿತು.
ಥ್ಯಾಂಕ್ ಯು.
ಮಾಡ್ತೀನಿ.
Bajirao Nazare,
My lord, I appear for the petitioner, my lord.
ಇದನ್ನ awaiting ಅಂತಿದೆ.
ಹೌದು ಸಮಯ ನೋಟಿಸ್ ಜಾರಿ ಆಗಿಲ್ಲ.
For the statement.
Yes. Respond number 2. Chandra Maulishwar Reddy. Yes, government,
Please, my lord.
you are directed to serve the notice.
Yes, my lord, it will be served, my lord. A date may kindly be fixed. Will ensure that it is served, my lord.
List after.
My lord, interim order, my lord.
List after service of notice to the respondent number 2. Interim order granted earlier is extended to the next date of hearing.
Please, my lord.
Grateful.
Twenty. VK Naik. ಬೆಳಿಗ್ಗೆ ಬರಲಿಲ್ಲ.
My lord,
ಹಾ,
in this matter, Shivkumar Tangli requested time for filing objections. my lord.
2016 writ petition ಇನ್ನ
ಎಲ್ಲ papers ready ಇದಾವಂತ ಒಂದು week time ಕೊಟ್ರೆ you will file objections.
Learned counsel for the respondent number 2 seeks time as a last chance list on date.
Yes.
My lords, papers not found, my lords, because actually the papers is in Indi, but my lords, he was wrong made party KPT cell, that is come under my lords KEB. ಅದಕ್ಕೆ 1 week time ಕೊಟ್ರೆ ನಾನು ಅದಕ್ಕೆ ಇದು ಮಾಡ್ಕೊಂತೀನಿ ಸುಮ್ಮನೆ. And ಅವೆಲ್ಲ ಪೇಪರ್ಸ್ ಹುಡುಕ್ತಾ ಇದ್ದಾರೆ, ಸಿಕ್ಕಿಲ್ಲ, ಬೆಳಗ್ಗೆಯಿಂದ ಹುಡುಕ್ತಾ ಇದ್ದಾರೆ.
The learned counsel for the response 1 and 2 seeks time. In view of the relief sought for in the writ petition, the request for adjournment is not justified. Nonetheless, as a last chance list on
Any date, next week, my lords.
27.
27.
Kadaganchi.
No, I appear for the respondent, my lord. May I offer a judgment, my lord?
Sorry, yeah.
My lord, 30 days. The sole ground on which the present writ petition is filed, my lord, is with respect to the second part of the rule 3(1), with respect to.
It is held to be directory.
It is held to be a directory and also held that, my lord, mere irregularity, if there is no, my lord, prejudice cost, it cannot be, my lord, that 30 days period. Kindly see, my lord, para 7. The head note is also, my lord, explanatory. But para 7 may I read, my lord. While deciding whether the provision is mandatory or directory in nature, the courts have evolved different tests for application. One of the tests is whether the provision itself stipulates the consequences of the violation thereof. Although even that test has not been treated to be conclusive. In other words, even where provision does not provide for consequence of its violation, same came to be mandatory in character. The legal position regarding the approach to be adopted by the courts in regarding so and so, finding out whether they are mandatory or directory has been summed up by the Supreme Court in Sharif Uddin versus Abdul Ghani loan versus following. The difference between mandatory rule and a directory rule is that while the former must be strictly observed, in the case of the latter, substantial compliance may be sufficient to achieve the object regarding which the rule is enacted. Certain broad proposition which can be deducted from several decisions of the courts regarding the rules of construction that should be followed in determining whether a provision of law is directory or mandatory may be summarized thus. The fact that the statute uses the word shall while laying down a duty is not conclusive on the question whether it is mandatory or directory provision. In order to find out the true character of the legislation, the court has to ascertain the object which is the provision of law in question is to subserve and its design and the context in which it is enacted. If the object of law is to be defeated by non-compliance with it,
it has to be regarded as mandatory. But when provision of law relates to a performance of a public duty and the invalidation of any act done in this regard of that provision causes serious prejudice to those for whose benefit it is enacted, and at the same time who have no control over the performance of the duty, such provision should be treated as directory one. Where, however, a provision of law prescribes that a certain act has to be done in a particular manner by a person in order to acquire right, it is coupled with another provision which confers immunity on the other. When such act is done in that manner, the former has to be regarded as a mandatory one. A procedural rule ordinarily should not be construed as mandatory if the defect in the act done in pursuance of which can be cured by permitting appropriate
Can you please have a
rectification.
look at this, Venkatesh?
My lord.
ಇದೊಂದು ಸ್ವಲ್ಪ ಅನ್ಸುತ್ತೆ ನೋಡ್ಬಿಡಿ ರೆಡ್ ಲೈನ್ ಮಾರ್ಕ್ ಮಾಡಿ Just have a look.
This is, my lord, I have gone through, my lord. Just have
ಓದಿ ಫುಲ್ ಓದಿ
the 16th paragraph enter section.
ಮಾರ್ಕ್ ಮಾಡೋದು.
Please. First proviso to section 49 is breathing time to given to the assistant commissioner to set the ball in motion. He need not wait for expiry of 10 days before initiating action. Since the assistant commissioner is under mandate to conclude the process within 30 days, Rule 3.2 of the Rules 1994 is designed to provide adequate discretion to the assistant commissioner to steer the process so that it does not spill over 30 days mandate. If the argument of the learned counsel for the appellant is accepted, then it may at times overspill the 30 days mandate, in which event the no confidence motion would be rendered invalid. In the situation, by virtue of third proviso to section 49, the consequence could be disastrous in as much as members may or may not be exposed to the risk of being disabled to move another motion for confidence within the 6 months. This is with respect, the contest is with respect to, my lord, the earlier provision where 10 days, where allegation is there.
You're missing the point. 30 days ಫಿಕ್ಸ್ ಮಾಡಿದ್ಯಲ್ಲ.
My lord, I have
Consequence of not holding the meeting.
Yes, my lord.
30 days.
Yes.
This coordinate bench of this court said there is no consequence.
Yes.
Have a look at.
This is exactly where 30 days, above 30 days, 3 days delay was there. 33rd days meeting was fixed. Court, my lord, has held that that it is not the second para 9, my lord, sorry. This very seventh paragraph continuation next page alli 9 anta ಇದೆ ನೋಡಿ, para 9. Again, the backdrop, if we examine Rule 3 insofar as it directs the meeting should be held not later than 30 days from the date of motion is made, the only object which is sought to be achieved by the provision is to ensure that motion of no confidence do not remain unattended. All that meant to be achieved is that the authority concerned expeditiously arranges to have the motion put to vote after due notice to the member. It ensures that moving of the motion get the earliest possible opportunity to put the test in the move. Yes. That being so, the requirement of holding a meeting within 30 days cannot be said to be mandatory, not only because the consequence of failure to abide by the requirement are not stipulated, but also because the rule does not suggest that a motion duly moved by 2/3 of the members of the Panchayat would lose its efficiency if for one reason or the other a meeting is not convened within 30 days. The purpose underlying the provision is also no way affected or defeated in the meeting if the conducted within the reasonable period by the authority concerned, no matter beyond the period of 30 days. This is what, my lord, what they say is, in this matter, which your lordship, my lord, this is with respect to the 10 days period where it was there. But what?
On the sidelines of the 10 days, there's a reference.
The sideline of 10 days with respect to 30 days, the reference is because, my lord, those 10 days will have to be are very crucial where their earlier allegation had to be, my lord, tested and all those things. Now that since that is omitted, now tomorrow it's a democratic process, my lord. And the only, even otherwise, my lord, there are two limbs of my submission. One is, my lord, this 30 days, I rely on this judgment, my lord, which categorically on the very point of 30 days, the entire case revolves around 3 days delay, 33rd day. which this court has allowed it, my lord, saying that it is not, which I have read it out para number 9 also. And the second is, my lord, while the 30 days on 21st, my lord, of December, on Saturday, the requisition was made.
Yes.
The next day following is Sunday, my lord. And then, my lord, if it had to be calculated, it's just a proposition, my lord, which I am trying to, apart from the strong proposition that it is covered by this judgment, which is squarely covered by this judgment, is my submission, one.
Yes.
The second is, my lord, that since while calculating these 30 days period, as my lord is held with respect to this 15 clear days notice, the date of notice and the date of meeting will have to be excluded. Even in that case also, my lord, this will fall within the 30 days.
Come on, 21st, Allah.
Yes, my lord.
What is the date of notice?
Date of
Representation.
representation is 21/12/2024.
Yavaga. When is
Meeting is on 21/1/2025.
ಎಷ್ಟಾಗುತ್ತದೆ?
Which is within 30 days. 30th day falls on 21. If those 2 days are excluded, it would be on 29th day. Even including the general holidays and public holidays.
No question of general or public holiday.
No, I am just, my lord. If the proposition are, when, my lord, your lordship are aware, my lord, 15 clear days notice iddaga, the day of notice and the day of meeting shall be excluded. If those two, if the very same analogy is applied here also, then, my lord, the date of notice and the date of meeting is excluded, then I fall on the 29th day.
Yes. Inge 29th, December is 31 days.
31 days. So 21st of the December,
Yes.
my lord, May. 21st of December, if that is excluded, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12.
10 days, ಆಯ್ತಲ್ಲ.
10 plus 20.
10 days, yes, 20 days.
30 days.
30th day I am there.
So 30th day ಆಗೋಗಿದೆ. 30th
ಇಲ್ಲ
day
ಆಗಿಲ್ಲ, ಅವತ್ತಿನ ದಿವಸ ಆಗುತ್ತೆ.
ಯಾವತ್ತು?
21st ಗೆ.
ಹೆಂಗಾಗುತ್ತೆ?
Yes,
ಲೆಕ್ಕ ಮಾಡಿ.
That day have to be excluded ಅಂತ ಇದೆ.
21st exclude ಮಾಡಿ.
21st and both 21st are excluded. 2 days are excluded.
Okay, 2 days. 21st exclude ಮಾಡಿ. 22nd count ಮಾಡಿ.
22nd.
22nd, 23rd, 24, 25, 26, 27, 28, 29, 30 ಎಷ್ಟಾಯ್ತು?
10 days.
31 ಎಷ್ಟಾಯ್ತು?
Not the
ಎಷ್ಟಾಯ್ತು ಅಂತ ಹೇಳಿ? 10 days ಆಯ್ತು ಡಿಸೆಂಬರ್ ಅಲ್ಲಿ.
31st December.
ಹಾ? ಡಿಸೆಂಬರ್ 10 days ಆಯ್ತು.
December 10 days ಆಯ್ತು. ಇದು
January
21st day ಇದೆ.
ಎಷ್ಟಾಯ್ತು?
31 day.
ಎಷ್ಟಾಯ್ತಲ್ಲಿ?
31 days.
ಒನ್ ಡೇ ಡಿಲೇ.
ಅಲ್ಲ, ಎರಡು ಹಿಡ್ಕೊಂಡ್ರೆ ಹೇಳ್ತಾ ಇದ್ವಿ.
ಹಿಡ್ಕೊಂಡ್ರೆ ಹಿಂಗ ಹಿಡ್ಕೊಳಕ್ ಆಗಲ್ಲ.
ಅಲ್ಲ,
ಲಾಸ್ಟ್ ಮೀಟಿಂಗ್ ಡೇಟ್ ನೀವು ಹಿಡ್ಕೊಳಕ್ ಆಗಲ್ಲ.
ಅಲ್ಲ, ದಿ ಪ್ರಪೋಸಿಷನ್ ದಟ್ 15 clear days notice ಅಲ್ಲಿ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ, ದಿ ಜಜ್ಮೆಂಟ್ ಆಫ್ ದಿಸ್ ಕೋರ್ಟ್, my lord, is that the day of meeting and the day of notice will have to be excluded.
Yes.
Then if the day of notice is excluded, 21st of January and 21st of December, then, my lord, it is 30 days.
Day of meeting cannot be excluded. It doesn't make sense if you exclude day of meeting. You have to hold the meeting by the end of 30th day.
My lord, this judgment, my lord, which I, with all due respect, my lord, the coordinate bench of this court squarely covering where there was 33 days.
That's okay.
This was 33 days.
Let Kadaganchi answer that.
Allah, now problem is, my lord, tomorrow is the meeting. Let it be subject to result. Day after tomorrow.
Pass over. Barli Kadaganchi.
If not the entire purpose, what would be the prejudice caused, my lord, if it is a majority decision which has to be taken into, and what is said in this judgment is that it is the benefit for whom it is registered is for the 2/3 majority.
Hema Kulkarni. Hema Kulkarni. Okay. Password.
Case of no confidence, my lord, I'm challenged on two grounds. But one is, my lord, the notice is defective because, my lord, the copy of the proposed resolution mentioned by the members is not enclosed. Second is, my lord, it does not comply, my lord, 15 days clear notice. My lord, the notice issued at annexure A is not accompanied with, my lord, the copy of, my lord, resolution or the motion which is proposed by the members. Thereafter, my lord, I had applied for, my lord, the certified copy and then secured it at annexure D and E. My lord, this copy has to be enclosed along with the. They have only sent, my lord, this notice. One, and my lord, this notice, though dated, my lord, 4/1/2025, my lord, the Gram Panchayat, my lord, member, I'm sorry, my lord, the office of Gram Panchayat, Panchayati Abhiruddhi Adhikari has served this notice on 8/1/2025. My lord, which is also secured under, my lord, the provisions by applying the copy at page number 21.
Page number?
21, my lord. They have served it on, my lord, 8/1/2025.
The new ಬರ್ಕೊಂಡ್ರು.
Yeah, this is a certified copy I have received. That is the reason, my lord, I have applied, my lord, to the office of Assistant Commissioner, which is acknowledged on 8/1/2025.
Yes.
If 8/1/2025, my lord, is taken into account, my lord, it will not comply, my lord, the requirement under rule 3.
The government.
My lord, it may be taken tomorrow, my lord, day after tomorrow is no come down. I will secure instruction, it is served on 8/1.
And AG is directed to accept notice for respondent number 1, 2, 3.
1, 2, 3.
New Year.
My lord, I am the caveat, my lord.
Full stop. Will you accept notice for other respondents?
Please, my lord.
Mr. Ganesh Naik accepts notice for respondents 6 to, sorry,
6
5
to
to
16, my lord.
no, 5 to 16,
5 to 16, my lord.
5 to 17.
Sir, please.
16.
Notice to respondent number 4 is dispensed for the time being.
My lord, is the standing counsel is the Arun Kumar, number 1 document.
The learned AGA is directed to secure instructions as to when the notice under Rule 3(2) of the Rules 1994 was served on the petitioner. Yes, list tomorrow.
Tomorrow.
Yes. Yema Kulkarni.
Sorry, minutes. Here, my lords, the name of the husband of the member varies each time, my lords, without there being any satisfaction as to the identity of the member. AC has issued notice under Rule 3(2). May I take my lordship notice to page number 6, column number 3. Page number 16, column number 3. Srimati Lakshmi Rajshekar Hachadad. This is
Page
for
number
the
16.
16, column number 3.
Column number 3 is Jambagi intide.
Serial number 3, Srimati Lakshmi Rajshekar Hachadad. First column.
Rajshekar Hachadada.
Rajshekar Hachadad. So this is for the first time when she moved the no confidence motion, which got quashed in a writ petition number before this honorable court. Again, she moves, again the members have moved another requisition that could be found at page number 18, serial number 3. Srimati Lakshmi Chandrasekhar Hachadad. My lordship could Kindly come to page number 20.
Hmm.
Page number 19, sorry, Annexure C, page number 19, serial number 3. Srimati Lakshmi Raju Hachadad. So each time, milords, the name of the member varies. For the first time, it was Lakshmi Rajshekar Hachadad.
Hmm.
Second time, it was Lakshmi Chandrasekhar Hachadad. For third time, it is Lakshmi Raju Hachadad.
Yes.
So this is the only variation which I could find out
Aste.
on the basic, only this.
Out of.
The last occasion also, they had made a variation. At the first point of time, they put thumb impression,
point.
and second time signature they had. Now
Other
this is-
point. No other point.
No other ground. This is all.
AGS directed accept notice for response 1 to 3. Notice to response 4 and 5 is dispensed. Mr. Ganesh Nayak, sir, accepts notice for respondent number 7 to 19. Full stop. Next para. Idu order sheet al madi. The petitioner, being the president of Gram Panchayat Jambagi, is before this court challenging the correctness of a notice dated
My lord, is
3/1/2025, issued by the respondent number 3, proposing to hold a meeting of the members of the Panchayat on 21/1/2025 to consider a motion of no confidence. Next para. The petitioner contends that she is the president of the Panchayat. She was elected as the president of the Panchayat during the elections held
In 2020 minutes.
in 2020.
20
2020, we were elected as a member of the Panchayat.
member.
You know, the petitioner contends that she was elected as the president of the Panchayat and was discharging her duty, his duty to the satisfaction of all the members. When things stood thus, the members moved a notice of no confidence on 8/11/2024, which was questioned in WP number 203389/2024. This court, in terms of the order dated 8/11/2024, 6/12/2024, allowed the writ petition and quashed the notice of the meeting of the members to consider the motion of no confidence. She contends that in the representation submitted by the members, the name of one of the members was shown as Srimati Lakshmi Chandrasekhar Hachadad.
And Lakshmi Rajshekar Hachadad.
Later, another representation was submitted by the members on 1/1/2025, where the name of Srimati Lakshmi Raju Hachadad was found. However, the respondent number 3, without satisfying the correct name of the member, casually issued a notice under Rule 3(2) of the Rules 1994, proposing to hold a meeting of the members on 21/1/2025. The petitioner is therefore before this court challenging the said notice. The learned counsel for the petitioner submitted that one of the members had earlier submitted the representation where her name was shown as Lakshmi Rajshekar Hachadad. However, in the instant representation, her name is shown as Lakshmi Raju Hachadad. Therefore, she contends that the representation is filed in a casual manner and the respondent number 3 has not expended time to verify whether the persons who had submitted the representation
Along with my lord is the Aadhaar
had
card and
genuinely submitted it.
along with my lord is the Aadhaar card and election card also present before the assistant commissioner.
Full stop.
Enclosure is there.
Therefore, she contends that the procedure adopted by the respondent number 3 is wholly irrational and in a casual manner. Per contra, the learned AGA submitted that the person who had submitted the representation was in fact known as Srimati Lakshmi Raju Hachadat. He contends that in the earlier representation, her name was shown as
Chandrasekhar.
Srimati Lakshmi Rajshekar Hachadat. He therefore submits that the said person is one and the same person, and the petitioner has not disputed that the said Srimati Lakshmi was a member of the Panchayat. Therefore, he contends that even if there is a mistake in mentioning her name, that does not affect the proceedings in any manner whatsoever. The learned counsel for Mr. Ganesh Naik, the learned counsel for the private respondents submitted that
The key enclosure along with my lord, the requisition letter. Enclosure my lord is the key Pramana Patra, Sadashatva Pramana Patra ಮತ್ತು ಆಧಾರ್ ಕಾರ್ಡ್ ಎರಡು ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ರು.
submits that along with the application, along with the representation in form 1, the members had furnished the Aadhaar card
And the election.
and
Election certificate.
and election
Elected member certificate.
member certificate. Therefore, it contends that there is no dispute that the person who had submitted the representation, the persons who had submitted the representation were all members of the Panchayat. Next, but I consider submissions of the learned counsel for the petitioner and the learned counsel for the private respondents as well as the learned AGA. Next para. Since the only contention raised by the learned counsel for the petitioner was that the respondent number 3 did not ascertain the names and the persons who had signed the representation, a perusal of the representation dated 1/1/2025 shows that the representation was received by the respondent number 3. Full stop. It also shows that the persons who had submitted the representations had furnished their Aadhaar card numbers. Full stop. Therefore, even if it is assumed that the name of Srimati Lakshmi was wrongly mentioned as Lakshmi Raju Hachadat, that did not in any way materially affect the proceedings of the meeting. Full stop. Therefore, the impugned notice issued by the respondent number 3 cannot be held to be defective and cannot be held to be defective. Under the circumstances, the petition lacks merit and is dismissed.
Great.
Kadaganchi.
The scheduled meeting is on 32nd day. On
20?
that point,
26?
32nd day.
He is relied upon a coordinate bench of this court on judgment ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ.
Yes, ಅದ್ ನೋಡ್ದೆ ಸರ್. ಅದರಲ್ಲಿ if it is perused, there the meeting was held. No confidence motion was passed. After that, subsequent another election was held and respondent 6 was elected as a president. After that, he comes saying that the meeting with which I was no confidence motion was held was after 30 days. What the court says in that is, when you have participated, when you have kept silent, when all the respondent have done, when the due process of new president is being done, then you can't go back and say that that meeting is after 30 days. So that facts is not applicable to this case. Whereas the facts which are applicable to my case is that after 30 days, this is being done and before the meeting is conducted, I am before this honorable court.
Yes.
That is not this case, my lord. The
And the second one is, the head point that is being given is, without any allegations, the resolution was passed in this ruling. The representation was given. But in the present case, there is an allegations. When there is an allegations, my lords, this is a judgment of Honorable Justice Sunil Dutt Yadav in 2018, which says that if there is any allegations, then it comes under 49(2). The 49(2), which now is no more in existence, then fresh liberty has to be given to the petitioners always to move for an other representation.
No, we are granted interim order only on the ground that the
30
meeting
days.
was held after 30 days.
Yes.
Please restrict it to that.
Yes.
The judgment which I have provided, it has two limbs, my lord. The first one with respect to my lord would end at para number 4. Internal page 5, with respect to the consequences of the petitioner therein having not challenged or aggrieved at the earlier stage. Then the second, my lord, the court deals with the procedural rule 3 with respect to 30 days being directory and mandatory. And then holds, my lord, the spirit of the legislature at para number 28 and
Yes, Karagan, ಹೇಳಿ.
Sir, para number 4 ali judgment ali.
ಓದಿ.
Yes. No such objection was raised by any member of the Panchayat either. Not only that, on 10/10/96, when the motion came up for discussion, the petitioners absented themselves and thereby to holding the meeting. No matter the same was beyond the statutory period by Rule 3. On the date of meeting, 2/3 members of the Panchayat also did not object to holding of the meeting beyond prescribed period of 30 days. The motion was put to vote and carried, as already mentioned earlier. The question then is whether the petitioners should be allowed to make grievance against the illegality at this distant point of time. My answer is in negative. It is in this circumstances that
let him come.
I'll again come to, my lords, with this background, I'll again come to page number 3 of the judgment also. From the top. Para 2, page number 3 on the top. Calling upon to deliver, andre yavaga avaru oppose madidru. Calling upon delivery of the books and records in their custody to the secretary of the Panchayat. It is not in disputed that an administrator was appointed for the Gram Panchayat pending fresh election, who remain in charge of the affairs of the Panchayat during the interim. The notice was then issued by the Assistant Commissioner for fresh election to be held on 15/11/96. In the said election, 6th respondent was elected unopposed as Adhyaksha of the Panchayat. No election was, however, concluded for the post of Upadhyaksha. 2 days before holding of this election, the petitioner comes up with this present writ petition challenging the no confidence proceedings held against them on 10/10/1986 on the ground indicated earlier. So this is the past gone. Under that circumstances, this observation is made. Here, that wrong has not been done. It has been rightly stayed by this honorable court by order dated so and so. So hence, my prayer is the interim order which is extended as per the law, wherein with an observation that the law, what the law says exactly, it has to go in that manner. With that observation, what the judgments are passed by this honorable court. I most humbly pray that the
But the law declared by a coordinate bench is that this 30-month period is not mandatory.
Not mandatory andre ಅದು ಅಂತ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸ್ ಅಲ್ಲಿ ಅದು ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿದ್ದಾರೆ.
Circumstance ಅಂತ ಹೇಳಿಲ್ಲ.
ಇಲ್ಲ ಸರ್, not
Generally they
mandatory.
say, no.
Where?
Para 4 ends, my
They
lord.
say,
There
please
itself.
wait.
Yes.
No, please read paragraph number 9, last sentence.
9. Against the above background.
Last sentence. The purpose underlying the provision is also in no way affected or defeated if the meeting is conducted within a reasonable period by the statutory authority concerned, no matter beyond the period of 30 days. Substantial compliance with the provision would in any such case suffice.
Yes,
So therefore.
the very first line of the 9th paragraph.
What the.
Against the above background,
Hmm.
it is with that background only these observations are made.
Yes.
If it comes to this also, my lords, I have to again go to the notice because that notice is with allegations. Allegations under 49(1) can't be done. Yes.
No, if there are allegations, it has to be construed under section 3(1) only, 49(1).
49(1) the allegations ಬೇಕೇ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
The division bench of this court says.
Yes.
If there are allegations made and if there are no rules, then it should be construed as an application filed under 49(1).
No, my
That is the division bench of this court.
division bench of this honorable court in writ appeal number is, if I'm right, it is 844 of 2018, wherein Honorable Chief Justice and Justice S. Krishna Kumar has made. On the basis of that judgment, in 2018, immediately this judgment is passed, which is after this. Here what it says is, whenever there is an allegation, since 49(2) has been deleted, then the petitioner who is facing the allegation doesn't get the substantiate time there, nor there is any provision there to overcome the allegations there. Hence, the provision here, the judgment here was, the direction was given to the petition respondent thereat to move another resolution with nil strictly as per the provision of 49(1), saying simply to conduct another meeting. My submission here is also the same thing. Here also, when there is allegation against me, it is 2018 judgment, it is 2018 writ appeal judgment also comes to my rescue.
Yes.
Under that circumstances, if the court comes to conclusion that 30 days, no other bakers for me, it has to be done as per that. If this is taken, the division bench and the single bench judgment, which is subsequently after this judgment,
Yes.
then my writ petition has to be allowed,
Yes.
giving them a liberty. Always that is there.
May I to my lord point out the first aspect, my lord, with respect to the facts of this case where in 1998 which my lord holds. I have, my lord, extensive research for 2 days, my lord. I have done this, my lord. On 30 days period, this is the only judgment which has been referred in subsequent judgments where with respect to clear days notice have been said so. And this is another judgment of where my lords, this with respect to this fact, my lord, ends where, my lord, page 5, my lord, your lordship take up this judgment 1998. The internal page 5, the para 4, the continuation. 1998, this Muniyampa and another. In fact, the reading of entire judgment would be very crucial, my lord, but however, I will restrict to not to take much time.
Yes.
The para 4 will deal with the facts of the present case, of this case, of the Muniyappa's case, where, my lord, 33 days al notice agutte, he do not challenge the procedure at that point of time. Thereafter, no confidence is moved, new election is done, new Adhyaksha comes in. Now that ends with respect to that, my lord, the decision is after petitioner removal, the democratic process envisaged under Act has cumulated in a fresh election and thrown up a new Adhyaksha who enjoys support of confidence of 2/3. It would therefore be anomalous and even ironical of this court where the trust upon the Panchayat of 2 office bearers have been lost. Their confidence have been removed by the not less than 2/3 majority of total membership of the Panchayat. These petitions are therefore liable to be dismissed on that short ground alone. This where the entire, this petition, this fact ends. Now, my lord, the court further says, Since, however, the question whether the provision of Rule 3 are mandatory or directory was also argued at great length, I may as well deal with the aspect also at Rule 3 read as thus. So, my lord, the Rule 3 is now related. There it ends, my lord. The Assistant Commissioner will not speak if the motion is carried out by a majority of not less than the after cessation of para number 10, my lord, para number 5, may I come, my lord?
Yes.
The next para. A plain reading of the above would show that sub-rule 2 of Rule 3 is in two parts. One which requires each member of the Panchayat to be given not less than 15 clear days, clear notice of meeting convened to discuss the no confidence motion, and the other which requires the meeting so convened should be within 30 days from the date motion is made. Insofar as the rule requires 15 days prior notice to the members of Panchayat, the same is and ought to be interpreted to be mandatory in character. That is, because the purpose underlying the requirement of 15 days notice is to not only to ensure that the members have sufficient time to deliberate upon and the proposed motion, but also confer with each other and take conscious and careful decision on the subject. This rule is intended to ensure that the motion of no confidence are not rushed through without giving to the members voting at the meeting sufficient time to ruminate and take a considered decision. It is also aimed at ensuring that those holding elected offices as Adhyaksha and Upadhyaksha are not dislodged from their position post haste and summarily. That precisely was that the full bench of this court also held in Puttaswamy case relied upon by the petitioner. The question referred to the full bench was answered by the bench in the following words. The provision under section 47(3) of Karnataka Jilla Parishad, Taluk Panchayat Samitis, Mandal Panchayat and Nyaya Parishad Panchayat Act 1983 requires the Assistant Commissioner to give members of Mandal Panchayat notice of a meeting for a consideration of a motion of no confidence against the Pradhan or Upa-Pradhan of not less than 15 days of such meeting is mandatory. The full bench was not, however, concerned with the other aspect of the rule, according to which the meeting for discussion a no confidence motion is required to be convened not later than 30 days from the date of motion is given. The decision is silent as to whether such a requirement can be considered mandatory. It does not therefore lend any assistance to the petitioner. The nature of the requirement shall have to be considered independently. While deciding whether the provision is mandatory or directory in the nature, the courts have evolved different tests for application. One of the tests is whether the provision itself stipulates the consequences of the violation thereof. Although even the test has not been treated to be conclusive, in other words, even where the provision does not provide for consequences of its violation, the same can be mandatory in character. The legal position regarding the approach to be adopted by the court in examining the provision from the point of view of finding out whether they are mandatory or directory has been summed up in the by the Supreme Court in Sharifuddin versus Abdul Ghani loan in the following words. The difference between a mandatory rule and a directory rule is that while the former must be strictly observed, in the case of the latter, substantial compliance may be sufficient to achieve the object regarding which the rule is enacted. Certain board propositions which can be deduced from the several decisions of the courts regarding the rules of construction that should be followed in determining whether a provision of law is directory or mandatory may be summarized thus. The fact that the statute uses the word shall while laying down a duty is not conclusive on the question whether it is mandatory or directory provision. In order to find out the true character of the legislation, the court has to ascertain the object, which is the provision of law in question, is to be subserved and its design and the context in which it is enacted. If the object of a law is to be defeated by non-compliance with it, it has to be regarded as mandatory. But when a provision of law relates to performance of public duty and the invalidation of any act done in this regard of the provision causes serious prejudice to the other for those benefit it is enacted, at the same time who have no control over the performance of the duty, such provision should be treated as directory one. Where, however, a provision of law prescribes that a certain act has to be done in a particular manner by a person in order to acquire a right, and it is coupled with another provision which confers an immunity on the another, when such act is done in the manner, the former has to be regarded as mandatory one. A procedural rule ordinarily should not be construed as mandatory. If the defect in the act done in pursuance of it can be cured by permitting appropriate rectification to be carried out at subsequent stages unless by according such permission to rectify the error later on. Another rule would be contravened whenever a statute prescribes that a particular act is to be done in a particular manner and also lays down that a failure to comply with the said requirement leads to a specific consequence, it would be difficult to hold that the requirement is not mandatory and specified consequence should not follow. Similarly, in Dalchand versus Municipal Corporation, Bhopal and another, the court, while reiterating the above position, declared that there are no ready test or invariable formula to determine whether a particular provision in a statute is mandatory or directory. The broad purpose of the statute, the object of the particular provision, and the link between the two was held to be important. The waiving of consequence of holding a provision to be mandatory or directory is vital and more often than not determinative of the question. Reference may also be made to the decision of Supreme Court in Karnal Leather Karmachari Sangh versus Liberty Footwear, where the court held thus, it is well established that the wording of any provision are not determinative as to whether it is absolute or directory. Even the absence of penal provision for non-compliance does not lead to an inference that is only directory. The court therefore must carefully get into the underlying idea and ascertain the purpose to be achieved notwithstanding the text of the provision.
Yes.
Against the above backdrop, this is, my lord, with respect to all these judgments, the backdrop of this is the words, the against the backdrop is not the facts of the case, it is against of these observations of the Honorable Apex Court. If we examine Rule 3, in so far as it directs that a meeting should be held not later than 30 days from the date of motion is made, the only object which is sought to be achieved by the provision is to ensure that the motion of no confidence do not remain unattended. All that is meant to be achieved is that the authority concerned expeditiously arranges to have the motion put to vote after the due notice to the members. It ensures that those moving the motion get the earliest possible opportunity to put the test their move. That being so, the requirement of holding a meeting within 30 days cannot be said to be mandatory, not only because the consequences of the failure to abide by the requirement are not stipulated, but also because the rule does not suggest that a motion duly moved by 2/3 of the members of the Panchayat would lose its efficiency if for one or the other reason a meeting is not convened within 30 days. The purpose underlying the provision is also no way affected or defeated if the meeting is conducted within a reasonable period by the authority concerned.
Please,
No matter.
Venkatesh, suppose if it is 29th day,
Please.
suppose if the meeting is held on the 29th day, should we say that it is not mandatory, so it is directory?
Yes.
Suppose if it is meeting is held on the 29th day,
Yes.
29th day,
Yes.
can we say that it was directory or mandatory?
It was directory itself. My lord. The 30 days, what this judgment says? Yes,
30
yes, it
30
was
days,
directory.
the court has said it is not mandatory.
It was directory, even if it is
Suppose
held
the
on-
assistant commissioner holds a meeting on the 29th day or the 28th day or the 25th day.
It is always, what is underlying is 15 clear days notice has to be given. That is,
Forget that. We are in the next leg.
Yes.
30 days notice the coordinate bench of this court has said that it is not mandatory, it is directory. Correct?
yes,
Suppose can the assistant commissioner fix a meeting on the 25th day?
yes, sir.
He can.
He can,
Hmm,
he can.
yes.
The only when even if he can fix a meeting on 16th day after my proposition, after my requisition, provided 15 clear days notice is given to members.
So you're saying regardless of whether it is 29, 25, 26, 16 days, that is directory. not
That is
mandatory.
directory. The first limb, that what the judgment says is.
No, I'll give you a flip side.
Yes,
Till the meeting is held, the Adhyaksha can and win over them.
yes.
So it is 30 days time for him. It is 30 days time for him to horse trade.
Yes,
For horse trading,
yes, madam.
30 days time.
That is what the judgment
Or
says,
to
madam.
convince the members not to vote against the no conflict.
It is that 30 expeditiously ಮಾಡಬೇಕು when the 2/3 majority has given
No, no,
requisition.
Directory mandatory ಅನ್ನೋದಕ್ಕೆ if he has got 30-day time
To convince
To
his
convince
members
the members
to get the confidence of the members.
to vote against the no confidence.
Yes, yes, yes.
Can you say that holding a meeting on the 16th day is directory?
Yes, yes, my lord.
He has got 30 days time under the rules. He has got 30 days time to convince the members. First 15 days, next 15 days.
Then, my lord, if for a moment, my lord, if this analogy is taken, I suppose, my lord, there are 3 petitions which have been filed today itself, end of the list. All those meetings would not fall on the 30th day. Then every meeting of no confidence will go.
Yes.
If this proposition is, my lord, taken on 15th.
No, I'm only giving you a flip side.
Hypothetically, I'm answering, my lord.
You are not getting what I am trying to
I
say.
understand, my lord. I understand your question.
Provision
Yes.
can have 2 phases.
Yes, yes, yes.
It can have 2 phases.
Yes.
When you say that you hold the meeting on the 16th day, we'll say that it is provision is mandatory, so therefore 30-day period is mandatory. You cannot hold the meeting before 30 days.
Before 30 days.
But when it comes to holding a meeting after 30 days, you say it is directory.
Direct.
So the same provision has got 2 phases. One is before, one is after.
For that reason only, my lord, I had to, support, I have to come with the support by the proposition which even if I, my lord, I go with this proposition, my understanding, my lord, may I put up? I understand your lordship, my lord, to have put up this, which is also one of the aspect of looking into that. What I understood, my lord, is that the spirit of the legislation is that if the 2/3 majority will have to, my lord, give a requisition, then what is stipulated right at the rules is that the members of the Panchayat to discuss upon, to take a decision, 15 clear days notice has to be given. That is where they have to decide in those 15 clear days notice whether they have to vote against the no confidence or in favor of the confidence. Now, so far as, my lord, as the procedural, the second part of the procedural aspect, even the rules also, the second part it comes in. When the assistant commissioner, when I make a requisition, it says within 30 days you should hold a meeting because you should not sleep over for another 60 or 1 day till the term is over.
ನಿಮಗೆ 2 phases of this coin ಕೊಟ್ಟಿದ್ದು ಏನಕ್ಕೆ ಅಂದ್ರೆ when there is doubt as to whether a provision is directory or mandatory. When there is doubt whether the provision is mandatory or directory, what should be the procedure to be adopted? What should be the procedure to be adopted when there is doubt? See, the procedure, onsati ನೀವು directory ಅಂದ್ರೆ it is directory for all practical purposes. For all purposes, before or after, it is practical, directory.
ಅದಕ್ಕೆ there are 2, that is what in judgment I'll ಹೇಳಿದ್ರ, because I very categorically, there are 2 limbs, there are 2 aspects. When public duty is cast, my lord, then it becomes which has prejudice, my lord, if there is a prejudice to him, my lord, if he is getting more, 1 day more to convince.
Correct ರೀ, ಅದಕ್ಕೆ ಹೇಳಿದ್ದು 1 day more ಅಂದ್ರೆ ನೀವು ಡೈರೆಕ್ಟ್ರಿ ಅನ್ಬಿಟ್ರಿ.
ಇಲ್ಲ 1 day, even I am
30 days ಕಿಂತ ಜಾಸ್ತಿ ಆದ್ರೆ you say it is directory.
Even within 30 days I am saying.
Within 13 days you say it is mandatory.
No, it is directory itself.
How?
These 30 days is always a directory. What is mandatory is 15 clear days notice.
No.
The rules.
ನಾನೊಬ್ಬ ಪ್ರೆಸಿಡೆಂಟ್, ನನಗೆ 30 ದಿನ ಟೈಮ್ ಇದೆ. ನನಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಾಗಿಂದ ಅಥವಾ ಅವ್ರ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ಟಾಗಿಂದ 30 ದಿನ ಟೈಮ್ ಇದೆ. ಅವ್ರ ಮನೆಗೆ ಹೋಗ್ತೀನಿ, ಬೆಣ್ಣೆ ಕೊಡ್ತೀನಿ, ತುಪ್ಪ ಕೊಡ್ತೀನಿ, ಏನಾದರೂ ಕೊಡ್ತೀನಿ. ಒಟ್ಟು ಏನಾದ್ರು ಮಾಡಿ 30 ದಿನದಲ್ಲಿ ಎಳ್ಕೊತೀನಿ ಈ ಕಡೆ. Because I am sure that the meeting will be held on the 30th day. The meeting will be held on the 30th day. But if you hold a meeting on the 15th day, even before I go on, then the provision becomes mandatory. Then the provision becomes mandatory. But if it is after 30 days, I got more days. I got more days to go and convince them. So it becomes directory.
Something which is curtailed, your lordship are saying something where you are curtailing the right, it becomes directory. Where you are not curtailing it, then it becomes directory.
So same provision has got 2 phases.
Yes.
When there are 2 phases, what should be the procedure? Should it lean in favor of the person in whose favor the legislation is made, or it should be viewed against him?
I am not, this
Alala,
it should be in favor of the person whose,
Yeah,
whose favor legislation is made. May I read that very words, my lord, that's it. This very word is what is used, my lord. My lord, but in para number 7, my lord, the paragraph, but when a provision of law related to performance of a public duty and invalidation of any act done in this regard of the provision causes serious prejudice to those whose benefit it is enacted. Now, my lord, this moving of
Whose
motion of no
benefit?
confidence is
Idರಲ್ಲಿ ಯಾರ್ benefit?
the majority, the two-third member of the majority.
Yes.
Their benefit is the right is exercised by the majority of the members.
The person who's losing is the president.
Yes,
The person who's going to be affected is the president.
that is where no prejudice. How is he being affected? If he is if the analogy, my lord, of the directory nature is taken, then within
Yes.
30 days, the 30 days he has already got.
Yes.
I am on the 31st day as per his.
Let the elections be held. We'll keep
No.
it subject to the result of the election.
ನಾನು
Will
ಒಂದೇ
be subject of the.
Yes.
And another one, my lord, sorry, just before I conclude, my lord. Your lordship are well aware, my lord, with respect to the Abdul Razak judgment where irregularity or is concerned, then Adhyaksha
Yes.
could not, my lord, maintain the writ petition on no confidence motion when irregularity and on the ground of.
This judgment has already been commented upon.
Yes, and the other judgments with respect to the other aspect which I was mentioning, where, my lord, with respect to the 15 clear days notice early, the day of notice, the day of requisition and the day of meeting will have to be excluded. That is also, my lord, is clarified and by this judgment as the court and all.
Yes.
If that is considered.
Lords, 30 days mandatory. If the section is read again and again, the assistant commissioner shall thereafter convey a meeting
Yes.
for the consideration of the said meeting at the office of Gram Panchayat on the date appointed by him, which shall not be later than. It is not which shall be within 30 days. The sentence there is which shall not be later than 30 days under any circumstance. It cannot be later than 30 days. That is mandatory here. Rule 3, subclause 2.
Yes.
The Karnataka Gram Panchayat
Yes.
Rule 2. The assistant commissioner shall thereafter convey a meeting for consideration of the said motion at the office of Gram Panchayat on the date appointed by him, which shall not be later than 30 days.
Why do you think this particular prescription is made in the rules? Yak 30 days anta yak madidare? What is the consequence or what is the purpose? Purpose in? Because they use the words which shall not be later than 30 days.
And also the same word is used for 15 days also.
What is the purpose of using these words?
From the date on which the notice under subsection 1 was delivered to him, he shall give to the members a notice of not less than 15 days. There also the same word is used.
That is okay. Not be later than 30 days. What is the reason for using those words? What is the reason? Which shall not be later than 30 days. Yen reason in?
It is a fair time for preparation.
Then 31 days is also a fair time.
But that is illegal, my lords. Here, as per the section, Swami, now act prakar hodre, act prakar hogbeko. ಈಗ act prakar ಹೋಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ತಾವು ಏನು ಆರ್ಡರ್ ಮಾಡಬಹುದು? No, my lords. No.
You're not allowing me to make my submission.
My submission has to be in the frame of law.
Please wait.
Submission has to be in the frame of law, in the law. When one of I'll complete my argument.
Understanding what is running in my mind. There's a judgment of a coordinate bench of this court. There's a judgment of a coordinate bench of this court which says that this rule 3.2 prescribing 30 days time is a directory. Please bear that in mind.
Yes.
Please bear that in mind. I am bound by the judgment.
Yes.
I am
That
bound,
is,
I am bound by the judgment unless you convince me
yes,
that that judgment is not correct on a particular question,
yes.
on a particular interpretation of law. Please tell me how this judgment is not correct.
Yes. My lords, here, the memo is moved today. I have been served the ruling of this now at 3:30. So I may be permitted, let it be in the first matter tomorrow morning. I'll get the judgment wherein after 30 days, whether it is permissible or not.
Yes.
I may be given a fair opportunity.
But tomorrow is a meeting.
Yes, ma'am. For that reason, if I'm not getting an opportunity,
I'll take it up at 4:45. Please come back to
yes,
the court.
I'll come back. Yes.
Hmm. Yes, sir. 4:45. Chidamba? RJ Prasad. Sanjeev Kumar C. Patil.
My friend was here.
Huh?
He was here. My friend was here. The petitioners have registered this society with an object of constructing a Buddha Vihar and for allied objects like one which are stated in the bylaws. In 1993, this society is registered. Somewhere in 2011, the managing committee has also been renewed. A writ petition is filed by the private respondents challenging the renewal of the society by the petitioner's faction, if I may call that,
Yes.
in WP number 84685 of 2011. However, once they said writ petition, the order of which is at Annexure E, at page number 43, withdrawn.
43.
Page 43, Annexure E, is dated 4th of July 2012. This is withdrawn at the instance of two persons, especially my lords will see the name of petitioner number 2, though they are claiming themselves to be the society itself. Secretary and members so and so, number 2. Now they had challenged the renewal of where 2011.
What was challenged in this?
In this, what was challenged was the order dated 13/10/2011 and the endorsement dated 15/10/2011, which are essentially the acceptance of the renewal of the managing committee submitted on behalf of the petitioner's faction.
Yes.
In fact, after they withdraw this writ petition challenging the renewal submitted by the petitioners, based upon a complaint of the very same respondents, private respondents, the registrar holds an inquiry, and the inquiry report is at Annexure F, starting at page 45. In this inquiry report, what has been held is that this petitioner number 2 and the other members, other persons who claim to be members of the society, they are not members of the society at all. This has been held there. If my lords will permit me to read the relevant portion at page number 50. I'm just reading the relevant portions of that finding.
Yes, please.
Page number 50. ಈ ಸಮಿತಿಯ ಸದಸ್ಯರಾಗಿರುವ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆ ಅಥವಾ ಪುರಾವೆ ಈ ಪ್ರಾಧಿಕಾರದ ಮುಂದೆ ಸ್ಪಷ್ಟವಾಗಿಲ್ಲ ಮತ್ತು ಅವರೇ ಈ ಹಿಂದೆ ಸಲ್ಲಿಸಿದ 174 ಜನ ಸದಸ್ಯರ ಯಾದಿಗೆ ಯಾವುದೇ ಆಧಾರದ ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸದೇ ಇದ್ದ ಕಾರಣ ಈ ಪ್ರಾಧಿಕಾರವು ದಿನಾಂಕ 15/10/2011 ಕರ್ನಾಟಕ ಸಂಘದ ನೋಂದಣಿ ಕಾಯ್ದೆ 60 ಕಲಂ 25 ಅಡಿಯಲ್ಲಿ ಈ ಕೆಳಗಿನ ಅಂಶಗಳ ಕುರಿತು ವಿವರವಾದ ವಿಚಾರಣೆ ಕೈಗೊಳ್ಳಲು ಆದೇಶಿಸಿ ಶ್ರೀ MS ಕಠೆ ಸಹಾಯಕ ಸಂಘ ಉಪನಿಬಂಧಕರು
ವಿಜಯಪುರ್ ಇವರನ್ನು ವಿಚಾರಣಾಧಿಕಾರಿಯನ್ನಾಗಿ ನಿಯೋಜಿಸಿ ಈ ಪ್ರಾಧಿಕಾರ ಆದೇಶ ಸಹ ವಿಚಾರಣೆಯಲ್ಲಿ 1 ಸಮಿತಿಯ ಮೂಲ ಅರ್ಹ ಸದಸ್ಯರಾರು ಹಾಗೂ 2 ಶ್ರೀ ಸೋ ಅಂಡ್ ಸೋ ನಾಗರಾಜ್ ಪಿ ಲಂಬು ರವರು ಹಿ ಇಸ್ ದ ಪೆಟಿಷನರ್ ನಂಬರ್ 2 ಇನ್ ದಟ್ ರಿಟ್ ಪಿಟಿಷನ್. ಲಂಬುರವರು ಸಲ್ಲಿಸಿದ ಆಡಳಿತ ಮಂಡಳಿಯ ನಿರ್ದೇಶಕರು ಸಂಸ್ಥೆಯ ಸದಸ್ಯತ್ವ ಹೊಂದಿದ್ದಾರೆಯೇ, 3 ಸದಸ್ಯರ ಯಾದಿ ಪರಿಶೀಲಿಸುವ ಕುರಿತು ಹಾಗೂ ಇತರೆ ಮಾಹಿತಿಗಳ ಕುರಿತು ವಿಚಾರಣಾ ಕೈಗೊಳ್ಳುವ ಬಗ್ಗೆ ಆದೇಶಿಸಲಾಗಿತ್ತು. ಸದರಿ ದಾಖಲೆಯನ್ನು ನಿಶಾನೆ 6 ಎಂದು ದಾಖಲಿಸಲಾಯಿತು. ಈ ಮೇಲಿನ ಆದೇಶದ ವಿಚಾರಣಾಧಿಕಾರಿ ಸೋ ಅಂಡ್ ಸೋ ಸಂಘಗಳ ಉಪನಿಬಂಧಕರು ವಿಜಾಪುರ್ ಅವರು ಸಮಿತಿ ಕುರಿತು ವಿಚಾರಣಾ ಸೂಚನೆಗಳಂತೆ ವಿಚಾರಣೆ ನಡೆಸಿ ದಿನಾಂಕ 6/2/2012 ತಮ್ಮ ವಿಚಾರಣೆ ವರದಿಯನ್ನು ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಸಲ್ಲಿಸಿದ್ದು ಸದರಿ ವರದಿಯನ್ನು ನಿಶಾನೆ 7 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಸಿಮಿಲರ್ಲಿ my lords, the kindly come to a little yes, I will read the further ones. 7 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಆದರೆ ಅದರ ಮುಖ್ಯವಾದ ವಿಚಾರಣಾ ಮಾಹಿತಿಗಳನ್ನು ಗಮನಿಸಲಾಗಿ ಅಧಿಕೃತ ಕಾರ್ಯದರ್ಶಿಗಳಾದ ಶ್ರೀ ಸಂಜೋತ್ ಔದಿ ರವರು, ದಟ್ ಈಸ್ ದ ಪೆಟಿಷನರ್ ಬಿಫೋರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್, ಸದರಿ ಸಮಿತಿ ಸದಸ್ಯರ ಯಾದಿಯಲ್ಲಿ 178 ಜನ ಸದಸ್ಯರೆಂದು ಮತ್ತು ಅದರಲ್ಲಿ ಪ್ರಸ್ತಾವನೆ 2 ಸಲ್ಲಿಸಿದ ಶ್ರೀ ನಾಗರಾಜ್ ಪಿ ಲಂಬು ಹಾಗೂ ಜಿತೇಂದ್ರ ಕಾಂಬ್ಳೆ ಪೆಟಿಷನರ್ ನಂಬರ್ 1 ಇನ್ ದ ಅರ್ಲಿಯರ್ ರಿಟ್ ಪಿಟಿಷನ್ ರವರ ಹೆಸರುಗಳು ಇರುವುದಿಲ್ಲವೆಂದು ಹಾಗೂ ಅವರು ಸಲ್ಲಿಸಿದ ಆಡಳಿತ ಮಂಡಳಿಯ ಸದಸ್ಯರುಗಳು ತಮ್ಮ ಸಂಘದ ಸದಸ್ಯರಾಗಿರುವುದಿಲ್ಲವೆಂದು ತಿಳಿಸಿ ತಮ್ಮ ಆಕ್ಷೇಪಣೆಯನ್ನು ಸ್ಪಷ್ಟಪಡಿಸಿದ್ದು ಇರುತ್ತದೆ. ಅದೇ ವಿಚಾರಣೆಯಲ್ಲಿ ಇದರಿಂದ ಸಮಿತಿಯ ಅರ್ಹ ಸದಸ್ಯರ ಯಾದಿಯನ್ನು 2 ಪಕ್ಷದವರು ಕೂಡ ಖಚಿತಪಡಿಸುವುದಲ್ಲಿ ವಿಫಲರಾಗಿದ್ದಾರೆ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಈ ಸಂಗತಿಗಳನ್ನು ಆಧರಿಸಿ ವಿಚಾರಣಾ ವರದಿ ಮೂಲಕ ಸದರಿ ವಿಚಾರಣಾಧಿಕಾರಿ ವಿವರ ತಿಳಿಸಿದ್ದೇನೆಂದರೆ, ಸದರಿ 2010-11ನೇ ಸಾಲಿನ ಸಮಿತಿ ಸರ್ವಸಾಧಾರಣ ಸಭೆ ಕರ್ನಾಟಕ ಸಂಘ ಸೋ ಅಂಡ್ ಸೋ ಕಲಂ 11 ಜರುಗಿಸಿದ್ದು ಕಂಡು ಬರುವುದಿಲ್ಲ ಎಂದು ಸ್ಪಷ್ಟವಾಗಿ ಸಮಿತಿಯ ಎಲ್ಲ ದಾಖಲೆ ಅಧಿಕೃತ ಆಡಳಿತ ಮಂಡಳಿ ಕಾರ್ಯದರ್ಶಿಗಳಾದ ಸಂಜೋತ್ ಔದಿರವರು ಹಾಜರುಪಡಿಸಿದ್ದು ಮಾತ್ರ ಸ್ಪಷ್ಟವಾಗಿದ್ದು. If I can skip this portion, the relevant portion for my argument is in the next page, at page 51, the unnumbered last paragraph, unnumbered third paragraph. Some 4 lines from the top of that. I will read. ಈ ಸಂದರ್ಭದಲ್ಲಿ it starts like this paragraph. ಈ ಸಂದರ್ಭದಲ್ಲಿ ಸದರಿ ದಾಖಲೆಗಳನ್ನು ರೂಪಿಸಿ ಈ ಪ್ರಾಧಿಕಾರಕ್ಕೆ 11-12ನೇ ಸಾಲಿನ ವಾರ್ಷಿಕ ಲೆಕ್ಕ ಹಾಗೂ 12-13ನೇ ಸಾಲಿನ ಸಂಘದ ಕಾರ್ಯಕಾರಿ ಮಂಡಳಿಯ ಯಾದಿಯನ್ನು ದಿನಾಂಕ 16/10/2012 ಸಲ್ಲಿಸಿದ್ದು ಇದೆ. ಸದರಿ ವಾರ್ಷಿಕ ವರದಿಗಳನ್ನು ಸಲ್ಲಿಸುವುದಕ್ಕೆ ಇವರು ಸಮಿತಿಯ ಸದಸ್ಯತ್ವ ಹಕ್ಕುಳ್ಳವರಾಗಿಲ್ಲವೆಂದು ಹಾಗೂ ಸಮಿತಿಯ ಪರವಾಗಿ ಸಭೆಯನ್ನು ನಡೆಸುವ ಅಧಿಕೃತ ಕಾರ್ಯದರ್ಶಿಗಳು ಆಗಿರುವುದಿಲ್ಲವೆಂದು ಮೇಲ್ನೋಟದಲ್ಲಿ ಈ ಮೇಲಿನ ವಿವರಿಸಿದಂತೆ ಹಕ್ಕುಳ್ಳವರ ಆಗಿಲ್ಲವಾದ್ದರಿಂದ ಸದರಿ ಅವರು ಸಲ್ಲಿಸಿದ ವಾರ್ಷಿಕ ವರದಿಯನ್ನು ಸಮಿತಿಯ ಪರವಾಗಿ ಸ್ವೀಕೃತಿ ಪಡೆಯಲು ಅರ್ಹತೆ ಪಡೆದಿರುವುದಿಲ್ಲ. ಅದರಂತೆ ಈ ಕಾರಣಗಳಿಂದಾಗಿ ಅವರು ಈ ಹಿಂದೆ 2010-11ನೇ ಸಾಲಿನ ಲೆಕ್ಕಪತ್ರ ವರದಿ ಮತ್ತು 11-12 ಸಾಲಿನ ಆಡಳಿತ ಮಂಡಳಿಯ ಯಾದಿಯನ್ನು ಈ ಪ್ರಾಧಿಕಾರದ ಮುಂದೆ ತಪ್ಪು ಮಾಹಿತಿಗಳೊಂದಿಗೆ ನೀಡಿ ದಿನಾಂಕ 4/8/2012 ಸ್ವೀಕೃತಿ ಪ್ರಮಾಣ ಪತ್ರ ಪಡೆದಿದ್ದು ಕರ್ನಾಟಕ ಸಂಘಗಳ ಸಮಿತಿ ನಿಯಮಾವಳಿ ವಿರುದ್ಧವಾಗಿದೆ. Then my lords will see the operative portion at page 52. Here my lords, the application or the submission made by the petitioner's faction is also rejected because it is time barred. However, it is very clearly stated from the 3rd unnumbered paragraph in the operative portion. Second unnumbered paragraph. ಅದರಂತೆ ಶ್ರೀ ನಾಗರಾಜ್ ಪಿ ಲಂಬು ರವರು ಸದರಿ ಸಮಿತಿಯ ಕಾರ್ಯದರ್ಶಿಗಳೆಂದು ಹೇಳಿಕೊಂಡು ಮೇಲೆ ವಿವರಿಸಿದಂತೆ ತಪ್ಪು ಮಾಹಿತಿಗಳೊಂದಿಗೆ 2010-11ನೇ ಸಾಲಿನ ಆಡಿಟ್ ವರದಿ 11-12 ಸಾಲಿನ ಆಡಳಿತ ಮಂಡಳಿ ಯಾದಿಯನ್ನು ಈ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಸಲ್ಲಿಸಿದ ದಿನಾಂಕ 4/8/12 ಪಡೆದುಕೊಂಡ ಸ್ವೀಕೃತಿ ದಾಖಲೆಯ ಕುರಿತು ಈ ಮೇಲೆ ಚರ್ಚಿಸಿದಂತೆ ರದ್ದಾಗಿದೆ ಎಂದು ಪರಿಗಣಿಸಲಾಗಿದೆ. ಅದರಂತೆ ಶ್ರೀ ನಾಗರಾಜ್ ಪಿ ಲಂಬೂರ್ ಅವರು ತಾವೇ ಸಮಿತಿ ಕಾರ್ಯದರ್ಶಿಗಳೆಂದು ತಪ್ಪು ಮಾಹಿತಿಯೊಂದಿಗೆ 11-12ನೇ ಸಾಲಿನ ಆಡಿಟ್ ವರದಿ ಹಾಗೂ 12-13ನೇ ಸಾಲಿನ ಆಡಿಟ್ ವರದಿ ಮಂಡಳಿ ಯಾದಿಯನ್ನು ಪ್ರಸ್ತಾವನೆ 2 ಮೂಲಕ ಸಲ್ಲಿಸಿದ್ದು ತಿರಸ್ಕರಿಸಲಾಗಿದೆ. ಅಲ್ಲದೆ ಅವರು ಸಲ್ಲಿಸಿದ ಯಾವತ್ತು ಪ್ರಸ್ತಾವನೆ 2 ದಾಖಲೆಗಳನ್ನು ಹಾಗೂ ಅವರ ಸಲ್ಲಿಸಿದ ಪ್ರಸ್ತಾವನೆ 2 ಜೆರಾಕ್ಸ್ ಪ್ರತಿಗಳನ್ನು ನಿಶಾನೆ ಸೋ ಅಂಡ್ ಸೋ ಎಂದು ಗುರುತಿಸಿ ನಿಶಾನೆ 10 ಜೆರಾಕ್ಸ್ ಪ್ರತಿಯನ್ನು ಈ ಕೆಳಕಂಡೆ ನಮೂದಿ ಇಟ್ಟುಕೊಂಡು ಸದರಿ ಪ್ರಸ್ತಾವನೆ ವರದಿಗಳನ್ನು ಈ ಮೂಲಕ ಹಿಂದಕ್ಕೆ ಮರಳಿಸಿ ದಾಖಲೆ ಪಡೆಯುವುದಕ್ಕೆ ಕಾರ್ಯಾಲಯಕ್ಕೆ ಸೂಚಿಸಿದ್ದೇನೆ. ಸದರಿ ಅಧಿಕೃತ ಸಂಘದ ಕಾರ್ಯದರ್ಶಿಯಾದ ಶ್ರೀ ಸಂಜೋತ್ ಔದಿರವರಿಗೆ ಈ ಕೆಳಗಿನಂತೆ ನಿರ್ದೇಶಿಸಿದ್ದೇನೆ. ದಟ್ ಇಸ್ ದ ಪೆಟಿಷನರ್. ಸಮಿತಿಯ ಸಭೆಯಲ್ಲಿ ಮತ ಚಲಾಯಿಸುವ ಹಕ್ಕುಳ್ಳ ಅರ್ಹ ಸದಸ್ಯರು ಬಗ್ಗೆ ಹಾಗೂ ಸರ್ವ ಸದಸ್ಯರ ಯಾದಿಯ ಕುರಿತು ದೃಢೀಕರಣ ಪಡೆಯಲು ನಿಯಮಾವಳಿಗಳನ್ನು ರೂಪಿಸುವುದಕ್ಕೆ ಈ ಆದೇಶದಿಂದ 3 ತಿಂಗಳ ಅವಧಿಯೊಳಗೆ ಎಲ್ಲ ಸರ್ವ ಸದಸ್ಯರ ಸಭೆಯನ್ನು ಕರೆದು ನಿರ್ಧರಿಸಿಕೊಳ್ಳುವುದು. ಈ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಪ್ರತಿ ವರ್ಷ ಮಾರ್ಚ್ 31ರಿಂದ 9 ತಿಂಗಳ ಅವಧಿಯೊಳಗೆ ನಿಯಮಾವಳಿಗಳಂತೆ ಸದಸ್ಯರ ಸಭೆಯನ್ನು ಕರೆದು ವಾರ್ಷಿಕ ವರದಿ ದೃಢೀಕರಿಸಿ ನಿಗದಿತ ಅವಧಿಯೊಳಗೆ ಈ ಪ್ರಾಧಿಕಾರದಿಂದ ಸ್ವೀಕೃತಿ ಸಲ್ಲಿಸುವುದು. After this inquiry report at Annexure F, my lords will see at Annexure G. It starts at page number 68.
ನಾಗರಾಜ್ ಪಿ ಲಂಬು ಅಂದ್ರೆ ಯಾರು? ನಾಗಪ್ಪ ಅವರೇನಾ?
ಹೌದೌದು ಅವರೇ. Nagaraj P. Lambu and Jitendra are the 2 petitioners in the earlier writ petition.
ನಾಗರಾಜ್ ಲಂಬು and Nagappa Lambu one and the same
They are one and the same. They change their name, or sometimes they like there is another name Chandrakant who calls himself as Kantu. So they are vernacular substitutions of the same name.
Yes.
So this Annexure F inquiry report is also, in fact, 15/6/2013 inquiry report is also challenged by the very same, now the respondents 3 and 4 herein at Annexure H, page 78.
Yes. Page 68.
After this, in fact, after the inquiry report, as per Annexure G, there is a resolution passed by the petitioners faction where the total number of elected members are now stated, are resolved to have been elected again for the subsequent years. This resolution, which is consequent to the order at Annexure F, is subject matter of a writ petition at Annexure H. That writ petition also, my lords, is again dismissed as not pressed.
But what was challenged in the petition?
In this writ petition, what is challenged, your lordships will find, is the resolution at Annexure G.
ಇಲ್ಲ ಕಾಣ್ತಾ ಇಲ್ಲ ಇದು ಪೇಜ್ ನಂಬರ್ 18 ಅಲ್ಲಿ ಸರ್ಟನ್ ರಿಲೀಫ್ಸ್ ಅಂತ ಅಂದ್ರು.
ಹೌದು, ಅಷ್ಟೇ ಬಂದಿದೆ. ಸರ್ಟನ್ ರಿಲೀಫ್ ಅಷ್ಟೇ ಬಂದಿದೆ.
Yes, yes.
Copy ಇದ್ರ ಕೊಡಿ, writ petition copy. There is a reference to that, my lords, in the subsequent order. I will point it out. This is WP number 201830, and in the order at Annexure V. Annexure V and Annexure W are the recent orders now of the very same authority. This order of withdrawal of the writ petition is dated for 12th of April 2023.
Yes.
On the very next day, on 13th of April 2023, the order at Annexure W is passed. The resolution which is at Annexure G, that resolution, my lords, is of the year 25/8/2013. This 2013 order resolution is challenged in the year 2014, kept pending till 2023. And on 12th of April 2023, the writ petition is withdrawn. Thereby,
That is after this Annexure W.
no, Annexure G is the resolution which the petitioner's faction passes.
The writ petition withdrawn 12th April.
There are 2 writ petitions. I will tell this. Writ petition is withdrawn on 12th of April 2023. In this writ petition, what was challenged was the resolution passed by the petitioner's faction holding a management committee meeting consequent to the earlier inquiry report at Annexure F.
Yes.
Now, this resolution is dated 25/8/2013. This is of the year 2013.
Yes.
That 2013 resolution is challenged in 2014.
Yes.
It is kept pending and is withdrawn only in the year 2023. Very strangely, just one day before the order at Annexure W is passed, which is an order accepting the management committee, so-called management committee, submitted by the respondents 3 and 4 now. For this, my lords, there is another inquiry report at Annexure V. This Annexure V, they state that this is dated 10th of April 2023. So stealthily, there is an ex parte inquiry report which is first probably prepared, and then they approach this court to withdraw the writ petition which was pending. And very next day, they get the approval from the district registrar. Now, very strangely, my lords will see here in the inquiry report at Annexure V. We can't even call this as an inquiry report, but The provisions of section 25 are invoked, therefore it can be stated so. My lords will find at page number 85 the reference to that earlier writ petition which they withdraw. At page 85, the last two paragraphs.
Yes.
The last two paragraphs. ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಕಲಬುರಗಿ ರಿಟ್ ಸಂಖ್ಯೆ 201830 of 2014 ವಿಚಾರಣೆ ಬಾಕಿ ಇದ್ದು ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ವಿಚಾರಣೆ ಕೈಗೊಳ್ಳಬಾರದೆಂದು ಹಾಗೂ ಅವರ ಗುಂಪಿನ ಸದಸ್ಯರು ಸದರಿ ವಿಚಾರಣೆಯಲ್ಲಿ ಭಾಗವಹಿಸುವುದಿಲ್ಲವೆಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಕಾರಣ ಸಂಘದ ಅಧ್ಯಕ್ಷರ ಮನೆಯಲ್ಲಿ ಮದುವೆ ಕಾರ್ಯಕ್ರಮ ಇರುವುದರಿಂದ ಗುಂಪಿನ ಎಲ್ಲ ಸದಸ್ಯರು ವಿಚಾರಣೆಗೆ ಹಾಜರಾಗಿರುವುದಿಲ್ಲ. ಇನ್ನೊಂದು ವಿಚಾರಣೆ ದಿನಾಂಕ ನೀಡಲು ಗುಂಪಿನ ಎಲ್ಲ ಸದಸ್ಯರು ಲಿಖಿತ ಹೇಳಿಕೆ ಸಲ್ಲಿಸಿರುವುದು ಕಡತವನ್ನು ಸೇರಿಸಿಕೊಂಡು ಸಾಮಾಜಿಕ ನ್ಯಾಯ ದೃಷ್ಟಿಯಿಂದ ವಿಚಾರಣೆಯನ್ನು ಮುಂದೂಡಲಾಯಿತು. ದೆನ್ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಕಲಬುರಗಿ ರಿಟ್ ಸಂಖ್ಯೆ 201830 ಅರ್ಜಿದಾರರು ಕೋರಿರುವ ಕೋರಿಕೆ ಸಲ್ಲಿಸಲು ಸಂಪೂರ್ಣ ಕಡತ ಕಚೇರಿಯಲ್ಲಿ ಲಭ್ಯವಿರುವುದಿಲ್ಲ. ಕಾರಣ ನೋಂದಣಿ ಇಲಾಖೆಯ ಕಚೇರಿಯಲ್ಲಿ ಸದರಿ ಸಂಘದ ಕಡತ ಈ ಕಚೇರಿಗೆ ಸ್ವೀಕೃತಿಗೊಂಡಿಲ್ಲ ಹಾಗೂ ಹಸ್ತಾಂತರಗೊಂಡಿರುವುದಿಲ್ಲ. ಸದರಿ ಕಡತ ನೋಂದಣಿ ಕಚೇರಿಯಲ್ಲಿ ಇರುವುದು ಖಾತ್ರಿಪಡಿಸಿಕೊಳ್ಳಲಾಗಿದೆ. ಕಾರಣ ಸದರಿ ಕಡತ ಮುಂದಿನ ವಿಚಾರಣೆ ಸ್ವೀಕೃತಿ ಪಡೆಯಲು ಪ್ರತ್ಯೇಕವಾಗಿ ಪತ್ರ ಬರೆಯಲು ನಿರ್ಣಯಿಸಲಾಯಿತು. ಇಂದಿನ ವಿಚಾರಣೆಯಲ್ಲಿ ಒಂದು ಗುಂಪಿನ ಮುಖ್ಯಸ್ಥರಾದ ಶ್ರೀ ಸೋ ಅಂಡ್ ಸೋ ಇವರು ತಮ್ಮ ತಂಡದ ಸದಸ್ಯರೊಂದಿಗೆ ವಿಚಾರಣೆ ಹಾಜರಿರುತ್ತಾರೆ. ಅವರು ಹಾಜರಾತಿಯನ್ನು ದೃಢೀಕರಿಸಲಾಯಿತು. ಬಟ್ ಫೈನಲಿ ಮೈ ಲಾರ್ಡ್ಸ್ ವಿಲ್ ಸಿ ಅಟ್ ದಿ ನೆಕ್ಸ್ಟ್ page number 89, where in the middle of this page your lordships will find the date ದಿನಾಂಕ 10/3/2023 ವಿಚಾರಣೆಯನ್ನು ಕರೆಯಿಸಲಾಯಿತು. And in the next paragraph, in the last two lines, my lords will see what finally the authority says. The last line, last sentence. ಸದರಿ ಗುಂಪಿನ ಸದಸ್ಯರು ಇಂದಿನ ವಿಚಾರಣೆಗೆ ಉದ್ದೇಶ ಪೂರ್ವದಿಂದ ಗೈರ್ ಹಾಜರಾಗಿ ಏಕತರಪೆಯಿಂದ ಪರಿಗಣಿಸಿ ವಿಚಾರಣೆಯನ್ನು ಮುಂದುವರೆಸಲಾಯಿತು. So finally the authority decides to proceed ex parte.
Where are you reading that?
My lords, in page number 89.
87.
Sorry, 87, page 87. Page 87, the third unnumbered paragraph, end of the third unnumbered paragraph. It starts with ದಿನಾಂಕ 10/3/23. Thereafter, ಹಾಗೂ ಸಂಘದ ಸದಸ್ಯರಾದ. In that, my lords, the last sentence, ಸದರಿ ಗುಂಪಿನ ಸದಸ್ಯರು ಇಂದಿನ ವಿಚಾರಣೆಗೆ ಉದ್ದೇಶ ಪೂರ್ವದಿಂದ ಗೈರ್ಹಾಜರಾಗಿ ಏಕತರಪೆ ಎಂದು ಪರಿಗಣಿಸಿ ವಿಚಾರಣೆಯನ್ನು ಮುಂದುವರೆಸಲಾಯಿತು. ಏಕತರಪೆ is ex parte. Then, my lords, there is absolutely no reference to the earlier inquiry report finding stating that this Sri Nagaraj Lambu is not the member of the society and that Mr. Jitendra is also not the member of the society. Nothing of that sort is stated there.
ಎಲ್ಲ ಹೇಳಿದಾರಲ್ಲ ಇಲ್ಲಿ
ಹೇಳಿದರೆ 10/4/23 ಇಬ್ಬರು ಪ್ರೆಸೆಂಟ್ ಇದ್ದಾರೆ.
Present ಇರೋದಿಲ್ಲ.
Page 85.
Page 85 ದಲ್ಲಿ
third paragraph.
Yes.
ದಿನಾಂಕ 4/8/11
4/8/2011 ನಾಗರಾಜ್ ಲಂಬು ಇವರು ನೇತೃತ್ವದಲ್ಲಿ ಜರುಗಿದ ಸಂಘದ ಸಾಮಾನ್ಯ ಸಭೆ ನಿಯಮಾನುಸಾರ ಜರುಗಿಸಿಲ್ಲ ಎಂದು ಸ್ವೀಕೃತಿ ಪತ್ರ ರದ್ದು ಮಾಡಿದ ವಿವರ ಪರಿಶೀಲನೆ ಮಾಡುವುದು. ಈಗ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಕಲಬುರಗಿ ಇದರ ರಿಟ್ ಸಂಖ್ಯೆ 84685/14 ಇದು ಬಾಕಿ ಇದೆ. ಕಚೇರಿ ನಿರ್ದೇಶನ ಪಾಲಿಸದೆ ಇರುವುದು. ಸಂಘ ಕಾರ್ಯಕಾರಿ ಮಂಡಳಿ ರಚನೆ ಮಾಡಿದ್ದು ಸನ್ 11/12 ಆಡಳಿತ ಮಂಡಳಿ ಯಾದಿ ದಿನಾಂಕ 4/8/2012 ಅನುಮೋದನೆ ನೀಡಿ ಸ್ವೀಕೃತಿ ನೀಡಲಾಗಿದೆ. ಈ ಕುರಿತು ಮರು ವಿಚಾರಣೆ ಕಾಲಕ್ಕೆ ಸಂಘದ ಸದಸ್ಯರಲ್ಲದ ಶ್ರೀ ಜಿತೇಂದ್ರ ಕಾಂಬ್ಳೆ ಹಾಗೂ ನಾಗರಾಜ್ ಲಂಬು ಇವರು ಸಲ್ಲಿಸಿರುವ ಆಡಳಿತ ಮಂಡಳಿಯ ಸದಸ್ಯರು ಯಾದಿ ಆರ್ಥಿಕ ದಾಖಲಾತಿಗಳು ತನ್ನಿಂದ ತಾನೇ ರದ್ದಾಗುತ್ತದೆ ಎಂದು ಅರ್ಥಿಸಿಕೊಳ್ಳಲಾಗಿದೆ. ದಿನಾಂಕ 11/11/2013 ಸ್ವೀಕೃತಿ ಪತ್ರ ಪರಿಶೀಲಿಸಲಾಗಿ 11/12 ದಿನಾಂಕ 4/8/2012 ಅವಧಿಯ ಸ್ವೀಕೃತಿ ಪತ್ರ ರದ್ದುಪಡಿಸದೆ ದಿನಾಂಕ 11/11/2013 ಸನ್ 11/12 13/14 3 ವರ್ಷಗಳ ಅವಧಿಗಾಗಿ ಶ್ರೀ ಮಹೇಶ್ ಖ್ಯಾತನ್ ಇವರು ಸಲ್ಲಿಸಿರುವ ನವೀಕರಣ ಅರ್ಜಿ ಕಡತಕ್ಕೆ ಸೇರಿಸಿಕೊಂಡು ಸ್ವೀಕೃತಿ ನೀಡಲಾಗಿದೆ. Now, what is stated so far as that, if your lordships want me to read that portion where the authority still assumes that he is the member, is at page 86. I had stopped after reading the first paragraph. If your lordships permit me to read the paragraph, some third unnumbered paragraph. ಸಂಘದ ನೋಂದಣಿ ದಿನಾಂಕ 14/5/93. It starts like this. ಸಂಸ್ಥಾಪಕರಾದ ನಮ್ಮ ಜೊತೆಯಲ್ಲಿ ಶ್ರೀ ಸಾಬು ಚಲವಾದಿ ಹಾಗೂ ಶ್ರೀ ನಾಗಪ್ಪ ಪಿ ಲಂಬು ಇವರು ಸಂಸ್ಥಾಪಕರ ಸದಸ್ಯರು ಇರುತ್ತಾರೆ ಎಂದು ಸಂಘದ ಕಾರ್ಯದರ್ಶಿ ಶ್ರೀ ದಶವಂತ್ ಗುನಾಪುರ್ ಇವರು ಇಂದಿನ ವಿಚಾರಣೆಗೆ ಮುಂದುವರೆದು ಹೇಳಿಕೆ ಸಲ್ಲಿಸಿದರು. ಸಂಸ್ಥಾಪಕ ಹೇಳಿಕೆ ಪಡೆಯಲು ತೀರ್ಮಾನಿಸಲಾಯಿತು. This is only a statement which is recorded. Nothing, no finding on that at all. Now, my lords, it could have been assumed that if they are not negating this statement, then they accept it. But in the wake of the finding at Annexure F, where it is held that these two persons are not the members, now recording of this statement is not sufficient. The authority should have then overturned the earlier finding at least to say that this statement is acceptable. Nonetheless, there is nothing on record produced to show how he becomes a member. What is shown, what is attempted to be shown is in the bylaws of the year 1993, there is an original list and the member at serial number 2 is rounded off and a manuscript is now found stating the name of this Sri Nagaraj Lambu. That is at Annexure B. I will point out that one little later. Now, in this order at Annexure V or the inquiry at Annexure V, firstly, this proceeds ex parte against the petitioners.
Please come
Secondly,
to page 88,
88. Yes.
last paragraph.
Yes. ದಿನಾಂಕ 23/2023 ವಿಚಾರಣೆಗೆ ಕರೆಯಲಾಯಿತು. ಶ್ರೀ ರಾಜಶೇಖರ ಹೆಡಳಿ ತಂಡದ ಸದಸ್ಯರ ಪೈಕಿ ಈ ಕೆಳಗಿನವರು ಮಾತ್ರ ವಿಚಾರಣೆಗೆ ಹಾಜರಾಗಿರುತ್ತಾರೆ. ಮಹೇಶ್ ಕ್ಯಾತನ್ ಇವರು ಸಂಘದ ಸದಸ್ಯರಾದ ಸಂಜೋತ್ ಅವಧಿ ಇವರ ಲಿಖಿತ ಪತ್ರದ ಅಡಿಯಲ್ಲಿ ವಿಚಾರಣೆ ಗೈರ್ ಹಾಜರಿರುವುದು ದಾಖಲು ಮಾಡಿಕೊಳ್ಳಲಾಯಿತು. ಇಂದಿನ ವಿಚಾರಣೆಯಲ್ಲಿ ಭಾಗವಹಿಸಿದ ಸದಸ್ಯರ ಪೈಕಿ 4 ಜನ ಸದಸ್ಯರು ವಿಚಾರಣೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ದ್ವಿಪ್ರತಿಗಳಲ್ಲಿ ತಮ್ಮ ಲಿಖಿತ ಆಕ್ಷೇಪಣೆಗಳನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಅದನ್ನು ವಿಚಾರಣೆ ಕಡತಕ್ಕೆ ಸೇರಿಸಿಕೊಳ್ಳಲಾಯಿತು. ರಾಜಶೇಖರ ಹೆಡಳ್ಳಿ, ಶ್ರೀ ಶಶಿಕಾಂತ್ ಹೊನ್ವಾಡ್ಕರ್, ನಾಗರಾಜ್ ಲಂಬು, ಶ್ರೀ ಅನಿಲ್ ಹೊಸ್ಮನಿ ಇಂದಿನ ವಿಚಾರಣೆಗೆ ಹಾಜರಾಗಿರುವ ಶ್ರೀ ನಾಗರಾಜ್ ಲಂಬು ಇವರು ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಕಲಬುರಗಿ ಪೀಠ ಇದರ ರಿಟ್ ಅರ್ಜಿದಾರರಾಗಿದ್ದು ರಿಟ್ ಸಂಖ್ಯೆ 20183014 ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ತಮ್ಮ ಹೇಳಿಕೆಯನ್ನು ಸಲ್ಲಿಸಿದರು. ಸನ್ 2011-12ನೇ ಸಾಲಿಗಾಗಿ ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯರ ಪೈಕಿ ಕಾರ್ಯದರ್ಶಿಗಳಾದ ನಡವಳಿಕೆಗಳು ಕಾರ್ಯಾಲಯದಲ್ಲಿ ಕಲಂ 13ರ ಅಡಿಯಲ್ಲಿ ದಾಖಲಾತಿಗಳು ಸಲ್ಲಿಸಿ ದಿನಾಂಕ 4/8/2011 ಸ್ವೀಕೃತಿ ಪಡೆಯಲಾಗಿದೆ. 13 ಜನ ಆಡಳಿತ ಮಂಡಳಿಯ ಸದಸ್ಯರ ಆಗಿರುತ್ತಾರೆ. ಇದನ್ನು ಪ್ರಶ್ನಿಸಿ ಸಲ್ಲಿಸಿರುವ ರಿಟ್ ಪಿಟಿಷನ್ 8468/11 ದಿನಾಂಕ 4/7/2012 ಆದೇಶ ಪ್ರಕಾರ ಅರ್ಜಿಯನ್ನು ಹಿಂಪಡೆಯ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಪುನಃ 27/1/2014 ರಿಟ್ ಅರ್ಜಿ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಕಲಬುರಗಿಯಲ್ಲಿ ದಿನಾಂಕ 6/2/2014 ರಿಟ್ ಸಂಖ್ಯೆ 20183014 ಇದನ್ನು ದಾಖಲು ಮಾಡಲಾಗಿದ್ದು ದಿನಾಂಕ 25/8/2013 ಕೈಗೊಂಡ ನಿರ್ಣಯ ಪ್ರಕಾರ ಆಡಳಿತ ಮಂಡಳಿ ಮೂಲ ಸದಸ್ಯರನ್ನು ಪರಿಗಣಿಸದೇ ಇರುವ ನಿರ್ಣಯ ತಡೆ ಇಡಲು ಮಾಡಿಕೊಂಡ ಮುಖ್ಯ ಅರ್ಜಿ ದಾಖಲಾತಿಗಳು ಈ ಕಚೇರಿ ಕಡತದಲ್ಲಿ ಲಭ್ಯವಿರುವುದಿಲ್ಲ. This is, my lords, 25/8/2013 is the resolution at Annexure G passed on behalf of the petitioners faction. ಶ್ರೀ ಸಂಜೋತ್ ಅವಧಿ ಇವರು ದಿನಾಂಕ 30/12/2022 ಪ್ರಕಾರ ದಿನಾಂಕ 25/5/2012 ಆದೇಶವನ್ನು ಹಾಜರುಪಡಿಸಿರುತ್ತಾರೆ. ದಿನಾಂಕ 20/2/2023 ಸಲ್ಲಿಸಿದ ತಮ್ಮ ಅರ್ಜಿಯಲ್ಲಿ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಕಲಬುರಗಿ ಇದರಲ್ಲಿ ದಾಖಲು ಇರುವ ರಿಟ್ ಅರ್ಜಿ ಇತ್ಯರ್ಥ ಆಗಿರುವವರೆಗೆ ವಿಚಾರಣೆ ಕಾಲಾವಕಾಶ ನೀಡಲು ಕೋರಿರುತ್ತಾರೆ. ಮುಂದುವರೆದು ದಿನಾಂಕ 6/3/2023 ಮೇಲೆ ತಿಳಿಸಿರುವ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶ ಹಾಗೂ ಅರ್ಜಿದಾರರ ಮೂಲ ದಾವಾ ಅರ್ಜಿಯನ್ನು ಈ ಕಾರ್ಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಿ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ತೀರ್ಪಿನಂತೆ ಹಾಗೂ ಆದೇಶದಂತೆ ತಮ್ಮ ಒಪ್ಪಿಗೆ ಸೂಚಿಸಿರುತ್ತಾರೆ. ಅಲ್ಲದೆ ಈ ಕಚೇರಿಯ ಪತ್ರ ದಿನಾಂಕ 30/12/2022 ನಿರ್ದೇಶನದಂತೆ ನವೀಕರಣ ಮಾಡಲು ಸಾಧ್ಯವಿಲ್ಲವೆಂದು ತಿಳಿಸಿದ ವಿಷಯವನ್ನು ಪ್ರಸ್ತಾಪಿಸಿರುತ್ತಾರೆ. ಹೀಗಾಗಿ ದಿನಾಂಕ 10/3/2023 ಜರುಗುವ ವಿಚಾರಣೆಗೆ ತಿಳಿಸಿದ ವಿಷಯದ ಪ್ರಸ್ತಾಪಿಸಿರುತ್ತಾರೆ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಸಂಪೂರ್ಣ ಕಡತದೊಂದಿಗೆ ಮಧ್ಯಾಹ್ನ 5 ಗಂಟೆಗೆ ಅರ್ಜಿದಾರರಾದ ಶ್ರೀ ನಾಗರಾಜ್ ಲಂಬು ಹಾಜರಾಗಲು ಒಪ್ಪಿಕೊಂಡ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಹಾಗೂ ಪ್ರಕರಣದ ವಿಚಾರಣೆಗೆ ಶ್ರೀ ರಾಜಶೇಖರ ಹೆಡಳಿ ತಂಡದ ಸದಸ್ಯರು ಸಲ್ಲಿಸಿರುವ ಲಿಖಿತ ಆಕ್ಷೇಪಣೆ ಕಡತಕ್ಕೆ ಸೇರಿಸಿಕೊಂಡು ಪ್ರಕರಣದ ವಿಚಾರಣೆಯನ್ನು ಮಧ್ಯಾಹ್ನ 5 ಗಂಟೆ ಮುಂದೂಡಲಾಯಿತು. ದಿನಾಂಕ 23 ಮುಂದೂಡಲ್ಪಟ್ಟ ವಿಚಾರಣೆಯನ್ನು ಮಧ್ಯಾಹ್ನ 5 ಗಂಟೆಗೆ ಕರೆಯಲಾಯಿತು. ಒಂದು ಗುಂಪಿನ ಮುಖ್ಯಸ್ಥರಾದ ಶ್ರೀ ರಾಜಶೇಖರ್ ಹೆಡಳಿ ಇವರು ಗುಂಪಿನಲ್ಲಿರುವ ಸಂಘದ ಸದಸ್ಯರಾದ ನಾಗರಾಜ್ ಲಂಬು ಇವರು ಮುಂದುವರೆದು ವಿಚಾರಣೆ ಹಾಜರಾಗಿರುತ್ತಾರೆ. ಅವರ ಹಾಜರಾತಿಗಳನ್ನು ಒಪ್ಪಿಕೊಳ್ಳಲಾಯಿತು. ಮುಂದುವರೆದು ವಿಚಾರಣೆಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಸಂಘದ ವಿರುದ್ಧ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಕಲಬುರಗಿ ಪೀಠದಲ್ಲಿ 2 ರಿಟ್ ಅರ್ಜಿ ಸಲ್ಲಿಸಲಾಗಿದ್ದು ಇದರಲ್ಲಿ 14 ಪ್ರತಿವಾದಿಗಳ ವಿರುದ್ಧ ದಾಖಲು ಮಾಡಿದ ಅರ್ಜಿಗಳ ವಿವರ ಈ ಕೆಳಕಾಣಿಸಿದ ರಿಟ್ ಅರ್ಜಿಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ದಾಖಲೆಗಳೊಂದಿಗೆ ಹೇಳಿಕೆ ಸಲ್ಲಿಸಿದರು. Then, my lords, at page 90, there is the next date of hearing dated 10/4/2023. Then was at page 91, it is in this, the first unnumbered paragraph.
Yes.
This is recorded there. ಈ ಪ್ರಕರಣದಲ್ಲಿ ತಮ್ಮನ್ನು ಒಳಗೊಂಡಂತೆ ಹಾಗೂ ನಮ್ಮ ಸಮಿತಿಯ 13 ಜನ ಮೇಲೆ ಅಧ್ಯಕ್ಷರು ಹಾಗೂ ನಿರ್ದೇಶಕ ಮಂಡಳಿಯ ಮೇಲೆ ರಿಟ್ ಇರುವುದರ ಪ್ರಯುಕ್ತ ನನ್ನ ಹೇಳಿಕೆ ಹೀಗಿದೆ. ಅಂದರೆ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯಕ್ಕೆ ನಾನು ಹೋಗಿ ರಿಟ್ ಪಿಟಿಷನ್ ಇತ್ಯರ್ಥ ಪಡೆದುಕೊಳ್ಳಲು ನಮಗೆ ಸಂಬಂಧಿಸಿದ ಅಧಿಕೃತ ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸುತ್ತೇನೆ. ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ನೀಡುವ ತೀರ್ಪಿಗೆ ಬದ್ಧನಾಗಿದ್ದೇನೆ. ಈ ಹಿಂದೆ ತಮ್ಮ ಕಾರ್ಯಾಲಯದಿಂದ ನನಗೆ 3 ನೋಟಿಸ್ಗಳು ತಾವು ನೀಡಿದ್ದು ಸರಿ ಅಷ್ಟೇ. ನೀವು ನಮ್ಮ ವಿರೋಧಿ ಬಣದ ಶ್ರೀ ನಾಗಪ್ಪ ಪುಂಡ್ಲಿಕ್ ಲಂಬು ಹಾಗೂ ಶ್ರೀ ಜಿತೇಂದ್ರ ಅಶೋಕ್ ಕಾಂಬ್ಳೆ ಹಾಗೂ ಅವರ ಬಣದವರ ಹೇಳಿಕೆಗಳನ್ನು ತಾವು ಪಡೆದುಕೊಂಡಿದ್ದನ್ನು ಇಂದು ತಾವು ಮೌಖಿಕವಾಗಿ ತಿಳಿಸಿದ್ದು ಸರಿ ಅಷ್ಟೇ. ನನ್ನ ಸಮಿತಿಯ ಈ ಹಿಂದೆ 2011-12ನೇ ಸಾಲಿನಲ್ಲಿ ಮೇಲ್ಕಾಣಿಸಿದ ಇರುವರು ವಿರೋಧಿಗಳು ನನ್ನ ಸಂಸ್ಥೆಯನ್ನು ಎತ್ತಿ ಹಾಕಿ ತಮ್ಮ ಕಚೇರಿಯಿಂದಲೇ ರಿನಿವಲ್ ಮಾಡಿಕೊಂಡಿದ್ದು, ಆ ಸಮಯದಲ್ಲಿಯೂ ರಿಟ್ ಪಿಟಿಷನ್ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ರಲ್ಲಿ ನ್ಯಾಯಾಲಯವು ಪ್ರಕರಣವನ್ನು ಕ್ವಾಶ್ ಇಂಪ್ಯೂನ್ಡ್ ಆದೇಶ ಮಾಡಿದ್ದನ್ನು ತಮ್ಮ ಗಮನಕ್ಕೆ ತರಬಯಸುತ್ತೇನೆ. ಈ ಪ್ರಕರಣವು ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಿಂದ ತೀರ್ಮಾನ ಆಗುವವರೆಗೆ ನಮ್ಮ ಸಂಸ್ಥೆಯ ವಿಚಾರಣೆಯನ್ನು ಮುಂದೂಡಲು ತಮ್ಮಲ್ಲಿ ವಿನಂತಿಸಿಕೊಳ್ಳುತ್ತೇನೆ. ತದನಂತರ ದಿನಮಾನಗಳಲ್ಲಿ ಸರ್ಕಾರದ ನಿಯಮಾನುಸಾರ ತಾವು ಕ್ರಮ ಕೈಗೊಳ್ಳಬಹುದಾಗಿದೆ ಅಂತ ನನ್ನ ಹೇಳಿ ಬರೆಸಿದ ವೈಯಕ್ತಿಕ ಹೇಳಿಕೆ. ನಾನು ಇಂದು ನಮ್ಮ ಇನ್ನುಳಿದ ಸದಸ್ಯರನ್ನು ನಾನು ಕರೆತಂದಿರುವುದಿಲ್ಲ. ಆದರೆ ನಾನು ಕಾನೂನು ಪ್ರಕಾರವಾಗಿ ಸಾಮಾನ್ಯ ಸಭೆ ಕರೆದು 2022-23ನೇ ಸಾಲಿಗೆ ನವೀಕರಣ ಮಾಡಿಕೊಳ್ಳಲು ತಮ್ಮಲ್ಲಿ ಇನ್ನೊಮ್ಮೆ ವಿನಂತಿಸಿಕೊಳ್ಳುತ್ತೇನೆ. Similarly, what the statements of several persons is taken. Then next page.
ವಿಚಾರಣೆ ನಿರ್ಣಯ.
I will read that. Vicharana Nirnaya. At page 91, my friend wants me to read the Vicharana Nirnaya. That's the ಬೌದ್ಧ ವಿಹಾರ ನಿರ್ಮಾಣ ಸಮಿತಿ ವಿಜಯಪುರ್ ಈ ಸಂಸ್ಥೆ ಕರ್ನಾಟಕ ಸಂಘಗಳ 60ರ ಅಡಿಯ ದಿನಾಂಕ 14/5/93ರಂದು ನೋಂದಾಯಿಸಲಾಗಿದೆ. ನೋಂದಣಿ ಸಂಖ್ಯೆ 45/9394 ಇರುತ್ತದೆ. ಸದರಿ ಸಂಘದ ನೋಂದಣಿ ಪ್ರಮಾಣ ಪತ್ರ ದಿನಾಂಕ 17/5/93ರಂದು ಸ್ವೀಕೃತಗೊಂಡಿರುತ್ತದೆ. 94-95ರಿಂದ 2005-6ನೇ ಸಾಲಿನ ಅವಧಿಯ ಮೇರೆಗೆ ಶ್ರೀ ಮಲ್ಲಪ್ಪ ಶಂಕರಪ್ಪ ಕೋಟ್ಯಾಳ್ಕರ್ ಇವರು ಕಾರ್ಯದರ್ಶಿಯಾಗಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಾರೆ. ಈ ಅವಧಿಯಲ್ಲಿ ಶ್ರೀ ಯಮನಪ್ಪ ಜಮ್ನಾಳ್, ಶ್ರೀ ಅಲ್ಲಪ್ಪ ಗುರಪ್ಪ ಅವಧಿ, ಶ್ರೀ ರಾಯಪ್ಪ ಅಲ್ಲಪ್ಪ ಅವಧಿ ಹಾಗೂ ಶ್ರೀ ಚಂದ್ರಶೇಖರ್ ಕಾತ್ಯಾನ್ ಇವರು ಅಧ್ಯಕ್ಷರಾಗಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಾರೆ. ಶ್ರೀ ಮಲ್ಲಪ್ಪ ಶಂಕರಪ್ಪ ಕೋಟ್ಯಾಳ್ರವರು ಇವರು ಮರಣ ಹೊಂದಿರುತ್ತಾರೆ. ವಿಚಾರಣೆ ಕಾಲಕ್ಕೆ ಮರಣ ಪ್ರಮಾಣ ಪತ್ರ ಪರಿಶೀಲಿಸಿ ಖಾತ್ರಿಪಡಿಸಿಕೊಳ್ಳಲಾಗಿದೆ. ಸಂಸ್ಥಾಪಕರ ಸದಸ್ಯರಾದ ಶ್ರೀ ಯಮನಪ್ಪ ಜಮ್ನಾಳ್, ಶ್ರೀ ಅಲ್ಲಪ್ಪ ಗುರಪ್ಪ ಅವಧಿ, ಶ್ರೀ ರಾಯಪ್ಪ ಅಲ್ಲಪ್ಪ ಅವಧಿ ಹಾಗೂ ಶ್ರೀ ಚಂದ್ರಶೇಖರ್ ಜಿ ಕ್ಯಾತನ್ ಇವರು ಕೂಡ ಮರಣ ಹೊಂದಿರುತ್ತಾರೆ. ಮರಣ ಪ್ರಮಾಣ ಪತ್ರ ಪರಿಶೀಲಿಸಿ ಖಾತ್ರಿಪಡಿಸಿಕೊಳ್ಳಲಾಗಿದೆ. ಸಂಸ್ಥಾಪಕ ಸದಸ್ಯರಾದ ಶ್ರೀ ಮಲ್ಲಪ್ಪ ಶಂಕರಪ್ಪ ಕೋಟ್ಯಾಳ್ಕರ್ ಇವರು ದಿನಾಂಕ 21/3/2006ರಂದು ಮರಣ ಹೊಂದಿರುತ್ತಾರೆ. 2006-7ನೇ ಸಾಲಿನಲ್ಲಿ ಸಂಘದ ಕಾರ್ಯದರ್ಶಿ ಇರುವ ಬಗ್ಗೆ ಇಲಾಖೆಗೆ ನವೀಕರಣ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವುದು ಕಾನೂನು ಬಾಹಿರವಾಗಿದೆ. 2006-7ರಿಂದ 10-11ನೇ ಸಾಲಿನ ಅವಧಿಯವರೆಗೆ ಕಾರ್ಯಕಾರಿ ಮಂಡಳಿ ಪಟ್ಟಿಗಳು ಹಾಗೂ ಸಂಘದ ಅಧಿಕೃತ ತಕ್ತೆಗಳು ಕರ್ನಾಟಕ ಸಂಘದ 60 ಕಲಂ 13ರ ಪ್ರಕಾರ ಕಾನೂನು ಬಾಹಿರವಾಗಿ ನವೀಕರಣ ಅರ್ಜಿ ಸಲ್ಲಿಸಿ ದಿನಾಂಕ 21/1/2021ರಂದು ಸ್ವೀಕೃತ ಪಡೆಯಲಾಗಿದೆ. 11-12ನೇ ಸಾಲಿನ ನವೀಕರಣ ಅರ್ಜಿ ಪರಿಶೀಲಿಸಿ ದಿನಾಂಕ 4/5/2011ರಂದು ಸ್ವೀಕೃತಿ ನೀಡಲಾಗಿದೆ. ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿ ಯಾದಿ ಹಾಗೂ ಸಂಘದ ಆರ್ಥಿಕ ತಕ್ತೆಗಳು ಕಡತಕ್ಕೆ ಸೇರಿಸಿಕೊಂಡು ಪ್ರಾಧಿಕಾರದಿಂದ ಸ್ವೀಕೃತಿ ನೀಡಿರುವ ಕುರಿತು ತಕರಾರು ಇರುತ್ತದೆ. 11-12ನೇ ಸಾಲಿನ ಒಂದು ತಂಡದ ಸ್ವೀಕೃತಿ ಪತ್ರ ದಿನಾಂಕ 4/5/2011 ತನ್ನಿಂದ ತಾನೇ ರದ್ದಾಗಿದೆ ಎಂದು ಭಾವಿಸಿಕೊಂಡು 11-12ರಿಂದ 13-14ನೇ ಸಾಲಿನ ಅವಧಿಗಾಗಿ ಪ್ರಾಧಿಕಾರದಿಂದ 11-11/2013ರಂದು ಕಾನೂನು ಬಾಹಿರವಾಗಿ ಸ್ವೀಕೃತಿ ಪಡೆಯಲಾಗಿದೆ. ಸದರಿ ಅವಧಿಯಲ್ಲಿ ಶ್ರೀ ಚಂದ್ರಶೇಖರ್ ಜಿ ಕ್ಯಾತನ್ ಮತ್ತು ಸಂತೋಷ್ ರಾಯಪ್ಪ ಅವಧಿ ಇವರು ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯರಾಗಿರುತ್ತಾರೆ. ಇವರು ಕೈಗೊಂಡ ಕಾನೂನು ಬಾಹಿರ ನಡವಳಿಕೆ ಹಾಗೂ ಪ್ರಾಧಿಕಾರವು ಹೊರಡಿಸಿರುವ ಸ್ವೀಕೃತಿ ಪ್ರಶ್ನಿಸಿ ಹಾಗೂ ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿ ವಿರುದ್ಧ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಕಲಬುರಗಿ ಇದರಲ್ಲಿ ರಿಟ್ ಸಂಖ್ಯೆ 8468/11 ದಿನಾಂಕ 4/2/2012ರಂದು ಅರ್ಜಿದಾರರು ಶ್ರೀ ಜಿತೇಂದ್ರ ಕಾಂಬ್ಳೆ ಹಾಗೂ ಶ್ರೀ ನಾಗರಾಜ್ ಲಂಬು ಇವರು ತಕರಾರು ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಉದ್ಭವಿಸಿರುವ ತಕರಾರು ಅರ್ಜಿಯನ್ನು ಮರುಪರಿಶೀಲಿಸಿ ಸದರಿ ಸಂಘವು ದಿನಾಂಕ 25/8/2013ರಂದು ಕೈಗೊಂಡ ನಡವಳಿಕೆಗಳು ಕಾನೂನು ಬಾಹಿರವೆಂದು ತಿಳಿದುಕೊಂಡು ರಿಟ್ ಅರ್ಜಿ ಸಂಖ್ಯೆ 8468/11 ಇದನ್ನು ದಿನಾಂಕ 21/7/2014ರಂದು ಸ್ವಹಿತಾಸಕ್ತಿಯಿಂದ ತಕರಾರು ಅರ್ಜಿಯನ್ನು ಅರ್ಜಿದಾರರು ಹಿಂಪಡೆದಿರುತ್ತಾರೆ. ಪುನಃ ಮಾನ್ಯ ಕಲಬುರಗಿ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸದರಿ ಅರ್ಜಿದಾರ ರಿಟ್ ಸಂಖ್ಯೆ 201830 ದಿನಾಂಕ 6/2/2014 ಹೊಸದಾಗಿ ತಕರಾರು ಅರ್ಜಿ ದಾಖಲು ಮಾಡಿರುತ್ತಾರೆ. ಸದರಿ ರಿಟ್ ಅರ್ಜಿ ಅಂತಿಮ ನಿರ್ಣಯಕ್ಕಾಗಿ 10/4/23 ಅಂತ್ಯಕ್ಕೆ ಬಾಕಿ ಇರುತ್ತದೆ. ಶ್ರೀ ದಶವಂತ್ ಗುನಾಪುರ್ ಹಾಗೂ ಇತರರು ಸಲ್ಲಿಸಿರುವ ತಕರಾರು ಮುಖ್ಯ ಅರ್ಜಿ ಅಂಶಗಳ ಕುರಿತು ದಿನಾಂಕ ಅವಧಿಯಲ್ಲಿ ಕಲಂ 25 ಅಡಿಯಲ್ಲಿ ಜರುಗಿಸಿದ ಶಾಸನಬದ್ಧ ವಿಚಾರಣೆ ಕಾಲಕ್ಕೆ ಸಂಘದ ಎರಡೂ ಗುಂಪಿನ ಸದಸ್ಯರ ಲಿಖಿತ ಹೇಳಿಕೆ ಮತ್ತು ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಕಡತಕ್ಕೆ ಸೇರಿಸಲಾಗಿದೆ. ಸಂಸ್ಥಾಪಕರ ಸದಸ್ಯರಾದ ಶ್ರೀ ಮಲ್ಲಪ್ಪ ಶಂಕರಪ್ಪ ಕೋಟ್ಯಾಳ್ಕರ್ ಇವರು ದಿನಾಂಕ 21/3/2006 ಮರಣ ಹೊಂದಿರುತ್ತಾರೆ. 2006-7ನೇ ಸಾಲಿನ ಸಂಘದ ಕಾರ್ಯದರ್ಶಿಯಾಗಿ ಆಯ್ಕೆಯಾಗಿರುವುದು ಕಾನೂನು ಬಾಹಿರವಾಗಿದೆ. 2015-16ರಿಂದ 22-23 ಸಾಲಿನ 8 ವರ್ಷಗಳ ಅವಧಿಯಲ್ಲಿ ಆಯ್ಕೆಯಾದ ಆಡಳಿತ ಮಂಡಳಿ ಯಾದಿಯಲ್ಲಿ ಕಾಣಿಸಿದ ಸದಸ್ಯರಾದ ಶ್ರೀ ಚಂದ್ರಶೇಖರ್ ಕ್ಯಾತನ್ ಇವರು ದಿನಾಂಕ 7/7/2015 ಮತ್ತು ಶ್ರೀ ಕೃಷ್ಣ ಪಡಳ್ಳಿ ಇವರು 21/10/2020 ಹಾಗೂ ಶ್ರೀ ಕೆ ಬಸಣ್ಣ ಚಲವಾದಿ ಇವರು 12/12/19 ಮೃತರಾಗಿರುತ್ತಾರೆ. ಸದರಿ ವ್ಯಕ್ತಿಗಳು ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿಯ ಸದಸ್ಯರನ್ನಾಗಿ ಆಯ್ಕೆ ಮಾಡಿದಂತೆ ಪ್ರತಿ ವರ್ಷದ ಆಡಳಿತ ಮಂಡಳಿಯ ಸದಸ್ಯರ ಯಾದಿಗಳು ಹಾಗೂ ಸಂಘದ ಆರ್ಥಿಕ ತಕ್ತೆಗಳು ತಯಾರಿಸಿ ಶ್ರೀ ಮಹೇಶ್ ಕ್ಯಾತನ್ ಹಾಗೂ ಸಂಜೋತ್ ಅವಧಿ ಇವರು ದಿನಾಂಕ 30/12/2022 ನವೀಕರಣ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಮಾನ್ಯ ಸಹಕಾರ ಸಂಘಗಳ ನಿಬಂಧಕರು ಬೆಂಗಳೂರು ಇವರ ಸುತ್ತೋಲೆ ದಿನಾಂಕ 19/5/2021 ಅವಕಾಶದಂತೆ ನವೀಕರಣ ಅರ್ಜಿ ಸಲ್ಲಿಸಲಾಗಿದ್ದು ಪರಿಶೀಲಿಸಲಾಗಿದೆ. ಸದರಿ ನವೀಕರಣ ಅರ್ಜಿಯ ತಕರಾರು ಕುರಿತು ಶ್ರೀ ದಶವಂತ್ ಗುನಾಪುರ್ ಹಾಗೂ ಇತರ 19 ಜನ ಸದಸ್ಯರು ದಿನಾಂಕ 7/2/23 ತಕರಾರು ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಇದಲ್ಲದೆ ಸದರಿ ಸಂಘದ ಅರ್ಜಿದಾರರಾದ ಶ್ರೀ ರಾಜಶೇಖರ್ ಯಡಳ್ಳಿ ಇವರು ನವೀಕರಣ ಅರ್ಜಿಯನ್ನು 27/12/22 ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ದಿನಾಂಕ 30/12/2022 ಸಲ್ಲಿಸಿರುವ ನವೀಕರಣ ಅರ್ಜಿ ಕುರಿತು ತಕರಾರು ಅರ್ಜಿ ಅಂಶಗಳ ನಿಯಮಾನುಸಾರ ಪರಿಶೀಲಿಸಿ ಅವಶ್ಯಕವಾಗಿ ಅರ್ಜಿದಾರರ ಕೋರಿಕೆಯನ್ನು ಶಾಸನಬದ್ಧ ವಿಚಾರಣೆ ಕೈಗೊಳ್ಳಲು ತೀರ್ಮಾನಿಸಲಾಯಿತು. ದಿನಾಂಕ 21/2/23 ವಿಚಾರಣೆ ಜರುಗಿಸಲು ಉಭಯ ತಂಡದ ಸದಸ್ಯರಿಗೆ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಿ ಸ್ವೀಕೃತಿ ನಿಯಮಾನುಸಾರ ಪಡೆದು ದಿನಾಂಕ 21/2/23 10/4/23 ವಿಚಾರಣೆಯನ್ನು ಜರುಗಿಸಲಾಯಿತು. ಕೈಗೊಂಡ ವಿಚಾರಣೆ ಕಾಲಕ್ಕೆ ಉಭಯ ತಂಡದ ಸದಸ್ಯರು ವಿಚಾರಣೆಗೆ ಗೊತ್ತುಪಡಿಸಿದ ದಿನಾಂಕಗಳಂದು ಹಾಜರಾಗಿ ತಮ್ಮ ಹೇಳಿಕೆಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಅವರು ಸಲ್ಲಿಸಿರುವ ಹೇಳಿಕೆಯನ್ನು ವಿಚಾರಣೆ ಕಾಲಕ್ಕೆ ದಾಖಲು ಮಾಡಿಕೊಂಡು ಪೂರಕ ದಾಖಲಾತಿಗಳ ಕಡತಕ್ಕೆ ಸೇರಿಸಿಕೊಳ್ಳಲಾಗಿದೆ. ಎರಡೂ ಗುಂಪುಗಳ ಉಭಯ ತಂಡದ ಮುಖ್ಯಸ್ಥರು ಸಲ್ಲಿಸಿರುವ ಹೇಳಿಕೆ ಹಾಗೂ ದಾಖಲಾತಿಗಳು ಪರಿಶೀಲಿಸಿ ಸಂಸ್ಥಾಪಕರಾದ ಸದಸ್ಯರಾದ ಶ್ರೀ ಸಾಬು ಚಲವಾದಿ ಮತ್ತು ಶ್ರೀ ದಶವಂತ್ ಗುನಾಪುರ್ ಇವರ ಹೇಳಿಕೆಯನ್ನು ಮುಖ್ಯ ಸಾಕ್ಷಿದಾರರನ್ನಾಗಿ ಪರಿಗಣಿಸಿ ಹೇಳಿಕೆ ಪಡೆಯಲಾಯಿತು. ಅದರ ಹೇಳಿಕೆ ಮತ್ತು ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಸಂಘದ ಮೂಲ ದಾಖಲೆಗಳು ಶ್ರೀ ರಾಜಶೇಖರ್ ಯಡಳ್ಳಿ ಇವರ ತಂಡದ ಸದಸ್ಯರ ಸ್ವಾಧೀನದಲ್ಲಿ ಲಭ್ಯವಿರುತ್ತದೆ. ವಿಚಾರಣೆ ಕಾಲಕ್ಕೆ ಹಾಜರುಪಡಿಸಿರುತ್ತಾರೆ. ದಾಖಲಾತಿಗಳು ಪರಿಶೀಲಿಸಿ ದೃಢೀಕರಿಸಿ ಪರಿಶೀಲಿಸಲಾಗಿದೆ. ಸಂಘದ ಸ್ಥಿರಾಸ್ತಿ ಮೂಲ ದಾಖಲಾತಿಗಳು, ಆಸ್ತಿ ಖರೀದಿ ಪತ್ರ, ಸಂಘದ ಸ್ಥಿರಾಸ್ತಿಗಳ ಬಾಡಿಗೆ ವ್ಯವಹಾರ ಹಾಗೂ ಕಟ್ಟಡದ ದುರುಪಯೋಗ ಹಾಗೂ ಸದುಪಯೋಗ ಹಾಗೂ ಸರ್ಕಾರದ ಅನುದಾನದಲ್ಲಿ ಬೌದ್ಧ ವಿಹಾರ, ವಸತಿ ಗೃಹಗಳು, ಶೌಚಾಲಯಗಳು, ಕೋಣೆಗಳು, ವಾಣಿಜ್ಯ ಮಳಿಗೆಗಳು, ಬೌದ್ಧ ಬಿಕ್ಕು ಉಪಾಸಕರ ವಿಶ್ರಾಂತಿ ಕೋಣೆಗಳು, ವಿಹಾರದ ಮುಖ್ಯದ್ವಾರ ಹಾಗೂ ಪೀಠೋಪಕರಣಗಳು ಸಂಘದ ಉದ್ದೇಶಗಳ ಪ್ರಕಾರ ಪ್ರತಿ ವರ್ಷ ಕಾಲಕಾಲಕ್ಕೆ ಕೈಗೊಂಡ ಧಾರ್ಮಿಕ ಚಟುವಟಿಕೆಗಳು, ಸಭೆ ಸಮಾರಂಭಗಳು ಹಾಗೂ ದಾನಿಗಳಿಂದ ಪಡೆದ ಅನುದಾನ, ಚೆಕ್, ಬ್ಯಾಂಕಿನ ಸಂದಾಯ ಮಾಡಿರುವ ದಾಖಲೆ, ಸಮಾಜದ ಗಣ್ಯರಾದ ಶ್ರೀ ಬಸವರಾಜ್ ಆಕಾಶ್ ಇವರ ಆರ್ಥಿಕ ನೆರವು, ಮಾಲ್ಬಾಗಾಯತ್ ಸರ್ವೆ ನಂಬರ್ 890, 891 1 ಎಕರೆ 5 ಗುಂಟೆ ಜಾಗವನ್ನು ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ದಿನಾಂಕ 27/2/96 ಪ್ರಕಾರ ದಾನಿಗಳಿಂದ ಪಡೆದ ಮೊತ್ತ 1,48,500 ರೂಪಾಯಿ ಸರ್ಕಾರಕ್ಕೆ ಸಂದಾಯ ಮಾಡಿ ಸಂಘದ ಹೆಸರಿಗೆ ಸ್ಥಿರಾಸ್ತಿಯನ್ನು ದಿನಾಂಕ 11/10/97 ನೋಂದಣಿ ಮಾಡಲಾಗಿದೆ. ದಾನಿಗಳಾದ ಶ್ರೀ ಬಸವರಾಜ್ ಆಕಾಶ್ ಇವರು ಸ್ಥಿರಾಸ್ತಿ ಖರೀದಿಸುವ ಸಲ್ಲಿಸುವ ಮೊತ್ತ ಲೆಕ್ಕಕ್ಕೆ ತೆಗೆದುಕೊಳ್ಳಲಾಗಿದೆ. ಶ್ರೀ ಸಾರಿಪುತ್ರ ಬಂತೆಜೆ ಮಹಾರಾಷ್ಟ್ರ, ಶ್ರೀ ಬೋಧಿ ಧಮ್ಮ ಬಂತೆಜೆ ಜಪಾನ್ ಇವರು ಧಾರ್ಮಿಕ ಧಮ್ಮ ದೀಕ್ಷೆ ರೂಪದಲ್ಲಿ ಧರ್ಮದ ವಿಚಾರಕ್ಕಾಗಿ ಧರ್ಮಶಾಲೆ, ದೊಡ್ಡ ಕೋಣೆ ಹಾಗೂ ಕಟ್ಟಡದ ಮೇಲಂತಸ್ತುಗಳ ಲೋಕಸಭಾ ಸದಸ್ಯರಾದ ಶ್ರೀ ಬಸವರಾಜ್ ಪಾಟೀಲ್ ಯಾತ್ನಾಳ್ ಇವರು ಅನುದಾನದಿಂದ ಕಟ್ಟಡಗಳು ನಿರ್ಮಾಣ ಮಾಡಲಾಗಿದೆ. ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯರಾದ ಶ್ರೀ ರಾಜಶೇಖರ್ ಯಡಹಳ್ಳಿ, ಶ್ರೀ ಶಶಿಕಾಂತ್ ಹೊನ್ವಾಡ್ಕರ್ ಇವರ ಮುಂದಾಳತ್ವದಲ್ಲಿ ಶಾಸಕರಾದ ಶ್ರೀ ರಾಜು ಅಲ್ಗೂರ್ ಹಾಗೂ ಸಚಿವರಾದ ಶ್ರೀ MB ಪಾಟೀಲ್ ಇವರ ಅವಧಿಯಲ್ಲಿ ಲಭ್ಯವಿರುವ ಅನುದಾನದಲ್ಲಿ ಐತಿಹಾಸಿಕ ಬೌದ್ಧ ವಿಹಾರ ಕಟ್ಟಡವನ್ನು ಲೋಕಾರ್ಪಣೆಗೊಳಿಸಲಾಗಿದೆ. ಈ ಕಟ್ಟಡದ ಸದ್ಬಳಕೆ ಕುರಿತು ಸದಸ್ಯರಲ್ಲಿ ಗೊಂದಲ ಇರುವುದು ದಾಖಲೆಯಿಂದ ಸ್ಥಿರಪಟ್ಟಿದೆ. ಸಂಘದಲ್ಲಿ 2 ಗುಂಪುಗಳು ಇರುವುದರಿಂದ ಒಟ್ಟು ಸದಸ್ಯರ ಸಂಖ್ಯಾಬಲ ನಿರ್ಧರಿಸಲು ಸನ್ 23-24ನೇ ಸಾಲಿನ ಸಾಮಾನ್ಯ ಸಭೆ ನಿಯಮಾನುಸಾರ ಜರುಗಿಸಿ ಸಭೆಯಲ್ಲಿ 2 ಗುಂಪಿನ ಎಲ್ಲಾ ಸದಸ್ಯರು ಒಳಗೊಂಡು ಸಾಮಾನ್ಯ ಸಭೆಯನ್ನು ಸ್ಪಷ್ಟ 21 ದಿವಸಗಳ ನೋಟಿಸ್ ಅನ್ನು ನೀಡಿ ಸದರಿ ಸಭೆಯಲ್ಲಿ ಅವಶ್ಯವಿದ್ದಲ್ಲಿ ಚುನಾವಣೆ ಮೂಲಕ ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯರ ಆಯ್ಕೆ ಪ್ರಕ್ರಿಯೆಯು ಚುನಾವಣಾ ಪದ್ಧತಿ ಅನುಸರಿಸಿ ಸಭೆಯ ನಂತರ 14 ದಿನಗಳೊಳಗಾಗಿ ಕಚೇರಿ ಕಡತಕ್ಕೆ ದಾಖಲಾತಿಗಳು ನಿಯಮ 13ರ ಪ್ರಕಾರ ಸಲ್ಲಿಸಲು ಪ್ರತ್ಯೇಕ ನಿರ್ದೇಶನ ನೀಡಲು ತೀರ್ಮಾನಿಸಿತ್ತು. ಸಂಘದ ಸ್ಥಿರಾಸ್ತಿಗಳ ಪೈಕಿ 8 ವಾಣಿಜ್ಯ ಮಳಿಗೆಗಳು ಸಂಘದ ಉದ್ದೇಶಗಳಿಗಾಗಿ ಬಳಸಿಕೊಳ್ಳದೆ ಇರುವುದು ಹಾಗೂ 2 ತಂಡದ ಸದಸ್ಯರು ಕಟ್ಟಡಗಳ ಆದಾಯದ ಸದುಪಯೋಗ ಪಡಿಸಿಕೊಳ್ಳದೆ ಇರುವುದು ದೂರು ಅಂಶಗಳ ಹೇಳಿಕೆಯಿಂದ ಸಾಬೀತಾಗಿರುತ್ತದೆ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಕೂಡಲೇ ಸನ್ 23-24ನೇ ಸಾಲಿನಿಂದ ಸಂಘ 8 ವಾಣಿಜ್ಯ ಮಳಿಗೆಗಳ ಸದುಪಯೋಗ ಪಡಿಸಿಕೊಳ್ಳಲು ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯರು ಜವಾಬ್ದಾರರು ಎಂದು ಅಭಿಪ್ರಾಯಿಸಲಾಗಿದೆ. ಆದ್ದರಿಂದ
ಬ್ಲಾಂಕ್ ಆದ್ದರಿಂದ ಬ್ಲಾಂಕ್
ಇಲ್ಲ at page 20
ಇಲ್ಲ ಅದು ಪೇಜ್ ರೀಡ್ ಪೆಟಿಷನ್ ಜೊತೆಗೆ ಲಗತ್ತಿಸಿಲ್ಲ. ಹಚ್ಚೇ ಇಲ್ಲ ಪೇಜ್.
with the statement of objection ಅಲ್ಲಿ
it is filed
ನಾವು along with my statement of objection I have filed.
along with the statement. Page 20 of the statement of respondent number 3.
R1 last page one.
ಆದ್ದರಿಂದ ನಿಯಮಾನುಸಾರ ಕೂಡಲೇ ಸಂಘದ 8 ವಾಣಿಜ್ಯ ಮಳಿಗೆಗಳ ಕುರಿತು ನಿಯಮಾನುಸಾರ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯರು ಕ್ರಮ ಜರುಗಿಸದೆ ಇದ್ದಲ್ಲಿ ಪ್ರಾಧಿಕಾರವು ಹೊರಡಿಸುವ ನಿರ್ದೇಶನ ಉಲ್ಲಂಘನೆ ಪಟ್ಟಲ್ಲಿ ಕಲಂ 28ರ ಕ್ರಮಗಳು ನೋಟಿಸ್ ಇಲ್ಲದೆ ಜಾರಿಗೊಳಿಸಲು ಪ್ರಾಧಿಕಾರವು ಸ್ವತಂತ್ರವೆಂದು ಅಭಿಪ್ರಾಯಿಸಲಾಯಿತು. ಸನ್ 14-15ನೇ ಸಾಲಿನ ಅವಧಿಯವರೆಗೆ ಪ್ರಾಧಿಕಾರದ ಕಲಂ 13ರ ಪ್ರಕಾರ ಸ್ವೀಕೃತಿ ನೀಡಿರುತ್ತದೆ. ಪ್ರಾಧಿಕಾರವು ಈಗಾಗಲೇ ಒಪ್ಪಿಕೊಂಡ ಕ್ರಮಗಳ ತೀರ್ಮಾನಕ್ಕೆ ಒಳಪಟ್ಟು ಹಾಗೂ ಸದರಿ ಅವಧಿ ಪೂರ್ಣಗೊಂಡ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದರಿ ಅವಧಿ ಕುರಿತು ಮಾನ್ಯ ಕಲಬುರಗಿ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ರಿಟ್ ಸಂಖ್ಯೆ 20183014ರ ತೀರ್ಮಾನಕ್ಕೆ ಒಳಪಟ್ಟು ಪ್ರಕರಣವನ್ನು ಕೈ ಬಿಡಲು ತೀರ್ಮಾನಿಸಲಾಗಿದೆ. ಸನ್ 15-16ರಿಂದ 22-23ನೇ ಸಾಲಿನ ಅವಧಿಗಾಗಿ ಶ್ರೀ ರಾಜಶೇಖರ್ ಯಡಹಳ್ಳಿ ಇವರು ಸಲ್ಲಿಸಿರುವ ನವೀಕರಣ ಅರ್ಜಿ ನಿಯಮಾನುಸಾರ ಇರುವುದು ದೃಢಪಟ್ಟಿದೆ. ಸದರಿ ಅವರು ಸಲ್ಲಿಸಿರುವ ನವೀಕರಣ ಅರ್ಜಿಯನ್ನು ಮಾನ್ಯ ಸಹಕಾರ ಸಂಘಗಳ ನಿಬಂಧಕರು ಬೆಂಗಳೂರು ಇವರ ಸುತ್ತೋಲೆ ಸಂಖ್ಯೆ 19/5/21ರ ಪ್ರಕಾರ ದಾಖಲಾತಿಗಳು ಕಡತಕ್ಕೆ ಸೇರಿಸಿಕೊಳ್ಳಲು ಅಭಿಪ್ರಾಯಿಸಲಾಗಿದೆ. ಹಾಗೂ ಶ್ರೀ ಮಹೇಶ್ ಕ್ಯಾತನ್ ಇವರು ತಪ್ಪು ದಾಖಲಾತಿ ಸಲ್ಲಿಸಿರುವುದು ಕಲಂ 28ರ ಕ್ರಮಕ್ಕೆ ಪ್ರಾಧಿಕಾರವು ತೀರ್ಮಾನಿಸಿ ಪ್ರಾಧಿಕಾರವು ಅವರ ನವೀಕರಣ ಅರ್ಜಿಯನ್ನು ನಿಯಮಾನುಸಾರ ವಿಲೇವಾರಿ ಮಾಡಲು ಹಾಗೂ ಹಿಂಬರಹ ನೀಡಲು ಅಭಿಪ್ರಾಯಿಸಿ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಕಲಬುರಗಿ ಇದರಲ್ಲಿ ಇರುವ ರಿಟ್ ಸಂಖ್ಯೆ ಸೋ ಇದರ ಮುಂದಿನ ತೀರ್ಪಿಗೆ ಒಳಪಟ್ಟು ನಿಯಮಾನುಸಾರ ಇರುವ ನವೀಕರಣ ಅರ್ಜಿ ದಿನಾಂಕ 27/12/2022ರ ಇದರ ಸಂಪೂರ್ಣ ದಾಖಲಾತಿಗಳ ಕಡತಕ್ಕೆ ಸೇರಿಸಿಕೊಂಡು 15-16ನೇ ಸಾಲಿನಿಂದ 22-23ನೇ ಸಾಲಿನ ಆಡಳಿತ ಮಂಡಳಿ ಯಾದಿಗಳು ಹಾಗೂ ಆರ್ಥಿಕ ತಥ್ಯಗಳು ಅನುಮೋದಿಸಲು ಹಾಗೂ ಶ್ರೀ ರಾಜಶೇಖರ್ ಯಡಹಳ್ಳಿ ಇವರ ಅರ್ಜಿಯನ್ನು ಇತ್ಯರ್ಥಪಡಿಸಲು ವರದಿಸಲಾಗಿದೆ. There are 2 things are absent in this. So
Annexure W ಏನಾಯ್ತು?
Annexure W is the consequent renewal. Annexure W, this says Karnataka ಸಂಘಗಳ ಕಲಂ 13ರ ಪ್ರಕಾರ
It is the order, my lord, after issuance of registration.
Consequent order with 2 conditions imposed thereon.
The 2 conditions.
I will read that portion also, the operative portion. ಕರ್ನಾಟಕ ಸಂಘಗಳ ಕಾಯ್ದೆ 60ರ ಕಲಂ 13ರ ಪ್ರಕಾರ ಬೌದ್ಧ ನಿರ್ಮಾಣ ಬೌದ್ಧ ವಿಹಾರ ನಿರ್ಮಾಣ ಸಮಿತಿ ವಿಜಯಪುರ ಸಂಗೊಳ್ಳಿ ರಾಯಣ್ಣ ಕಾಲೋನಿ ಬಾಗಲಕೋಟ್ ರಸ್ತೆ ವಿಜಯಪುರ ಇವರ ಶಾಸನಬದ್ಧ ಕಲಂ 25 ವಿಚಾರಣೆ ವರದಿಯನ್ನು ಆಧರಿಸಿ ಸಂಘದ ಸನ್ 14-15ನೇ ರಿಂದ 21-22ನೇ ಸಾಲಿನ ಸಲ್ಲಿಸಿದ ಆರ್ಥಿಕ ತಕ್ತೆಗಳು ಹಾಗೂ ಸನ್ 15-16 ರಿಂದ 22-23ನೇ ಸಾಲಿಗಾಗಿ ಕಾರ್ಯಕಾರಿ ಮಂಡಳಿ ಪಟ್ಟಿಯನ್ನು ನಿಯಮ 13ರ ಪ್ರಕಾರ ದಿನಾಂಕ 27-12-2022 ಸಲ್ಲಿಸಿರುವ ದಾಖಲಾತಿಗಳು ಮಾನ್ಯ ಸಹಕಾರ ಸಂಘಗಳ ನಿಬಂಧಕರು ಬೆಂಗಳೂರು ಇವರು ಸುತ್ತೋಲೆ ಸಂಖ್ಯೆ ದಿನಾಂಕ 19/5/21 ಪ್ರಕಾರ ಸಂಘವು ಸಲ್ಲಿಸಿರುವ ನವೀಕರಣ ಫೀ 19,900 ರೂಪಾಯಿ ದಿನಾಂಕ 31/12/22 ಒಳಗೊಂಡು ಸ್ವೀಕರಿಸಿ ಕಡತಕ್ಕೆ ಸೇರಿಸಿಕೊಂಡು ಈ ಕೆಳಕಾಣಿಸಿದ ಷರತ್ತುಗಳಿಗೆ ಒಳಪಟ್ಟು ಅನುಮೋದಿಸಿ ಸ್ವೀಕೃತಿಯನ್ನು ಇಂದು ದಿನಾಂಕ 13/4/23 ನೀಡಲಾಗಿದೆ. ಕಂಡೀಷನ್ ನಂಬರ್ 1 and 2 is ಸಂಘದ ವಿಚಾರಣೆ ಕಾಲಕ್ಕೆ ಕಡತಗಳ ಸದುಪಯೋಗ ಪಡಿಸಿಕೊಳ್ಳದೆ ಇರುವುದು ದೃಢಪಟ್ಟಿದ್ದು ಸನ್ 23-24ನೇ ಸಾಲಿನಿಂದ ನಿಯಮಾನುಸಾರ ಸಾಮಾನ್ಯ ಸಭೆ ಜರುಗಿಸಿ ಸಂಘದ ಕಡತಗಳ ಸದ್ಬಳಕೆ ಹಾಗೂ ವಾಣಿಜ್ಯ ಮಳಿಗೆಗಳ ನಿರ್ವಹಣೆಯ ಆದಾಯ ವೆಚ್ಚಗಳ ಬಗ್ಗೆ ಕ್ರಮ ಕೈಗೊಳ್ಳುವುದು. ನಂಬರ್ 2 is ಸಂಘದ ಸದಸ್ಯರಲ್ಲಿ 2 ಬಣಗಳಾಗಿದ್ದು ಕೂಡಲೇ ಸನ್ 23-24ನೇ ಸಾಲಿನ ಸಾಮಾನ್ಯ ಸಭೆಯಲ್ಲಿ ಎಲ್ಲಾ ಸದಸ್ಯರನ್ನು ಒಳಗೊಂಡು ಪ್ರಾಧಿಕಾರವು ಸೂಚಿಸಿರುವ ನಿರ್ದೇಶನ ದಿನಾಂಕ 6/2/12 ಪ್ರಕಾರ ನಿಯಮಾನುಸಾರ ಆಡಳಿತ ಮಂಡಳಿಯ ರಚನೆ ಮಾಡಿಕೊಂಡು ಸಭೆಯ ನಿರ್ಣಯದ ಪ್ರಕಾರ ನಿಗದಿತ ಅವಧಿಯೊಳಗಾಗಿ ಒಟ್ಟು ಸದಸ್ಯರ ಯಾದಿಯೊಂದಿಗೆ ನವೀಕರಣ ಅರ್ಜಿ ಸಲ್ಲಿಸುವುದು.
Yes. Yes, what about your membership? When was that restored? How was it restored?
Not.
How was the membership of this Nagappa restored?
Lord, my membership is in the before registration only, page number 15. This 15, my lord.
Enquiry challenge ಮಾಡಿದ್ರಲ್ಲ?
Yes, my lord.
Challenge ಮಾಡಿ withdraw ಮಾಡ್ಕೊಂಬಿಟ್ರು.
No, because my lord, that yes, my lord. My in that also, my lord, both have filed a report. My report has been rejected and their report has been accepted. And further, there is a direction is given by the authority to hold an, my lord, inquiry under the to hold a meeting in every year. Thereafter, my lord, since from 2014 to 22, no meeting was held, nothing, my lord. Simply because and nobody has filed a report, audit report, or, my lord, renewal of the license. Because of this pendency of the writ petition, and they have filed now this impugned order, my lord, it was accepted since from the year 2014-15 to 22-22. My lord. Last 4 years, they have also filed a report and these my lord report.
First name ನಾಗಪ್ಪ
Yes.
ಹೆಂಗೆ ಮೆಂಬರ್ ಆದ್ರು ಅಂತ ಹೇಳಿ.
My lord, Nagappa became member in the, my lord, when this was registered, page number 15. Your lordship may kindly see his name found in, my lord, serial number 2. 15, my lord. In the writ petition itself, they have produced
50
15, my lord, 15.
ನಮ್ಮಲ್ಲಿ 17 ಠರಾವು ನಂಬರ್ 1.
15 ಅಲ್ಲಿ
serial number 2 ಇದೆ Nagappa Pundlik Lambu. This name, my lord, they have what they stated that this
15 ಲೇನು ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ.
ಇಲ್ಲಿ ನನ್ನ ಅಲ್ಲ
17 ಸ್ವಾಮಿ.
sorry, my lord, there what
17 ನಲ್ಲಿ
ನಾಗಪ್ಪ ಪುಂಡ್ಲಿಕ್
ಹಾ, ಇದು ಏನಾಗಿದೆ ಸ್ವಾಮಿ, ಮುಂಚೆ this some other person, my lord, wanted to become a member. Now thereafter, my lord, he what they say that he don't want to become member, hence his name is coded up and my name is entered, and this was submitted for registration. It is not that, my lord, after registration we have scored up. This is the same, my lord, list has been submitted to the registration and that has been registered.
Whether some this Buddha Vihar is constructed or not.
Yes.
Yes, it is there, my
It
lord.
is constructed by the petitioner's faction, my lord, and funds have been received. That is utilized also.
Why don't you sit and put your heads together and it is some ಯಾವುದೋ ಒಂದು ಬೌದ್ಧನಲ್ಲೇ ಇಷ್ಟೊಂದು ಗಲಾಟೆ ಮಾಡಿದ್ರೆ ನೀವು ಹೆಂಗೆ ನೀವು?
The petitioner says they have
There is
raised
one,
the fund,
only
they have
one dispute, my lords, if your lordship should direct the registrar to oversee that. Who are the actual members and how many members are actual members as on today? If he decides that, then my lords, all of them can be notified to hold an election for this particular year.
Is there any subscription fee fixed?
Yes, ಅವಾಗೇನೋ 1,000 ರೂಪಾಯಿ ಅಲ್ಲಿ ತುಂಬಿದ್ದಾರೆ, ಮೊದಲು ಆಗಿದ್ರು, ಈಗಲೂ ಇದೆ ಅನ್ಸುತ್ತೆ.
Prepare a list of voters.
ಈಗ as per my instruction nearly 200 persons are
My
there.
lord, the main paras, my lord, not read by the senior counsel. Annexure V, first page ಅಲ್ಲಿ ಕೆಳಗಿನ ಎರಡು ಪ್ಯಾರಾಗಳು ಓದಿದ್ರೆ the history of the society, this Buddhavihara Sangha, how it is running, that those two paras and the next page, mail in para. May I read, my lord?
Next,
Annexure V,
The impound order.
the inquiry, input or inquiry report,
page?
page number 89. ಸನ್ 94-95 ಸಾಲಿನ ಶ್ರೀ ಅಲ್ಲಪ್ಪ ಗುರಪ್ಪ ಅವಧಿ ಹಾಗೂ ಮಲ್ಲಪ್ಪ ಶಂಕರಪ್ಪ ಕೊಟ್ಯಾಳ್ಕರ್ ಇವರ ಅಸ್ತಿತ್ವದಲ್ಲಿ ಆಡಳಿತ ಮಂಡಳಿ ರಚನೆ ಮಾಡಿದ್ದು ಸನ್ 95, 96, 96, 3 ವರ್ಷಗಳ ಸಂಘದ ನವೀಕರಣವು 97ರಂದು ಸ್ವೀಕರಿಸಿಕೊಂಡಿರುತ್ತದೆ ಹಾಗೂ 97, 98, 98, 99, 99, 2000, 2001 4 ವರ್ಷಗಳ ಸಂಘ ನವೀಕರಣ 27/12/2000 ಸ್ವೀಕೃತಿಗೊಂಡಿರುತ್ತದೆ. ಸನ್ 2001-2 ಸಾಲಿನಲ್ಲಿ ರಾಯಪ್ಪ ಅಲ್ಲಪ್ಪ ಅವಧಿ ಹೊಸ ಅಧ್ಯಕ್ಷರು ಮಲ್ಲಪ್ಪ ಕೊಟ್ಯಾಳ್ಕರ್ ಕಾರ್ಯದರ್ಶಿಯಾಗಿ 24/12/2000 ಸ್ವೀಕೃತಿಗೊಂಡಿರುತ್ತದೆ.
ಸಿಗ್ತಾ ಇಲ್ಲ ಅದು page 89.
It is page 84. What he is reading is at page 84.
84 ಸ್ವಾಮಿ, ಅದು 9 ಕಟ್ 4 ಇದೆ, 9 ಅಂತ ಹೇಳಿ 84. ಕೆಳಗಿಂದ ಎರಡನೇ ಪ್ಯಾರ ಸ್ವಾಮಿ.
ಆಯ್ತು.
This is the history of the society, how it is running. Every 3 and 4 years it is continuously renewed, my lord. Last ಸನ್ 2005-6 ಶ್ರೀ ಜೆ.ಸಿ. ಕ್ಯಾತನ್ ಮಲ್ಲಪ್ಪ ಕೊಟ್ಯಾಳ್ಕರ್ ಇವರ ನೇತೃತ್ವದಲ್ಲಿ ಆಡಳಿತ ಮಂಡಳಿ ರಚನೆ ಮಾಡಿದ್ದಿರುತ್ತದೆ. 26/10/2001 ಸ್ವೀಕೃತಗೊಂಡಿರುತ್ತದೆ. 2006-7 ಸಾಲಿನ ಸ್ವಯಂ ನೇತೃತ್ವದ ಕೊನೆ ಕಾರ್ಯದರ್ಶಿ ಆಡಳಿತ ಮಂಡಳಿ ಜಾರಿಯಲ್ಲಿ ಇರುತ್ತದೆ. 7-8 ಸಾಲಿನಲ್ಲಿ ಸ್ವಯಂ ಸಂಜೋತ್ ರಾಯಪ್ಪ ಅವಧಿ ಕಾರ್ಯದರ್ಶಿ ಪ್ರಥಮ ಬಾರಿಗೆ ಆಡಳಿತ ಮಂಡಳಿ ಜಾರಿ ಇರುತ್ತದೆ. 2008, 9, 10, 10, 11, 5 ವರ್ಷಗಳ ಸಂಘದ ನವೀಕರಣವು ದಿನಾಂಕ 21/11 ಸ್ವೀಕೃತಿಗೊಂಡಿರುತ್ತದೆ. ಪರಿಶೀಲಿಸಲು ಬಾಕಿ ಸನ್ 11-12 ಸಾಲಿನ ಸಂಘದ ನವೀಕರಣವು ಸ್ವೀಕೃತಗೊಂಡ ದಿನಾಂಕ 4/5/11 ಪ್ರಕಾರ ಜಿತೇಂದ್ರ ಕಾಂಬಳೆ, ನಾಗರಾಜ್ ಲಂಬು ಇವರ ನೇತೃತ್ವದಲ್ಲಿ ಆಡಳಿತ ಮಂಡಳಿಯಲ್ಲಿ ಜಾರಿ ಇರುತ್ತದೆ. ಸನ್ 11-12, 12-13, 13-14 3 ವರ್ಷಗಳ ನವೀಕರಣವು ಆಗಿರುತ್ತದೆ. ಸ್ವೀಕೃತಿ ಪತ್ರ ಸ್ವಯಂ ಪ್ರಕಾರ ಗ್ಯಾತನ್ ಮತ್ತು ಸಂಜೋತ್ ರಾಯಪ್ಪ ಅವಧಿ ಇವರು ಮುಂದಾಳತ್ವದಲ್ಲಿ ಮಂಡಳಿ ಜಾರಿ. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾಮೆಲರ್ ಸನ್ 15-16, 16-17, 17-18 ಅಪ್ ಟು 21-22 ಹೀಗೆ 8 ವರ್ಷಗಳ ಆಡಳಿತ ಮಂಡಳಿ ಅಸ್ತಿತ್ವದಲ್ಲಿ ಇರುವುದಿಲ್ಲ. ಕಾರಣ ಸಂಘದಲ್ಲಿ 2 ತಂಡಗಳು ರಚನೆಯಾಗಿರುತ್ತವೆ. ಮಹೇಶ್ ಕ್ಯಾತನ್ ಇವರ ತಂಡದ ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯರಲ್ಲಿ ಮೃತ ಸದಸ್ಯರು ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯರಾಗಿ ಮುಂದುವರೆದಿದ್ದು ಕಾನೂನು ಉಲ್ಲಂಘನೆಯಾಗಿದೆ. ಪ್ರಥಮ ವಿಚಾರಣಾಧಿಕಾರಿಗಳು ಸಹಕಾರ ಸಂಘಗಳ ಸಹಾಯಕ ನಿಬಂಧಕರು ವಿಜಯಪುರ ಇವರ ವರದಿ ದಿನಾಂಕ 6/2/12 ಪ್ರಕಾರ ಸಂಘದ ಸಾಮಾನ್ಯ ಸಭೆ ನಿಯಮಾನುಸಾರ ಜರುಗಿಸಲು ಸಂಘಕ್ಕೆ ನಿರ್ದೇಶನ ನೀಡಲಾಗಿದೆ. ಸದರಿ ನಿರ್ದೇಶನ ಸಂಘವು ಉಲ್ಲಂಘನೆ ಮಾಡಿರುತ್ತದೆ. ವಿಚಾರಣೆಗೆ ಹಾಜರಿದ್ದ ನಾಗರಾಜ್ ಲಂಬು ಇವರ ಹೇಳಿಕೆ ಪ್ರಕಾರ ನವೀಕರಣ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ ಕಾಲಕ್ಕೆ 177 ಸದಸ್ಯರ ಯಾದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಸಂಜೋತ್ ಅವಧಿ ಇವರು ಸಲ್ಲಿಸಿದ ಯಾದಿ ಪ್ರಕಾರ ಒಟ್ಟು 287ರಷ್ಟು ಇರುತ್ತಾರೆ ಎಂದು ಸಲ್ಲಿಸುವ ಹೇಳಿಕೆ ಗಮನಿಸಿದಾಗ 2 ಗುಂಪುಗಳು ಇರುವುದು ಖಚಿತವಾಗಿದೆ. ಸದರಿ ದಾಖಲೆಯಲ್ಲಿ ಒಟ್ಟು 61 ಸಾಮಾನ್ಯ ಸದಸ್ಯರು ಇರುತ್ತಾರೆ. 2 ಲಿಸ್ಟ್ ಅಲ್ಲಿ 61 ಮಾತ್ರ ಕಾಮನ್ ಸ್ವಾಮಿ. ಸಾಮಾನ್ಯ ಸದಸ್ಯತ್ವದಲ್ಲಿ ಗೊಂದಲವು ಉಭಯ ಸದಸ್ಯರ ಗುಂಪುಗಳ ಸಂಖ್ಯಾಬಲ ನಿರ್ಧರಿಸಲು ಅರ್ಹ ಮತದಾರರ ಯಾದಿ ತಯಾರಿಸಲು ಅವಶ್ಯಕವಾಗಿದೆ. ಪ್ರಾಧಿಕಾರವು ದಿನಾಂಕ 16/6/13 ನಿರ್ದೇಶನ ನೀಡಲಾಗಿದೆ. ಮಾರ್ಚ್ ತಿಂಗಳ ಬಳಿಕ ಸಾಮಾನ್ಯ ಸಭೆ 14 ದಿವಸದೊಳಗೆ ಸಂಘ ಕಾರ್ಯಕಾರಿ ಮಂಡಳಿ ಪಟ್ಟಿ ಹಾಗೂ ಆರ್ಥಿಕ ವರದಿ ಕಡತಕ್ಕೆ ಸೇರಿಸಿಕೊಳ್ಳಲು ಕಡ್ಡಾಯವಾಗಿ ನವೀಕರಣ ಅರ್ಜಿ ಸಲ್ಲಿಸುವ 3 ವರ್ಷಗಳ ನಂತರ ಚುನಾವಣೆ ಪ್ರಕ್ರಿಯೆ ಆಡಳಿತ ಮಂಡಳಿ ರಚನೆ ಮಾಡಲು ಸಂಘದ ಬೈಲಾದಲ್ಲಿ ಅವಕಾಶವಿರುತ್ತದೆ. ಸನ್ 11-12 ಸಾಲಿನ ಸಾಮಾನ್ಯ ಸಭೆ ನಿಯಮಾನುಸಾರ ಜರುಗಿಸಲಿವೆಂದು ವಿಚಾರಣಾಧಿಕಾರಿಗಳು ತಮ್ಮ ವರದಿಯಲ್ಲಿ ನಿರ್ದೇಶನ ನೀಡಿರುತ್ತಾರೆ. And thereafter, my lord, I request your lordship to page number 91. ಕೆಳಗಡೆಯಿಂದ ಮೂರನೇ ಪ್ಯಾರಾ ಸ್ವಾಮಿ. ಸಂಸ್ಥಾಪಕ ಸದಸ್ಯರಾದ ಮಲ್ಲಪ್ಪ ಶಂಕರಪ್ಪ ಕೊಟ್ಯಾಳ್ಕರ್ ಇವರು ದಿನಾಂಕ 21/3/2000 ಮರಣ ಹೊಂದಿರುತ್ತಾರೆ. ಸನ್ 2006-7 ಸಾಲಿನಲ್ಲಿ ಸಂಘದ ಕಾರ್ಯದರ್ಶಿ ಇರುವ ಬಗ್ಗೆ ಇಲಾಖೆಗೆ ನವೀಕರಣ ಸಲ್ಲಿಸುವುದು ಕಾನೂನು. ಡೆಡ್ ಪರ್ಸನ್ ವಾಸ್ ಶೋನ್ ಆಸ್ ಎ ಸೆಕ್ರೆಟರಿ. ಸನ್ 2006-7ರಿಂದ 10-11 ಸಾಲಿನ ಅವಧಿಯವರೆಗೆ ಕಾರ್ಯಕ್ರಮ ಮಂಡಳಿಗಳು ಹಾಗೂ ಸಂಘದ ಆರ್ಥಿಕ ತಜ್ಞರು ಕರ್ನಾಟಕ ಸಂಘದ ಆಯ್ಕೆ ಪ್ರಕಾರ ಕಾನೂನು ಬಾಹಿರವಾಗಿ ನವೀಕರಣ ಅರ್ಜಿ ಸಲ್ಲಿಸಿ ದಿನಾಂಕ 21 ಸ್ವೀಕೃತಿ ಪಡೆಯಲಾಗಿದೆ. Anyhow, it is continued, not renewed. My lord, I request your lordship,
No, but why don't you at least prepare a voters list or a members list?
My lord, they have to, it is the, my lord, the condition number 2 in the annexure W.
You are the supervising authority.
Please, my lord.
You hold a meeting, you finalize the voters list. Depending upon the subscription fee that they have.
Yes, my lord, after going through all the papers, who have paid the subscription fees, etc., and who are the members. Only 61 members are the common in both the list. Excluding 61, all others, my lord.
No, all that you have to do is find out who are the members who subscribed. ದುಡ್ಡು ಕಟ್ಟಿದಾರೋ ಇಲ್ವೋ? ಕಟ್ಟಿದ್ರೆ list
My
ಕೊಡ್ತಾರೆ
lord,
ಅಲ್ವಾ?
only on the basis of papers, and the petitioner faction has shown the dead persons as secretary, etc., directors. For that reason, this Rajshekhar, this respond number 3 and 4, my lord, they have raised the funds, they have managed, and they are holding original records in their custody. For that reason, it was renewed and the certificate was issued. And my instructions are that even this year also, that this is the, my lord, respondents have renewed.
ಅಲ್ಲ, ಅದಕ್ಕೆ ಏನ್ ಮಾಡ್ತೀರಿ ಹೇಳಿ? How-
My lord, they have to settle in either before the civil court under section 25 or before the authority. They have to decide who are the members, my lord. Then,
But you are the person who can decide.
yes, yes, my lord, they have,
Cannot decide who are the members.
this may be disposed of with that direction, my lord. Both the fractions, they have to approach and give the list, and after holding inquiry, the members will be decided
We
by
cannot
fixing
leave
the time frame.
That we cannot leave it to you. You prepare the list of members. So list of members prepare ಮಾಡಿ.
My lord, yeah, very
ಅವ್ರ
ಎರಡು
ಬಳಿ
list-
ಇಸ್ಕೊಳ್ಳಿ- ಹಾ, ಎರಡು
We will
ತಗೊಂಡು
fix a date.
actually ನೀವು
Please, my lord.
We will fix a date within which all the members will have to file their nomination or particulars.
membership.
Based upon the particulars furnished, you
To show that they are the members.
the preliminary list on notify ಮಾಡಿ, objections ಹಾಕಿ, final list notify ಮಾಡಿ, then we'll consider what should be done in the writ petition.
Please.
In fact, not on an academic side, more on an academic side, the entire Karnataka Societies Registration Act and the rules does not mandate the registrar to either keep a copy of the original bylaws or the list of members or the subscribed members.
Bylaws ಇರುತ್ತೆ.
ಇಲ್ಲ, ಎಲ್ಲಿಲ್ಲ.
Bylaws ಇರುತ್ತೆ. Original bylaws will be there.
ಎಲ್ಲಿಲ್ಲ. The list of members who subscribe ಮಾಡಿದ್ದು, all these returns which are filed there under section.
ಅವೆಲ್ಲ ಅವ್ರ ಹತ್ರನೇ ಇರುತ್ತೆ ಸ್ವಾಮಿ.
ಅದೆಲ್ಲ ಇವ್ರಿಗೆ
Society
they hand it over to somebody, they don't retain anything. And there is also no procedure under the rules as to how the registrar can supervise these activities of societies, especially those societies which have little funding or financial help from the public or
No, but
society.
he is the end officer. He is the go-to officer for everything.
In fact, my lord should, my respectful submission is, my lords can direct or rather give guidance to the state government to issue circulars to work out this. There is a doctrine of unoccupied field, which your lordships can fill up by way of some guidelines. The government can issue certain circulars as to how these things can be supervised properly by the registrars.
There is one judgment in that Vakligara Sangha case. You just
Civil court ಗೆ ಹೋಗ್ಬೇಕು
What
ಸ್ವಾಮಿ.
is it?
Ultimately.
Whenever you have time, you just go through that. Vakligara Sangha case. High Court has gone extensively into all these things.
So an inquiry can be, my lords, reheld. This inquiry, which is a halfway an ex parte inquiry or something, it
So
can be
now
reheld in that context.
Now that, see, there can be freeze on all account operations, number one. There can be freeze on all account operations except for day-to-day expenses. Whoever is managing, let them manage. Day-to-day expenses ಏನಿದೆ ಅದು ತಕೊಳ್ಳಿ. But no major decisions, financial decisions. And let there be a list of members prepared, based upon which an election could be held. We can appoint somebody as election officer.
ಅದೇ ಕೆಳಗಿನ ಷರತಿ ಒಳಪಟ್ಟು ಇರೋದ್ರಲ್ಲಿ ಅದೇ ಇದೆ ಸ್ವಾಮಿ. ಅವ್ರ ಮೆಂಬರ್ಶಿಪ್ ಡಿಸೈಡ್ ಮಾಡ್ಕೋಬೇಕು.
Correct, but ಅದನ್ನ ನಾವು ನಿಮಗೆ ಬಿಡ್ಬೇಕಲ್ಲ.
ಅಂದ್ರೆ ಅವ್ರಿಗೆಲ್ಲ ಡೀಟೇಲ್ಸ್
My lords,
ಕೊಟ್ರೆ
they call for a preliminary report from the registrar on these lines. Till then, whoever the registrar will permit, my lords, he can just, that body can report to the registrar about their day-to-day expenses.
Continuing as per the last filings, they will continue, whoever is continuing.
Yes, sir. Let that body, my lords, whatever expenditure they are making, day-to-day expenses, let that be reported to the registrar so that there will be some transparency or some control.
The hearing the learned senior counsel for the petitioners and the learned counsel for the respondents.
3 and
3 and 4 and the learned AGA. It appears that there is an attempt at one-upmanship in the society. Full stop. While there's a report of the district registrar, that the respondent number 4 was not a member. In the subsequent report, it is found that the entire inquiry is at the behest of the respondent number 4. The district registrar has proceeded on the basis that the respondent number 4 was also a member. Full stop. The two rival factions have furnished a list of members to the registrar of societies, and only 61 names are common in both the lists. Therefore, comma, one faction, in order to wrest power, WREST, wrest power, has submitted a list of members, while the other faction has submitted another list. Full stop. There appears to be an attempt to throw a spanner into the good intentions with which the society was formulated or constituted. Full stop. This court therefore considers it appropriate to infuse regularity in the functioning of the petitioner and the only way to do it is to start the whole thing afresh by directing the district registrar of societies to first identify the members who had subscribed to the membership of the society.
As per bylaw number 3.
As per bylaw number 3.
Clause number 3 of bylaw.
The bylaws, as per the extant bylaws, as per the extant bylaws. Full stop. Thereafter, proceedings could be held to entrust the society to a duly elected body. Full stop. In order to achieve the aforesaid objective, this court has felt it imperative to pass the following directions to be complied with the Registrar of Societies, Vijaypura.
Vijaypura.
Yes. Full stop. Number 1, the Registrar of Societies shall prepare a list of eligible members as per the bylaws. Full stop. In order to do this, the registrar shall fix a date. Nave fix ಮಾಡ್ಬೋದಾ?
ಆಯ್ತು ಸ್ವಾಮಿ.
Shall, in order to achieve this, all members intending to stake their claim to the membership of the society shall submit all their documents to establish their membership by or before 12th February 2025. Full stop. The district registrar shall then verify the documents and then display or notify a provisional list of members by 28th February 2025. Agata? 16
ಆಯ್ತು
days.
ಸ್ವಾಮಿ.
16
If
days
they
after
will cooperate and file all the papers,
full stop. If this, any aggrieved member, any aggrieved person shall file his objections to the list so notified by or before 12th March 2025. Full stop. The district registrar shall then consider the objections and thereafter notify the final list of members by 29th March 2025. Full stop. The district registrar shall then decide holding a meeting of the general body of members, whereat a managing committee of the petitioner of the association shall be elected. And for this purpose shall finalize a calendar of events. Full stop. In the managing committee is elected in the manner aforesaid, the persons who are managing the association shall continue to do so, subject however to the condition that they shall not take any major policy decision or any decision that affects the finance of the finance or the working of the association. Full stop. This however does not, this however will not come in the way of the day-to-day expenses, come in the way of the present committee to draw funds to meet the day-to-day expenses of the society. Full stop. List this petition on yavat held. In order to oversee the aforesaid process, list this petition on
First week April. April, March.
ಅಲ್ಲಲ್ಲ ಇವಾಗ 12th ಕೊಟ್ಟಿದ್ದೀವಿ ಡೇಟು on 29th March 2025. March 2025.
Pleasure.
ಅದಾದ್ಮೇಲೆ ನೋಡೋಣ ಏನ 29th is Saturday ಅಲ್ವಾ? First and second April. 2nd April 2025.
The order copy.
Yes, we'll upload it by evening.
Please.
Petition stay ಮಾಡಬೇಕಾ? 8 ಮಳಿಗೆ ಹೋಗೋದು. Great.
Hmm.
2:30
ಒಂದು
ಮೂವ್ ಮಾಡಿದ್
ಯಾವುದು
2:30 ಮೂವ್ ಮಾಡಿದ್
ಕುಡಿ ಏನು
I am for the caveat lordship. In 230 matter, WPT 00166 of 2025.
ಹೇಳ್ರಿ
My caveat is not put up today lordship. I have
ನೀವು ಬಂದಿದ್ದೀರಲ್ಲ
no, kindly
Please.
taken up tomorrow lordship. I will request you lordship. Kindly taken up tomorrow lordship. I will request.
tomorrow.
But let them not execute the sale deed. That is my.
Sale deed in execution ಗೆ ನಾಳೆ ಇದೆಯಾ?
ನಾಳೆ ಇಲ್ಲ ಸ್ವಾಮಿ, ನಾಳೆ I will ready.
ಅಲ್ಲ ಅವ್ರು ಮಾಡಲ್ಲ.
So if you say that you will not execute the sale deed, then I list it tomorrow.
Lordship, I don't have instructions lordship, but tomorrow morning lordship I will wait.
No, that I cannot do. Here.
Please, my lord.
Lordship, my senior is not in station lordship. He is.
Doesn't matter, Mr. Yes.
Lord, a compromise decree between the respondents 2 to 9 and 10 to 31. 2 to 9 and 10 to 31. Came to be passed by this honorable court. My lords may kindly have my synopsis list of events that may be more assist. On 25/2/2015, my lord. As per that, in fact, my lord, I have got my own reservation whether it can be called as a decree, etc., because simply a joint memo was filed wherein, my lord, the respondents 10 to 23, 10 to 31 were supposed to execute a registered sale deed in favor of appellant therein, late Mahbub. That registered within 30 days from that date, that is February 2015, my lord. Thereafter, my lord, the appellant Mahbub, we do not know. We are the purchasers of the land recently. He did not turn up. He did not call upon the JDRs to execute the sale deed, etc. In the meanwhile, said appellant Mahbub Saab, in whose favor the sale deed was supposed to be executed of 14 acres, died on 19/12/2021, my lord. Then, my lord, on 21/4/2022, LRs of said Mahbub Saab said to have executed an assignment of that decree in favor of respondent number 1, Abdul Razak herein. Thereafter, my lord, in 2024, Abdul Razak, that is respondent number 1 herein, along with respondents 2 to 9, files an execution petition with a prayer that direct the JDRs to execute the sale deed. If they fail to execute it, kindly see that it is executed, my lord. So, my lord, this goes on. In the meanwhile, what happened, my lord? The petitioner number 1 on 29/6/2024, my lord, purchases the 14 acres of land from the JDRs 10 to 31, my lord, under a registered sale deed, my lord. Then, my lord, on 24/9/24, the DHRs files an application before the court below, IA number 2, to add the petitioner number 1 herein as one of the JDRs to the petition, my lord.
Yes.
Thereafter, my lord, notice was issued, it was not served, etc. In the meanwhile, my lord, since it takes time, I will just come to directly on serial number 11, the list of events.
Just confusing serial number 5 bani.
Please.
Petitioner number 1 purchased an extent of 14 acres of land.
Please.
In question from R2 to R9.
From R2 to R9.
Now you please come to the first paragraph in the writ petition.
ಅಲ್ಲ ಅದು JDR 2 to 9.
ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಸರ್, ನೀವು
ಅಲ್ಲ, I stand correct. I apologize.
Everything is so misleading.
ಇಲ್ಲ ಅದು ಹರಿದಾಗ, ಯಾಕಂದ್ರೆ ಶನಿವಾರ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ರು ಸಾಹೇಬ್ರೆ, ನಿನ್ನೆ ಬಿಟ್ಟು ಮೊನ್ನೆ.
ಶನಿವಾರ ಆರ್ಡರ್ ಆದ್ರೆ ಫ್ಯಾಕ್ಟ್ಸ್
ಅಲ್ಲ, ಅವರು ರಾತ್ರಿ ಬಂದ್ರು. ಅಲ್ಲ, I accept that mistake. Instead of JDRs, respondents 1 to 9 ಆಗಿತ್ತು ಸರ್. My lord, be that as it may, what happened, my lord? The stays on the.
Wait, please wait. But you have come into the picture only after the decree.
Please, my lord.
You are a purchaser pendente lite.
Pendente lite, we were not aware, and JDRs have sold it. Be that as it may, my lord. I am on a ground that, my lord, in an execution petition, when I was sought to be impleaded as one of the JDRs, notice was issued to me and appearance was on 18/1/25. ಮೊನ್ನೆ ಶನಿವಾರ. ಅವತ್ತಿನ ದಿವಸನೇ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿಬಿಡ್ತಾರ. Even without impleading me as, adding me as one of the JDRs, giving an opportunity to me to file my objections.
Yes. So don't execute the sale deed till the next date of hearing.
Lordship, kindly have it tomorrow, Lordship. I will.
No, either you undertake that you will not execute the sale deed, or I pass an order that you shall not execute the sale deed till the next date.
Lordship, my request is my
Good.
Lordship.
What is your name?
Harish, Lordship, Harish.
Huh?
Harish, Lordship.
Mr. Harish.
Yes.
Who appears-
Lordship, I am appearing for behalf of the Harshvardhan or Malli Patil as a caveator, Lordship.
ಆಯ್ತು ಎಷ್ಟನೇ ರೆಸ್ಪಾಂಡೆಂಟ್ ನೀವು
1 to 9.
I am for respondent number 1, Lordship. I have filed caveat in favor of respondent 1, Lordship.
1 to 9 or 1?
1 only, Lordship.
Mr. Abdul Razak.
Yes, Lordship.
The
Lordship,
Mr. Harish.
Lordship, have it tomorrow,
behalf
Lordship.
of Mr. Harshavardhan or Mali Patil has entered caveat for the respondent number 1. He has joined the proceedings through video conference and seeks time to file objections to the writ petition. The learned counsel for the petitioners, however, contend that the respondents are trying to get a sale deed.
Allah, commissioner is going to
Submits as a commissioner is appointed,
and commission warrant is issued.
appointed for execution of the sale deed, and that a warrant is now issued. He therefore contends that until disposal of this writ petition,
Lordship,
comma,
on submission.
the registration of the document be put on hold.
On
Full
submission,
stop. Next
Lordship.
para. Since the petitioners contend that notices were issued to them to impede them in the execution proceedings. And even before they were impleted, a commissioner is appointed for execution of a sale deed and a warrant is also issued. Comma, this court considers it appropriate to stay all further proceedings
Lordship, on
before the executing court, including the execution of the sale deed by the commissioner appointed by the court till the next date of hearing.
Lordship, on submission, Lordship.
Ah,
ಇದೇ ಆರ್ಡರ್ ನಾಳೆ ಸ್ವಾಮಿ ನಾಳೆ ಇಟ್ಕೊಂಡು ನಾಳೆ ಮಾಡೋದು
no,
ಸ್ವಾಮಿ.
sorry, ನೀವು ನಾಳೆ ಮಾಡಲ್ಲ ಅಂತ ಹೇಳಿ ನಾನು ರೆಕಾರ್ಡ್ ಮಾಡ್ತೀನಿ, ಐ ವಿಲ್ ನಾಟ್ ಪಾಸ್ ಎನಿ ಆರ್ಡರ್.
ನಾಳೆ ಮಾಡೋದಿಲ್ಲ ಸ್ವಾಮಿ, ನಾಳೆ ತಾವು ತಗೊಂಡ್ರೆ ನಾವು ಇದು ಮಾಡ್ತೀವಿ ಸ್ವಾಮಿ.
ನಾಳೆ ಮಾಡೋದಿಲ್ಲ ಅಂತ.
ಅಲ್ಲ ಮಾಡಲ್ಲ ಅಂದ್ರೆ ನಂದೇನ ಅಭ್ಯಂತರ
At
ಇಲ್ಲ.
this stage,
Only
comma, the learned counsel for the petition, respondent number 1 submits that that till tomorrow, comma, the respondents will not
ಅಲ್ಲ, R1 will not go for getting the
will not appear before the sub-registrar for executing the sale deed. Full stop. The submission is noted and list this petition tomorrow for consideration of interim prayer.
Please, Lordship. Great Lordship.
Milord, in the meanwhile, notices to the respondents 10 to 31 may be dispensed with because
The memo
memo ಕೊಡ್ತೀನಿ JDR
is filed by the learned counsel for the petitioner seeking dispensation of notice to respondents 10 to 31, as there also the JDRs.
they are JDRs.
Petition.
As far as 2 to 9 ಅವ್ರು ತಗೊಂತಿದ್ರೆ ಅನುಕೂಲ ಇಲ್ಕರ ನೋಟಿಸ್
2 to 9 ನೀವೇ ತಗೋತೀರಿ?
No, Lordship, I don't have instructions, Lordship.
ತಗೋತೀರಾ ಇಲ್ಲ?
ಇಲ್ಲ ಸ್ವಾಮಿ, notice has to.
In view of the memo, notice to the said respondents is dispensed. This list tomorrow.
ಪ್ಲೀಸ್.
Please, Lordship.
ಕರೀರಿ ಅದ್ಯಾರು ಕಡ್ಗಂಚಿಯವರು.
make on submission, Lord.
ಒಂದು ನಿಮಿಷ ಅದ.
Yes. Here there are 3 judgments.
Huh?
3 judgments of Honorable Justice Ravi Maliman. Wherein the first one. Para 5, page number 7. Admittedly, the aforesaid condition has not been fulfilled. The members have intimated to the Assistant Commissioner to call for a meeting by their written representation on 2/8. Assistant Commissioner has issued a notice on 14/9, fixing a meeting of no confidence motion on 5/10/2018. Even though there is clear 15 days notice given to members, the meeting is fixed beyond a period of 30 days, that is on 5/10, from the date of receipt of written representation by the members of Panchayat on 2/8 for holding no confidence motion. Therefore, it violates Rule 3(2) of Panchayat Raj rules. In view of non-compliance of provision of 3(2) of the Panchayat Raj rules, the implumed notice calling for holding no confidence motion is opposed to the law. Therefore, the aforesaid reason, the petitions are allowed. The implumed notice dated 14/9/2018 at annexure F and F1 are squashed. Even though the implumed notice has been squashed, the respondent members are at liberty to initiate a fresh notice as proceeded in accordance with law. This is one. On the same line, these are the other two rulings of Honorable single district. This is Puttaswamy.
Puttaswamy was not the 30-day.
Yes.
Puttaswamy was not regarding 30-day.
No, it is
15 days.
no. This is
This is not that Puttaswamy.
not that.
It's D Puttaswamy.
Same at page number 6, para 5.
Same.
Admit, yes, same 30 days. And this is another ruling, Kamalabai case, wherein also the same 30 days point was held.
Same.
Apart from that, my lords, his lordships wherein while sitting at Dharwad, a 3-bench judgment wherein 10 days point that was very well elaborated and a very elaborate judgment is being passed. There, it was very specifically, repeatedly again stated that as per the Supreme Court ruling, what the law says, what the act state shall, it has to be followed, is repeatedly said. And if I may be permitted to read that very paragraph which his lordship was also the part of the judgment, where, however, the words were clear. There is no ambiguity, there is no ambiguity, and the intention of the legislature is clearly conveyed. There is no scope for the court to invoke or take upon itself the task of amending or alternating the statutory provision. In that situation, the judges should not proclaim that they are playing the role of lawmakers merely for exhibiting of judicial will. They have to remember that there is a line, though thin, which separates adjudication from legislation. That line should not be crossed or erased. This can be overstepped by an alter recognition of the necessity not to cross it and institute as well as trained vigilance to do so. It is true that this court in interpreting the Constitution enjoyed the freedom which is not available in interpreting the statutes, and therefore it will be useful at this stage to reproduce. With this, when a law has prescribed, it has to be done. When it was taken 10 days clear notice, there was also a reference of 30 days clear notice also in this judgment, which in a very early part of judgment, it was mentioned. I'll also read that part, which this honorable court is. Kindly. Yes. In that judgment, 11th para. The concept of no confidence is based on the concept of omission in the corporate world, where a person who has lost confidence in the board of directors is bound to be removed. It is compared with that. And here, to save the time and just reproduce, here it is said that it is not only the fate of the who is Adhyaksha, it is a fate of the democratic system who has been elected through general election. It is not only fate of the person who is facing a non-confidence, but also the fate of the persons who have elected him. In that concept, it is said, that the no confidence motion has been done. 15 days clear notice is given, 30 days clear notice is given. With that, what the court says is, the assistant commissioner thereafter gives 15 days clear notice in form number 2 to all the members and convey a meeting on the day which shall not be beyond 30 days from the date of the member submitting form number 1. The meeting shall be presided by the Assistant Commissioner, who shall put the motion to the vote. Here also, it is 30 days clear notice has to be given. The circumstance of has questioned me why this system has been made. It is because of to set up a democratic system. It is the fate of the people also which is involved. With this observation and with these 3 judgments, I again humbly request to uphold the interim order that is passed by this on.
Can I now state some facts to you?
Please.
These 3 judgments.
Yes.
Do not consider the earlier judgment.
Do not
These 3 judgments
Huh.
do not consider the earlier judgment referred in Muniyappa, Manjulan. Muniyappa.
Yes.
These 3 judgments do not refer to Muniyappa.
Yes.
Correct?
Yes.
The full bench judgment which you referred.
Yes.
Was on the lines of Rule 3.1, whether 15 days is mandatory.
Yes.
Or whether the Assistant Commissioner has to issue a notice within 10 days.
Yes.
Or beyond 10 days. ಆ ground ಮೇಲೆ 3.1 ಅಲ್ಲಿ 30 days ಬಗ್ಗೆ ಇಲ್ಲ. There's a passing reference.
Yes.
In the full bench judgment.
Yes.
I'm asking you this question.
Yes.
When a provision can be both directory and mandatory, what should be the solution available to the court? Should it treat it as directory or mandatory? ಅದನ್ನ ನಿಮಗೆ ಕೇಳಿದ್ದು. ಈಗ if there's a criminal case, if an interpretation is made, the interpretation should be in favor of the accused. Whatever interpretation that you make should be favoring the accused. Similarly, when there is a possibility of 2 interpretation, one, ನೀವು ಈ ಕಡೆಯಿಂದ ನೋಡಿದ್ರೆ ಈಶ್ವರನ್ ತರ ಕಾಣುತ್ತೆ, ಈ ಕಡೆ ನೋಡಿದ್ರೆ ವಿಷ್ಣು ತರ ಕಾಣುತ್ತೆ. ಇವಾಗ ಏನಂತ ಹೇಳ್ಬೇಕು ಅವ್ರನ್ನ?
ಎಸ್ ಸರ್, ನನ್ನ ಕಡೆ ನೋಡಿದ್ರೆ ನಾನು ಒಬ್ನೇ ಅಲ್ಲ, ನನಗೆ ಆರಿಸಿದವ್ರು ಎಲ್ಲರೂ ಇದ್ದಾರೆ.
ಅಲ್ಲಿಗೆ
ಆ ಕಡೆ ನೋಡಿದ್ರೆ 8-9 ಜನ, 15 ಜನ, 16 ಜನ ಇರ್ಬೋದು.
When two views are possible, which are diametrically opposite to each other, what should the courts do? In whose favor should the court lean? ಯಾರ ಪರ ಬಗ್ಗಬೇಕು ಅಂತ?
To my understanding, the law is very clear, the section is very clear.
Going back to the section, now there's a judgment of a coordinate bench of this court.
After that, I have produced these much judgments.
These much judgments do not refer to the earlier judgment.
Not necessary, my lords, it is subsequent judgment.
I hope you know what is meant by a precedent.
My lords,
Precedent ಅಂದ್ರೆ ಏನು?
my lords, the court has asked me to produce 1 judgment of 30 days. I have produced 3 judgments, and also the passing reference of which this court is a part of it.
Kadaganchi, don't get emotional. You are a lawyer. Please
Sir,
wait.
I am not,
No,
sir,
please wait.
ನನಗೇನು
Kadaganchi.
ಕಾನೂನು ಬಿಟ್ಟು ಬೇರೆ ಮಾತಾಡಿದ್ರೆ I am not able to understand. Then why is this necessary? Why the word shall is necessary? Why the section rules are necessary?
There's a judgment of this court which was not rendered by me. There's a judgment of this court which was rendered in 1998.
Yes.
I hope you understand the meaning of a judgment. This court has held that the same rule that you are relying upon is directory. ಅಂದ್ರೆ 30 ದಿನಾನೂ ಆಗ್ಬೋದು, 33 ದಿನಾನೂ ಆಗ್ಬೋದು ಅಂತ ಹೇಳಿದ್ದಾರೆ
ಹೌದು
ಈ ಕೋರ್ಟ್. So this is the law.
Yes.
This is a law declared by this court.
Yes.
So therefore you cannot go back to that rule and say, rule ಅಲ್ಲಿ shall ಅಂತಿದೆ, shall ಅಂತಾನೆ ನೋಡ್ಬೇಕು ಅಂತ ನೀವು ಹೇಳಕ್ ಆಗಲ್ಲ.
Okay.
Because there's one judgment.
May I ask, for my understanding, if the judgment of 1919 is a law, then what is the judgment of 2018?
It can't.
What is it called? What is it?
It is per incurium. It is per incurium because these 3 judgments do not refer to this judgment. ಈ judgment ನ overrule ಮಾಡದೆ ಹೊರತು ಈ judgment ಬರೆಯಕ್ ಬರಲ್ಲ ಕಾನೂನು ಪ್ರಕಾರ.
ಸರ್, ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲಲ್ಲ ಸರ್, 1999 ಜಜ್ಮೆಂಟ್ ಇರೋದು. ಈಗ ಎಲ್ಲಾ ಕೇಸಲ್ಲಿ ಎಲ್ಲಾ ಜಜ್ಮೆಂಟ್ ಓವರ್ ರೂಲ್ ಮಾಡಿ ಒಂದು ಹೊಸ ಜಜ್ಮೆಂಟ್ ಬರೆಯೋದಾಗತ್ತಾ ಸರ್?
ಈಗ ಇವ್ರು ನನ್ ಮುಂದೆ 2 ಸೆಟ್ ಇದೆಯಪ್ಪ. ನನ್ ಮುಂದೆ 2 ಯಾವ್ದು ಫಾಲೋ ಮಾಡ್ಲಿ?
Some latest one,
Why?
because that is a law.
How do you say that? This is also equally of unequal strength.
Not once,
This is
3
also-
times, not once, 3 times.
ನೀವು 3 ಸತಿ ಇಲ್ಲ 300 ಸತಿ ಹೇಳಿದ್ರು ಅಷ್ಟೇನೆ. 300 ಸತಿ ಹೇಳಿದ್ರು ಅಷ್ಟೇನೆ.
ಅಲ್ಲ
Then
sir,
there are
what
two
ab-
sets.
What about the part, ಈಗ 15 ದಿನ mandatory ಅಂತ ತಾವೇ ಒಂದು judgment ಅಲ್ಲಿ it has been referred. After that, it has been referred 30 days is mandatory. You
Right.
can't interpret the law.
ಈಗ ಒಂದು ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇವ್ರ ಕಡಗಂಚಿ ಅಂತ ಒಂದು ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆ. ಇನ್ನೊಂದು ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇವ್ರ ಕಡಗಂಚಿ ಅಲ್ಲ ಅಂತ ಇದೆ. ಯಾವ್ದನ್ನ ತೀರ್ಮಾನ ಮಾಡ್ಬೇಕು? ಯಾವ್ದು ಒಪ್ಬೇಕು?
ಅಲ್ಲ ಸರ್, 30 ಕಾನೂನು ಏನ್ ಹೇಳುತ್ತೆ 30 ಒಳಗಾಗಿ ಅದನ್ನ ಯಾಕೆ ಇಂಟರ್ಪ್ರೇಟ್ ಮಾಡ್ಬೇಕು ಸರ್? ಯಾವಾಗ ಕ್ಲಿಯರ್ ಇದೆ ಕಾನೂನು, ಸೆಕ್ಷನ್ ಕ್ಲಿಯರ್ ಇದೆ ಅಂದ ಬಳಕೆ ವೈ ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಇಂಟರ್ಪ್ರೇಟ್? ತಾವೇ ಫಸ್ಟ್ ಟ್ರೈನರ್ ನನಗೆ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕೊಡುವಾಗ ಯು ಪಾಸ್ ದ ಸ್ಟ್ರಿಕ್ಚರ್ಸ್ ಆನ್ AC.
I learned my lesson. Henceforth, I will be strict in granting interim orders. Only when you have a 99.99%.
I'm thankful, sir, but I'm not learning my lesson to this act, why it has come into
So you're not,
existence.
as a lawyer, you're not assisting the court.
Let's-
Lawyer not assisting. I told you, I gave you a hint. ನಿಮ್ಗೆ hint ಕೊಟ್ಟೆ. ನೀವು ಹುಡುಕ್ಲಿಲ್ಲ. I gave you a hint, you did not follow the hint. You're still blinded by your own, ನೀವು ಒಂಥರ ಬ್ಲೈಂಡ್ ಆಗ್ಬಿಟ್ಟಿದ್ದೀರಿ. ಇಷ್ಟನ್ನೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಕು, ಇಷ್ಟು ಬಿಟ್ಟು ಮತ್ತೆ ಇನ್ನೇನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡದೇ ಬೇಡ ಅಂತ.
ಅಲ್ಲ ಸ್ವಾಮಿ, when
Sorry, Mr. Kadaganchi.
when the law is clear.
So when I told you that there are possibility of 2 interpretations, what should be the way out? When there are possibility of 2 interpretations, what should be the way
It
out?
is a mandatory provision that has to be.
I'll look into. I'll pass appropriate orders. We'll upload it by evening. What orders that have to be passed.
Hello, sir, by referring all those judgments.
We'll definitely refer to all those issues.
Then why is the law needed, my lords? Why is the section needed? Because I am blind today with these observations, with this.
I'll show you the light. ದಾರಿ ತೋರಿಸ್ತೀನಿ ನಿಮಗೆ ಏನು.
Because, my lords, with the kind reference. Andre, what is the consequence? Can I submit? The other day, when Honorable Court was pleased to pass an order regarding second no confidence motion. An interim order was, through writ petition, this court was pleased to squash the entire notice.
Yes.
AC was informed.
Yes.
She was today morning, the assistant commissioner was out for going to conduct a meeting saying that when my notice of second notice is being upheld, then why should I not conduct the meeting? The consequence of one judgment will lead to many of the.
So therefore,
ಅಂದ್ರೆ
ಆ ಒಂದು ಸ್ಟ್ರಿಂಗ್ ಇರುತ್ತಲ್ಲ, ಈ ತರನು ಹೇಳ್ಬಾರ್ದು, ಆ ತರನು ಹೇಳ್ಬಾರ್ದು. ಆ ತರ ಹೇಳಿದ್ರೆ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಯಾವ ತರ ಹೋಗ್ಬೇಕು? ಹಿಂಗ್ ಹೋಗ್ಬೇಕು, ಹಂಗ ಹೋಗ್ಬೇಕು.
ಅದಕ್ಕೆ ಅದನ್ನು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಅವ್ರು ಬಹಳ ಲಾಂಗ್ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಇಡ್ತಾ ಇದ್ರು ಅವಾಗ. ಅದಕ್ಕೆ ಅವ್ರಿಗೆ ಅದು ತಡೆ ಆಜ್ಞೆ ಸಲುವಾಗಿ 30 ದಿನದೊಳಗೆ ಮಾಡ್ರಿ ಅಂತ ಹೇಳಿ. The sole base is that when a representation was given in some cases 2 months, 3 months, 6 months, they were pending. No motion, no confidence motion was not called. At that time, this 30 days limitation has come into existence. The law mandates it. I know.
Tell us what is the purpose? You can't simply say law mandates. ಏನ್ purpose ಏನು? Will not be later than 30 days ಅನ್ನೋದಕ್ಕೆ ಉದ್ದೇಶ ಏನು?
ಅಂದ್ರೆ ಪೆಂಡಿಂಗ್ ಇಟ್ಕೊಂಡು ಕುಂದರ್ಬಾರ್ದು AC ಅವರು.
ಉದ್ದೇಶ ಏನ್ರಿ? ಇವಾಗ 15 days ನೋಟಿಸ್ ಮ್ಯಾಂಡೇಟರಿ ಅಂತ ಹೇಳಿದ್ವಿ. ಯಾಕೆ?
Because that has to be dealt.
ಯಾತಕ್ಕೆ ಮ್ಯಾಂಡೇಟರಿ?
Because there is some point which has been given by other members.
ಯಾನಕ್ಕೆ ಮ್ಯಾಂಡೇಟರಿ ಅಂತ ಹೇಳಿದ್ ನಾವು?
Mandatory.
We say
It is mandatory for the assistant commissioner to conduct it within 30 days.
ನಾವು 15 days period ಯಾತಕ್ಕೆ ಮ್ಯಾಂಡೇಟರಿ ಅಂತ ಹೇಳಿದ್ವಿ?
Awesome. That is there in this.
Why did we say that? That is there. Why did we say that? Why did we say that 10-day period is a discretionary period to the available to the assistant commissioner? 15-day period is a mandatory period. And why did we say? 10-day period ಇದೆಯಲ್ಲ,
ಹೌದು ಸರ್,
ಅದು ಇಟ್ ಇಸ್ ದ ಡಿಸ್ಕ್ರಿಷನ್ ಆಫ್ ದ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಅಂತ ಹೇಳಿದೀವಿ ಫುಲ್ ಬೆಂಚ್ ಅವರು. The 15-day period we say no discretion, it is mandatory.
Yes.
Why did we say that? ಯಾತಕ್ಕೆ ಹೇಳಿದ್ವಿ? ಹೇಳಿ ಯಾತಕ್ಕೆ ಹೇಳಿದ್ವಿ ಅಂತ.
ಸ್ವಾಮಿ ಅದನ್ನು ತಾವೇ ಹೇಳ್ಬಿಡಿ ನನಗೆ.
ನಾನು ಹೇಳದಲ್ರಿ. Now that you have gone through all those judgments, you please tell us. ಯಾತಕ್ಕೆ ಹೇಳಿದ್ವಿ?
ಇಲ್ಲ, my interpretation and the court interpretation is completely is dividing the thin line.
Yes.
Yes.
Good. The vacating stay ಹಾಕಿದ್ರಾ? Yes, madam. An application is filed for vacating the order of stay.
And as far as the allegations is concerned, that can't be treated as under clause 1. There is clear allegations. For that also I am relying upon.
Judgment ಕೊಡ್ರಿ.
Yes, sir.
A division bench judgment it shall be treated as a complaint under 49(1) anta. Yes. Even if the allegations, it shall be treated as 49(1). In fact, it is I'm sorry, I got very recently, my lord, Dharwad bench, Justice Anant Raman Hegde, it says that in the judgment similarly, which even includes the reasons, that is not allegation, there are the reasons for moving the no confidence. There's one judgment just rendered by Justice Dinesh Maheshwari. Please look into that. I'll.
Your writ appeal 844 of 2018 says that when there is an allegation, it has to be treated under clause 1 and call for another meeting by this is of Honorable Justice Lee. Yeah.
No. Dinesh,
There is a specific allegation.
there's one judgment of Justice Dinesh Maheshwari sitting in revision bench while considering the effect of 49(1), 49(2). Please go through that.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅದಾದ್ರೂ ಅದು ಇಲ್ಲ ಅಂತಂದ್ರೆ ಇದು ಒಂದು ಮ್ಯಾಂಡೇಟರಿ ಇದಲ್ಲ ಸ್ವಾಮಿ. ನನಗಲ್ಲಿ ಐ ಡೋಂಟ್ ಹ್ಯಾವ್ ಚಾನ್ಸ್ ಟು
ಗ್ರೌಂಡ್ ಇನ್ ದ ರಿಟ್ ಪಿಟಿಷನ್ ಆ ಅಲಿಗೇಷನ್ ಬಗ್ಗೆ ಅವರು ಗ್ರೌಂಡ್ ತೆಗೆದಿಲ್ಲ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ.
ಆಯ್ತು ಇರ್ಲಿ, ತೆಗೀರಿ.
My lord's allegation is there.
Law clerk.
Allegation is there. I'll be not. At page number 16, there is allegations.
Good. An application is filed.
Not to treat it as 49(1).
An application is filed by the, sorry, orders on IA 1 of 25 ಅಂತ ಮಾಡಿ. This is an application filed by the private respondents 5 to 16 to vacate the interim order dated 17/1/2025. Next paragraph. The petitioner who is the president of Gram Panchayat, Sri Chand, Panchayat Sri Chand, had filed this writ petition challenging the notice dated 30th of December 2024, proposing to hold a meeting of the members of the Panchayat on 21/1/2025 to consider a notice of no confidence. Full stop. This notice was challenged on the ground that the notice on the ground that the meeting was held beyond a period of 30 days, and therefore it violated Rule 3(1) of the Rules 1994. Full stop. This court therefore granted an interim order of stay of the notice. Full stop. An application is now filed by the respondents to vacate the order of stay granted on so-and-so date. Full stop. It is a contention of the private respondents that under Rule 3(2), though the meeting has to be held within 30 days, the said rule is held to be directory by a coordinate bench of this court in Muniappa and another, the state of Karnataka and others. He therefore contends that it is therefore contended that the petitioner would not in any way be prejudiced by holding the meeting on the 31st day. Full stop. Per contra, the learned counsel for the petitioner contends that three coordinate the coordinate bench of this court, coordinate bench of this court in WP number 39256 of 2018, WP number 45939 of 2018, and WP number 44105-44106 of 2018 have all held that quashed the notices of no confidence since the meeting was held beyond a period of 30 days. Full stop. He contends that in view of the latest law, as aforementioned, the impugned notice which is issued holding a meeting on the 31st day falls foul of Rule 3.1 of the Rules 1994. In addition, he contends that the representation submitted by the members carried many allegations against the petitioner, and therefore, without following the procedure contemplated under Section 49(2) of the Act 1993, the meeting could not have been held. Full stop. In support of this contention, he relied upon the judgment of a coordinate bench of this court in Srimati Purnima Sudin versus State of Karnataka, and contended that until rules are framed to consider a notice of no confidence under Section 49(2), the motion of no confidence cannot be proceeded with. Thus, he contends that the order of stay granted by this court is just and proper. Next part. A perusal of the writ petition shows that the challenge to the notification, the notice issued by the respondent number 2, respondent number 3, is based on the contention urged.
Excuse me, sorry, may I interrupt? I just now received Assistant Commissioner order wherein she has adjourned the meeting, and in return she has submitted to all the members that the meeting is adjourned.
That is, my lord,
It is a what?
tomorrow,
It
since
is an
the
order.
interim order was there passed on Friday, without, my lord, reference to that, they have intimated it to the members about the interim order. Now, this matter is still pending, which I have moved it today. So not, the government is here, my lord, to
So it
represent.
is adjourned.
It is adjourned.
No,
I'll
what date?
just get the printout, or if not, I'll just, please.
To what date?
that is because, my lord, Friday, the interim order of stay was granted. Which is, now this order, my lord,
Then I
whatever is the
didn't-
order of this court.
When is it adjourned to?
ದಿನಾಂಕ 21ರಂದು ನಡೆಯಬೇಕಾದ ಸಭೆ ತಾತ್ಕಾಲಿಕವಾಗಿ ಮುಂದೂಡಲಾಗಿದೆ.
Tatkalika, because of the
By
interim.
dated 18/1/2025.
So we
Dated.
list it tomorrow.
Yes,
You please go through the, we'll list it tomorrow.
yes,
You go through the position of law,
yes.
come back to the court better prepared. And don't pounce on the court, Kadaganchi. Don't pounce on the court. Don't find fault with the court for granting an interim order. Don't make the court ever feel guilty of having committed a mistake in granting an interim order. Because of your one case, all other lawyers will get affected. I'm sorry.
My lord.
I'm not on that.
Very, very sorry.
My lord, sir, may I make one submission?
ಇದು ಒಂದು ಕೇಸ್ಗೋಸ್ಕರ ನೀವು ಬೇರೆ ಲಾಯರ್ಗಳಿಗೆಲ್ಲ ನೀವು ತೊಂದರೆ ಮಾಡ್ತಿದ್ದೀರಿ. Which is
ಸರ್
not
ತೊಂದ್ರೆ ಅಲ್ಲ, ನಾನು ಲಾ ನೋಡ್ಕೊಂಡು ಇದನ್ ಬಿಟ್ಟು ಹೇಗಾಗತ್ತೆ ಅಂತ ನಾನು ಅದನ್ನ ಯೋಚನೆ ಮಾಡಿ ನಾನು
ಅದನ್ನ ಬಿಟ್ಟು ಅದಂಗ
ದಯವಿಟ್ಟು ನೀವು ನನ್ನನ್ನು ತಪ್ಪು ತಿಳ್ಕೊಬೇಡ. I only involved in completely in the subject and
I am not at all interested to fight with you, quarrel with you, Mr. Kadaganchi. I am only concerned with the position of law. That is all.
Even my feeling.
You are not seeing my point of view. You are not seeing my point of view. You are only blinded by your point of view. You are only blinded by your point of view. ನಿಮ್ಮ ಕಣ್ಣು ಕಾಣಿಸ್ತಿರೋದು ಬರೀ ಹಸಿರು, ನೀಲಿ, ಕೆಂಪು. ನನಗೆ 4-5 ಕಲರ್ ಕಾಣ್ತಾ ಇದೆ. ನನ್ನ 4-5 ಕಲರ್ ನೀವು ನೋಡ್ತಾ ಇಲ್ಲ. In my rainbow, there are 7 colors. In your rainbow, there are only 3 colors. You're not seeing my 7 colors in my rainbow. Please understand that.
My lord, may I make one submission? My lord, the notice of the Assistant Commissioner what he is referring to is only, my lord, because on 17 there was an order of stay. My lord, it will have to be acted upon, and accordingly, my lord, I am told now at 4 o'clock, despite, my lord, that there is a pendency, that as per if there is an order of this court, we would again take back that order. It is only communicated through WhatsApp. Now, my lord, what will happen is, if what the provision says, again 15 days, again it will have to be taken. My lord, the entire process, the entire exercise of, my lord, moving this application is, my lord, there is already date fixed for tomorrow, which is very well known to all the members, which is circulated and personally hand delivered to them. Now, my lord, any order that could be passed today will have to be acted upon by the Assistant Commissioner. However, on that ground, my lord, it cannot be urgent. Even if tomorrow morning if it is urgent, tomorrow at 12:30 is the meeting, which will have to be processed.
So tomorrow 10:30.
10:30, my lord, because
The top of the list.
that should not come in way of, because it is only the court order which will have to be given effect to.
With permission.
ಅಯ್ಯೇ ಇರ್ಲಿದು ಸ್ಟ್ರೈಕ್ ಮಾಡ್ಬಿಡಿ. ಅಯ್ಯೇ ಒನ್ ಆಫ್ ಸ್ಟೇ ಇದೆಲ್ಲ. The learned counsel for the petitioner submits that the Assistant Commissioner has adjourned the meeting. However, the learned counsel for the private respondents opposes this and contends that the meeting was adjourned in view of the stay granted by this court. He contends that since the meeting is scheduled tomorrow at 12:30, the meeting could still go on if the order of stay is vacated. Hence, list tomorrow at the top of the list at 10:30.
Government may be directed, may not to communicate. It's only WhatsApp communication.
One
not at personally
submission,
delivered
one sub.
to the Panchayat.
10:30 ನಾಳೆ ಇನ್ನೊಂದು ಪಂಚಾಯತ್ ಇದು ನನ್ನ ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಲಿಸ್ಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ. Let it be at 11. Let it be at 11. ನಾನು ಅದನ್ನ ಮುಗಿಸಿ ಇಲ್ಲಿ ಬರ್ತೀನಿ.
You want to come, you can come by 11:30. Otherwise,
Division bench.
I will pass the order right now.
ಸ್ವಾಮಿ ನನಗೆ 10 ನಿಮಿಷ.
10:10ವರೆಗೆ ಬನ್ನಿ ನೀವು.
ನಾನು ಅಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ 10 ನಿಮಿಷ.
ಅಲ್ಲಿ ಟೈಮ್ ತಗೊಳ್ಳಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಈಗ ಆಲ್ರೆಡಿ ಫಿಕ್ಸ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ದಯಮಾಡಿ ನನಗೆ ಪ್ಲೀಸ್ ಗಿವ್ ಮೀ, ಪ್ಲೀಸ್ ಅಕಾಮಡೇಟ್ ಮೀ.
10:30.
My lord, on submission.
ಹೇಳಿ ಅವ್ರೆ.
ಅಲ್ಲ ನಾಳೆ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್ 66 ಸೀರಿಯಲ್ ನಂಬರ್ 66 2 ಸಲ ಆಯ್ತು ಸರ್, ರೀಚ್ ಆಗಿಲ್ಲ ಸ್ವಲ್ಪ ಮೇಲೆ
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಮೇಡಮ್, ಆಟೋಮೆಟಿಕ್ ಎಕ್ಸ್ಟೆನ್ಷನ್. ಈಗ ನಾ ಸೀರಿಯಲ್ ವೈಸ್ ಕರಿತೀನಿ.
66 ಕೋರ್ಟ್ ಆಫೀಸರ್. ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಹೇಳಿ, ಒಂದ್ ನಿಮಿಷ ನಿಂದ್ರಿ. ಎಲ್ಲ
ಸರಿ ಸರ್, ಸರಿ ಸರ್, ಸರಿ.
29 ಇಲ್ಲಿ ಪಾಸ್ವರ್ಡ್ ಮುಗಿದೋಗಿದೆಯಲ್ಲ. 27/1 ಕೊಟ್ಟಿದ್ದಾರೆ ಡೇಟ್. ಅದೆಲ್ಲ ಮುಗೀತು. 2 ಬಂದಿದ್ರಲ್ಲ 47 entry ಮಾಡಿ. ಲೈಕ್ ನನ್ನ ಕಡೆ ಇಲ್ರಿ ಫೈಲ್ ಅದ ಚೆನ್ನಾಗಿ ಓದಿರ್ತಾರೆ ಹೇಳ್ಬೇಕು ಅಲ್ಲಿ ಹೇಳ್ಬೇಕಂದ್ರೆ ನೀವು ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕು ಅವಾಗ ನೀವು ಅಲ್ರಿ ನೀವು ಕೇಸ್ ಕರ್ದಾಗ ಇಲ್ಲಂದ್ರೆ ಅವ ಇಲ್ಲ ತಗೊಂಡಿಲ್ಲ ಅವ್ರು ಕೇಸ್ ನಾವು ಕಾಲ್ಔಟ್ ಮಾಡಿದೀವಿ 2ವರೆಗೆ ನಾವು ಇವು ಎಲ್ಲ ಫಸ್ಟ್ ಪಾಸ್ವರ್ ಆದ್ಮೇಲೆ ಇದನ್ ಮಾಡಿದೀವಿ.
ನಾವ್ ಒಂದ್ ವಾರ ಮೊದ್ಲೇ ಹೇಳಿದ್ದೆ ಬಿಡ್ತದ ಯಾಕೆ ಬೇರೆಯವ್ರ ಮಾತು
ನಾನು ಇಲ್ಲಿ ಹೇಳ್ತೀನಿ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ತೀನಿ. ನೀವು ಇದ್ದಾಗ ಕೇಸ್ ಕಾಲ್ಔಟ್ ಮಾಡ್ದಾಗ ಇರ್ಬೇಕ್ರಿ ಯಾರು ಅಕ್ಷಿಸ್ ಬೆಳಿಗ್ಗೆ ಅಲ್ರಿ 2ವರೆಗೆ ಒಂದ್ ನಿಮಿಷ ಸರ್ ನೀವು ನಿಮ್ ಜೂನಿಯರ್ ನಾನು ಹೇಳ್ತೀನಿ ಅಂತ ಹೇಳ್ತೀನಿ. ಆಯ್ತು ಅಲ್ಲ ಸರ್ ನೀವ್ ಇಲ್ಲಂದ್ರೆ ನಾ ಏನ್ ಮಾಡ್ರಿ ನೀವು ಹೇಳ್ಬೇಕು ಸರ್ ಅಟ್ಲೀಸ್ಟ್ ಅದೇ ನಾ ಹೇಳ್ತೇನೆ ಅಂತ ಹೇಳ್ತಾ ಇದೀನಿ. ನೀವು ಅಲ್ರಿ ನೀವು ಹೋಗ್ಬೇಕಾದ್ರೆ ಹೇಳ್ಬೇಕಲ್ಲ ಹೇಳುದೇ ನೀವು ಹಂಗ ಇದ್ದು ಮತ್ತೀಗ ನಾನು ಈಗ ತಪ್ಪು ನಾ ಹೇಳ್ತೀನಿ ನಾ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ತೀನಿ ನಾ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ತೇನೆ ಅಂತ ಹೇಳಿದೀನಿ. ನಾನು ನಿಮ್ಗೆ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ದೀನಿ ನಾ ಇಲ್ಲ ಅಂದಿದ್ದೇನೆ ನಿಮ್ಗೆ ನೀವೇ ಸೀರಿಯಸ್ ಆಗ್ತಾ ಇದ್ದಾರೆ. ನಾನು 2ವರೆಗೆ ಇದ್ದೀನಿ ಅಂತ ಇದ್ದಾರೆ ಸರ್. ಈಗ ಇದೇನು ಆನ್ಲೈನ್ ಇರುತ್ತೆ 2ವರೆಗೆ ಅದು ಕಾಲ್ಔಟ್ ಮಾಡಿದ್ದೆ ಆನ್ಲೈನ್ ಇರುತ್ತೆ. ನಾವೇನು ಕಾಲ್ಔಟ್ ಮಾಡೋದೇ ಇಲ್ಲ.
Court officer? Court officer? वेट कर दिया.